Grace and peace, everybody. We are back. You saw the thumbnail. You saw the title. You know what we're about to do. We're about to jump into this new motion by DeMonte Kendrick's attorney, Doug Weinstein. And he's been talking about something that most of us have talked about before, that the court needs to institute a shot clock. And what I mean by that is you only got a little bit of time. They've had unlimited amounts of time. And so I think this is going to be a fun read today. So what we're going to do very quickly is jump in. I want to make sure that everybody can hear me. Sounds good over on that end. I appreciate it. I appreciate everybody who's already jumped into the chat and the such of that nature. Thank you so much for stopping by today. Now, court is going to be starting late today, and I believe it's going to be starting late tomorrow at 12 o'clock, both days respectfully. So that's why this starts a little bit late so that we can get close to it, maybe stop this stream and then jump right into the next stream, so on and so forth. So I thank y'all, everybody, for hanging out with us. So Jason, what in the world is Mr. Doug Weinstein doing today? I'm glad you asked. First of all, add this to the stream. All right. So the first sentence is so epic. Shout out to Doug Weinstein. I think this first sentence is amazing. So it's again, state of Georgia versus DeMonte Kendrick. Let's read this motion here. I just love it. I love it. Motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentations of cumulative evidence. My goodness in the morning. Shout out to Doug. I cannot argue that we've been saying this. I agree 100%. Let's go, because this is not actually really long. The defendant, DeMonte Kendrick, by and through his undesignated counsel, without waiving any other rights to which he is entitled, files this motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence, stating the following. That sentence right there, hey, that's a run-on sentence that I can approve of. I can't argue. He's saying, like, look, judge, we got to move this thing along because there's no incentive for the state to be efficient. There's no incentive for the state to move it along. Come on, let's go. There's no incentive. So we're going to ask that you set a shot clock. I think that would be cool if they had a shot clock in the back of the court saying, okay, you got to get to the point. Quick. That would be hilarious. That might be a little bit too much, but I digress. Let's go. As this court has broad discretion to exercise reasonable control over the presentation of witness and evidence, the court should use that discretion to prevent this trial from stretching indefinitely and beyond the reaches of time due to the state's unpreparedness and inefficiency and presentation of cumulative evidence causing undue delay, poor decision-making by the jury, as well as harm to Kendrick and other defendants. I think this is interesting. Poor decision-making by the jury. I wonder what that meant. I would like to dig a little bit more into that. I mean, everybody catching strays today. Everybody catching strays from Doug Weinstein. YSL Weinstein. Is everybody going to catch a stray today? Simply put, the court should put a reasonable time limit, or shot clock, as I would like to say, on the remainder of the state's case. Somebody pointed out, like, the state has been going at us for almost 6 months. And I don't think they're any closer to proving that Young Thug did something as they are proving that he has dreadlocks. I mean, there's none at all. Let's keep going. The state has put and continues to put this court, these defendants, and the 16 jurors through an arduous, tedious journey. The court should put an end to our forced march, even as the state will likely contend that we should blindly trudge on in trust that the next months will be different, that the state will develop the speed and efficiency of our finest Olympic athletes. This dude is petty. Oh my gosh. Not throwing shade at the Olympics, not calling out the Olympics. Y'all, come on, Doug. You are a beast. Come on, Doug. Come on. Even the Olympians getting pulled into this thing. And that the finish line of their snail-like marathon is in sight. Y'all, at this point in time, this honorable court has borne witness to the state's unpreparedness and lackadaisical attitude toward any type of diligent approach to moving in a deliberate fashion toward a conclusion. I almost wish I was a school teacher still, because I would have my students read this. Like this right here, if I were a high school writing teacher, I would probably have my students read this and just diagram, talk about what kind of emotions this is. This is really good. This is really good. Let's continue though. Let's get done. But why should the state have any need to move with deliberate speed? The state returns home to their friends, family, and loved ones at the conclusion of each day. The state lives their lives, goes to work, and gets their paychecks no matter how long the trial proceeds. Meanwhile, for Kendrick and the other defendants, every day is Groundhog Day. This is masterful. This is making me hyped to watch trial today, because I can't wait to see how Judge Whitaker tries to get past this. Doug, shout out to you, Doug. This is excellent writing. But instead of waking up to Sonny and Cher, he wakes up to a cacophony of Rice Street and the ritual of heading to court. The U.S. Supreme Court has explained the critical role of trial judge in a trial case, in a criminal case. Our cases have consistently recognized the important role of the trial judge plays in the federal system of criminal justice. The judge is not a mere moderator, but the governor of the trial for the purpose of assuring its proper conduct and of determining questions of law. A criminal trial does not unfold like a play with actors following a script. There is no scenario and can be none. The trial judge must meet the situations as they arise and do this must have broad power to cope with the complexities and the contingencies inherent in the adversary process. To this end, he may determine generally in the order of which the parties will adduce proof. His determination will be reviewed only for abuse of discretion. The judge, I notice he has this in bold, the judge may refuse to allow cumulative, repetitive, and irrelevant testimony. If truth and fairness are not sanctified, why do I make this so small? Sorry about that. Are not sacrificed, the judge must assert substantial control over the proceedings. Wow. I'm sorry, Doug, you cooking today. I don't know what Doug cooking, shrimp and grits, etouffee, bacon and eggs. Bro, he is cooking today. The state, after originally proposing a witness list of over 700 witnesses, has a list of over 100. It still intends to present in trial. What specific evidence the state intends to use with each respective witness remains unclear. A very generalized description of subject matter to which each witness will testify has been provided. No end of the state's case in chief is in sight. This is simply untenable for the remaining 16 jurors or the defendants who remain jailed and without bond, and the presentation of another 100 witnesses by the state would cause undue delay, would be a waste of time, and would amount to needless presentation of cumulative evidence. As put so succinctly by the Third Circuit Court of Appeals, courts need not allow parties excessive time so as to turn a trial into a circus. After all, the court's resources are infinite and the court must dispose of much litigation. I'm sorry, the court's resources are finite and the court must dispose of much litigation. In short, the litigants in a particular case do not own the court. And we got that right there. Likewise, the prosecution here does not own the honorable court. The honorable court has broad discretion on the presentation of evidence and such, limit the introduction of duplicative or unnecessary witnesses by the state. As noted by the Georgia Supreme Court, we got the title right there, to provide the trial with broad discretion to exercise reasonable control over the presentation of witnesses and evidence to avoid needless consumption of time. All right. The Fifth Circuit, the predecessor of our 11th Circuit, has also recognized the ability of a trial court to limit the number of fact witnesses at a criminal trial, where those witnesses' testimony would be cumulative, upholding the limitation of the number of fact witnesses allowed to be presented to testify to the efficiency of a party's treatment methods. Furthermore, this court can limit the evidence under Rule 403 of our state's rules of evidence. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or considerations of undue delay, waste of time, or needless presentation of cumulative evidence. And we got that code right there. Thus, there is also a basis under either Rule 611 or Rule 403 for the court to exercise reasonable control and discretion in placing a time limit on the state's case to prevent undue delay, waste of time, or the needless presentation of cumulative facts or cumulative evidence. It has never been supposed that the party has an absolute right to force upon an unwilling tribunal in unending and superfluous mass of testimony limited only by its own judgment and whim. I totally agree. I totally agree. I'm just amazed that this has been said. I'm like, wait, this hasn't been said already? Like, nobody has called this out already? Wild. And in exercising its reasonable control over the presentation of witnesses and testimony, Kendrick also urges the court to consider the ramifications of the present pace of trial and its impact on the jury in this case, as well as the defendants. While there is no doubt that the new court is moving this case along with the fastest pace possible, given the court's meritorious recognition of the limited recognized right of the state to present its facts in a manner it deems best, the prospect of another 100 plus witnesses leads to several undeniable conclusions. This trial will last well into 2025 if the state is permitted unlimited time to present its case. Courts outside of Georgia, 11th Circuit, have recognized the impact of a jury of a lengthy trial merit consideration. For example, the 7th Circuit says this: exceedingly lengthy trials lead to a reduced concentration and recollection of the event on the part of all participants, particularly witness and jurors. In very long cases, exhaustion may diminish everyone's performance. The quality and the representative nature of the jury may be reduced by the fact that many citizens, often the most competent, are unable to and unwilling to take the time to sit for cases lasting weeks or months. Doug is cooking. Shout out to Doug Weinstein. Just put Doug in the chat. Just going to put Doug in the chat because Doug is crushing it. I mean, this is very, very clear. I actually am kind of surprised that this had not been said, but maybe because they now see just how bad it is. and how poor their planning is. Maybe that's it. Let's go. Jurors become overwhelmed by the volume of evidence and the number by its repetitiveness. Their attention flags, their minds wander. The witnesses, there were more than 100 in the trial of the two defendants, get mixed up in the jurors' minds and forgotten. The profusion of evidence, or rather examples, makes the documentary record unintelligible. The impressions created by the closing arguments are likely to wipe out everything that went before. Jury comprehension has been found to diminish after a mere 20 days of trial. That is a very good point. I never thought about that. Like, this is kind of like with students. Like, you would not teach students hour upon hour upon hour. They need breaks. They need time to break it up. They need topics to break it up, so on and so forth. We teach a little bit of math, even though we really got to get this in. We just let them marinate on that. Go to centers. When they get done with centers, they come to reading language arts. Even though I really want to crush this math, we're going to come back to it tomorrow because their brains are not able to comprehend it. I didn't realize, I wonder if there's studies that say how much jurors are able to comprehend based upon how long a trial is. Because 20 days seems pretty, I'd say that seems reasonable. That seems very reasonable that they would say 20 days. Finally, and not meaning to belabor the point, the court of Warner wisely notes, so now imagine jurors' mental state after 6 months, bearing in mind that memory loss and the psychological and cognitive problems of jurors in a super long trial compound the first problem. The difficulty of recruiting incompetent jurors for protracted trials. A less intelligent trial is heard by a less capable jury. The longer the trial, moreover, the likelier jury misconduct becomes. The jurors become bored, impatient, irritated. The judge's instructions against discussing the case before the jury retires is to deliberate becomes increasingly irksome and likely to be disobeyed. Man, this should have been given before they went on that. This should have been given to Glanville. I ain't gonna even lie. While the state puts on its case, witness by witness, Kendrick and other defendants sit in jail, their lives on hold, the clock ticking on their lives, second by second, minute by minute, hour by hour, day by day, month by month. Man, come on, bruh. You just hurting them. Just stop, Doug. You just hurting them. You just hurting them. Meanwhile, the risk of a confused jury, unable to comprehend a years-long trial, only grows. Wherefore, Mr. Kendrick respectfully requests that the Honorable Court to replace a reasonable time limit on the amount of time that the state has remaining to put forth its case in chief. This the 17th day of August. All right. That's crazy. The fact that this had to be said has got to be a crime and a shame. But shout out to, I'm sorry, man, this is great. I really wish I was a teacher still. Oh, wait, there's more here. Hold on. What is this? Oh, what is this? Oh, it's just the served papers. Sorry. It's just saying that people were served this papers. Okay. Certificate of service. Okay. Sorry about that. Yeah, it's super. If you were interested in reading it and whatnot, the moderators have already dropped it in the chat, and I'll make sure I put this in the description as well for the video. Shout out to Doug Weinstein. This was excellent, man. Excellently written. I really wish I was still a teacher. I ain't gonna even lie. There's very few times my friends know. If I say I really wish I was a teacher, trust me, that might be a sign that I'm being kidnapped. But I wouldn't mind reading this with my students and get like, what are your feelings about this? Because I could really see some kids really gleaning the emotion of this story. I mean, you're sitting in jail day upon day, but the the prosecution and the judge and the juries, they get to go home, but you got to sit in jail. I don't know, man. That dug into the feelings a little bit. That got your boy, they hit the feels. That hit the feels pretty well, man. This was well done. Shout out to you, Doug Weinstein. Absolutely, because I felt that. But what do y'all think? Let's see what we got in the chat. Thank you so much, everybody who stopped through. Looks like about 700 of y'all are here. Grace and peace to you all. Thank you so much for stopping by on today. What does Erica say? I'm just jumping in. I apologize if I missed anybody. I'm glad they put a motion for something, because when is this trial going to end? Why do we need it at all? I agree. Now, I am kind of surprised that Doug didn't put like a link to like a shot clock, because that would be comical. A big shot clock back there and say, look, you got time. Time's a ticking. You got 19 days. And it's just clicking down. Whatever you get done in 19 days, that's it. It's over. And I think this is going to put some pressure on Judge Whitaker. Erica, thank you so much for the comment. This is going to put some pressure on Judge Whitaker, because if she says no, she's going to look really weird, because y'all hear it. She's irritated as all get out. She's irritated by this case. She's irritated by the ineffectiveness of the state. So she's being negatively impacted. Judge is actually giving her an opportunity to do something, even though I think she should have just did it without needing to be cajoled, but that's beside the point. So if Judge Whitaker doesn't do that, what if she gives them a bond? What if she says, hey, they're still going to have unlimited time, but now they have bond? That would be crazy. That would be crazy. I don't think she's going to do it, but, or she just says, yes, like y'all have exactly 20 days. And hopefully she will set it. That's my prayer. Please, if she agrees with Doug, which, I mean, given what we've seen so far, I'm not holding my breath really, but if she agrees with Doug, prayerfully she'll set the limit and not say, okay, state, how much time do you need? Because I think that will be just complete and utter, putting the wolf or putting the fox over the hen house. But hopefully she'll determine and say, yes, I agree with you, Doug. They have 20 days. Or I agree with you, Doug. You have 15 days, state, to get it going and get it done, because we got to go. I think that would be great. Let's see what Sarah says. Sarah says, PD says, I said this last week in the chat. The jury will be overwhelmed. They are swamped. If you just scan through some of the witnesses that have been here in this trial, I've forgotten about them, and I can scan through them. I can go back. The jury is going to be overwhelmed. Doug said last night that the jurors are paying attention and even taking notes during the unending video jail recordings. I wonder if that's good for the defense. Okay. I'm not buying that they're paying attention. I'm not disagreeing with Doug, because there's no way that you know what they're doing. But if you're trapped there and all you can do is look up at the screen, you can't close your eyes, you can't pull out your phone, you can't take a nap. So if you're trapped there and all you can do, I mean, I would look like I'm paying attention too. That's about as good as I can give you. I mean, and then writing notes, I'm sorry. I don't believe that they write notes. I mean, they could be drawing pictures. They could be writing out a grocery list. They could be doodling. They could be just a whole bunch of stuff. Just because the pen is moving on paper, again, I'm a former second grade teacher. Just because the pencil's moving on the paper does not mean somebody's taking notes or paying attention. Trust me. If you ever taught a class of 7 or 8 year olds, you know that's not guaranteed. But I'm not arguing with them at all, though. Yeah. That's wild. I was thinking of this. What does she say? She says, after this trial, I think the jury will need a psych eval for all the information they are forced to not remember. The confusion in the courtroom, Miss Love talking in circles, the fighting, shaking my head. No argument there. I agree 100%. Boris, I never heard your story as to why you no longer teach. I'm old. I'm tired. Maybe I'll do a story about it. We'll do story time with Whitaker. I'm just tired of it. I mean, education is not what, if you have little people, education is a very interesting field. And I'll talk about it. Well, remind me, Bora Bora, and I'll do a story time with that. If I were a student, I'd love to be an intern. Absolutely. I mean, teaching can be fun, but it's a very interesting field, to say the least. Good morning there to you, Greg, and I appreciate everybody who stopped through. It is poetic justice that they are being forced, and I pray that Judge Whitaker responds favorably to this, because she's been shooting them down like duck hunt, right? I really hope that she at least gives the defense this W, because she's been giving out L's like we at Lululemon. But I hope she does, because this one is the right thing to do. I thought giving bond was the right thing to do. I thought a mistrial was the right thing to do. At least do this, Judge Whitaker. This is the correct thing to do, is to give these men a speedy trial. Maybe you don't need to set up an NBA style shot clock behind the bench, which would be crazy. But I do think a real bona fide time limit. You have 20 days. You have 4 weeks to get done. At least then people know that we're moving forward. That would be great. Yeah, I'm with you right here. Doug is bringing that heat. He's a literal beast. I'm going to call him a lyrical beast. He is a lyrical beast. This is well written, super encouraging. I'm sorry. I'm all about it. It's been my opinion that the prosecution has been dragging this to hoping for a plea deal. No argument for me, facts. I do think that's it. Because eventually you're going to run out of money. And when you're not able to pay anymore, and your attorney who's been fighting for you is like, hey, yo, we got to get this thing to the end. Like, let's just cop a plea. Like, I think that's what they're hoping for. Yo, thank you so much for the super chat. Thank you so much. Doug done did the two-step on this case. I'm trying to tell you, he is dubstepping on for sure. Oh, and by the way, thank you, Will Crump, as well, for the super chat as well. Both of you, thank you very much. Why won't the judge punish the state for repeating and blatant misconduct in the Brady implications? I'm just gonna walk away. I don't know. I don't know, because she should be coming out. She should be extremely perturbed by that. That right there should. That and the unpreparedness. I think there's some ethical violations, and just the fact that you're not prepared. Because y'all know, like me, we all chiming in today at 12 o'clock to see and hear Adrian Love give excuses for why she's not prepared. Whether it be her dog ate her homework, or we had some big storms here in Georgia. So this weekend, there was some really big thunderstorms pop up. She's going to blame thunderstorms. Gerbil infestation. She's gonna come up with some reason why she didn't do it. And maybe Mondo board will come up, but we all know she's not gonna have it done. And we also know, unless the Lord God has done something different, Judge Whitaker is gonna let it slide. And I think Judge Whitaker needs to, and I think Doug has done a really clear job here of explaining that it's your job, Judge. It's this honorable court's job to move this along. You're not held hostage because I say I'm going to have 1,000 witnesses. No, you say, no, you're going to cut that down to 10% and let's go. The best 10% and let's move it. Yeah, I mean, hopefully it will, but let's just tell the truth. That's part of why we want to chime in today. We're tapping in today to see and hear what Adrian Love is going to be her excuse today. Adorable says, love to Doug because I've been thinking the same darn thing. Everybody's been thinking it. Doug has just literally heard the cries and pleas of the best live chat on the planet. And he is just eloquently, I might say, put it into words. And I'm just going to read this sentence again. Shout out to you, adorable, deplorable, because I love this right here. Motion. I can see a student writing this, like, Mr. Whitaker, you're going too long. We need a motion to limit the state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence. Man, I need to put the little shots fired sound effect back in here. Doug, that hurt their feelings, Doug. Doug, you hurt their souls, my guy. Goodness gracious. Everybody was catching strays there for that one. Okay, I hate to say it. She will not agree. If she doesn't, then it will be her fault. A lot of this is Judge Whitaker's fault. Let's just tell the truth. She allowed a lot of these shenanigans and chicanery. If she turns down this motion, it's on her. But then also, I mean, now she's basically tacitly telling the state, y'all can take your time. Yeah, I don't know. Look, I'm sorry. There's no way you're going to convince me that that jury is truly engaged. I'm not saying that they're not looking at what's going on. I'm not saying that their pen is not on paper moving. I'm not saying that. Unless you can confirm to me that they're taking notes at 1 minute and 18 seconds, he said this. At 2 minutes and 45 seconds, he said this. And this is what I'm thinking about that. If you can't show me that, I'm sorry. I cannot. I'm not giving you that they're paying attention. I'm not giving it to you. What more than likely is happening, people writing their grocery list. They're writing new rap lyrics. They are playing tic-tac-toe. I'm sorry. They're not paying attention. I got to see it. Can't wait to hear Judge Whitaker's reply. I think she will agree, but will allow the state to continue to disregard deadlines. Hope I'm wrong. I can't disagree because that's what we've been watching. So because we've been watching it, Pink been paying attention. See, Pink is a student that was paying attention in class. And she knows you got a propensity to go off the rails. I used to have a teacher on my grade level that you could say something. There's certain terms that you were guaranteed to get them off on a tangent. And the students kind of knew, oh yeah, if we say this to Miss Bumblebee, she gonna go off on a tangent for 20 minutes about this topic. And the students kind of knew it. And they would kind of mention every now and then, they would kind of say something about this topic. And Miss Bumblebee was off to the races. They knew 20 minutes. Pew! We want to waste 20 minutes before we go to lunch. Mention this. And now we got 20 minutes extra for lunch. We want to waste 20 minutes of science time. Mention this. That's crazy, right? So Pink right here is paying attention. She knows, like, Judge Whitaker has a propensity of not following along and holding holding the state's feet to the fire. Shout out to you. Thank you so much. They might be taking notes, but how long are the notes? What are they taking notes on? I could literally be sitting there writing, can I remember what the sermon was about yesterday? And I would try to write down as much as I could from my pastor's sermon yesterday. And then when I get home, listen to it and see if I caught everything. I'm sorry. Just because your pen is moving does not mean that, just because you're looking at me does not mean that you're paying attention. Taking notes and doodling? Come on, man. I'm drawing pictures. Well, good to have you retired. Thank you so much. I mean, come on. Again, I'm not trying to be disagreeable, but I'm like, there's no reason for me to believe that they're paying attention because we ain't paying attention sometimes, right? I think they have seen the entire circus. I think they recap all of this in their spare time. No argument at all. What's up, Amethyst Angel? They're not taking notes. They're writing their memoir. Why didn't I think about that? Because people keep saying that the jury is going to write books. And this is it. They're probably writing this down. Day 114 of being held hostage. I mean, I'm with you. There is zero argument from me at all. I agree. I wouldn't be surprised. If there was a juror taking a little nap, let me tell you, I wouldn't be surprised. It is insidious to believe that the jury is locked in. I'm sorry, there's no reason to believe that. I'm not trying to be disagreeable. I just cannot believe that the jury is locked in, focused, laser focused. No, I'm not willing to give you that. I don't think about this one, Will. Will says, I'm wondering if the YSL defense team is going to have to move to get this judge recused. She won't come down to the prosecution and come down on the prosecution and sanction them for misconduct. I don't know if that's a recusable offense, but please understand, if there's a legal expert that can explain it, I will definitely hear it. I don't know if that's recusable. It's kind of like saying, if I go to your house, we're kids, and I come to your house to play, you might run, the way you run your house is going to be different than the way my mom ran our house. So therefore, it is very possible that you do things at your house, your parents do things at your house that my parents don't do. That doesn't mean that we got to get your parents replaced. It just means the way you run it is differently. Now, if you're putting somebody in harm's way, if you're doing something that's criminal, of course. But we're just saying, hey, y'all get to eat, 2 scoops of ice cream after dinner, or y'all can watch TV while, like, we couldn't watch TV and eat dinner when I was a child. So y'all get to watch TV and eat dinner. That's just different. It's not something. So I think each court gets to kind of run their own ship, I think. But that's a good question, though. LaToya said they write love letters. Dear family, I love you. If I pass away, you can have my goldfish and little Sally can have the gerbil. I love you. They checked out at the point they were being held against their will. Yo, that thing is crazy. I agree with you. I don't know how to, and Tanya, there's not really, I don't know how people are determining these things about the jury. The jury is in a box that you can't, it's hard to see through. You really got to be, I don't know how people are doing this. So people are saying things about the juror. I don't know how they're doing it. My name is Jason. I'm trying not to get kicked out of court, right? So I'm not over there like staring through the window, looking through anything of that nature. I don't know how people are saying these things like they're taking notes and they know what they're doing. I don't know how you know what they're doing. So that being the case, that I don't know how they're saying that anybody's taking notes. Truth be told, I don't know how you're seeing it, but I'm just staying out of it. If somebody says that, then that's what it is. Thank you again, Will, for the very kind super chat. Thank you very much for that. If you have values, teaching can be a real battle dealing with the administration. Most of the problems with, and I'll say this, and please remind me, I will gladly do a video about teaching. Most of the problems that you have in education are very, very rarely around children. Most of the problems in education are adults. Now, that could be the adults that are teaching. That could be the adults that are administrating, the adults at central office, or the adults that are raising these children. Most of the time, teachers are trained to deal with children. They're not trained to deal with the adults that really the problems. Because a lot of the time, it's not really children. Children, a lot of the time, again, being very general, kids most of the time want to learn something. If you can just present them something new in a fun way, kids don't have a problem with it. Okay, fine. You're going to teach me how to tie my shoe. Oh, you teach me multiplication. Oh, you're teaching me whatever. A lot of the time, it's the adults, the grown folk, the people that pay taxes, the people that punch a clock. It's them. They cause problems in schools. Now, it might be you, the adult. It might be your coworkers, your administration, central office, the adults that drop the kids off. But a lot of the time, it's not the kids. It's the adults. Okay, that's it. Remind me, I'll do a story time about it. Yo, if the jurors' chairs were like those massage chairs, like movies now have those very reclined, man, it would be nap time for sure. Oh, it would be nap time. The jurors need to have them benches that are in the gallery. Those benches are so uncomfortable. That's what the jurors, because it'll keep you awake. It'll keep you awake for sure. I agree. Lawyers are some pretty prolific writers. I like them. Now, I think sometimes they write too much, but this right here from Doug, hats off to Doug. This is definitely good. Hands down. They're writing their memoirs. They're getting it. Hey, I'm writing an outline. Chapter 1. I'm already on chapter 7. I got my outline going. Now the only problem is this. The only problem with the memoir idea. I just thought about it. The notes they have to give their notes, turn their notes in every day. I just thought about that. They can't take their notes home. So if they're writing their memoirs, they're giving their memoirs to the deputy when they leave out. And they can't have a phone, so they can't take pictures of it. So, man, that's the only thing. We got to find a way to get that. Ooh, I like this. I think they should give 60 hours to figure it out. No more. I like that. Instead of 20 days, you got 60 hours. So what's that? That's a little bit better than a week of roughly. The Lululemon, let me tell you, Rebecca, don't tell nobody. I'm a Lululemon fanatic. Matter of fact, this shirt is a Lululemon shirt. It has a lot of L's in it. So I'm trust me. Now the logo does not have L's in it. No. Matter of fact, you can probably see the logo if I turn around. The logo does not have L's in it, but I was making fun of their name. All right, but here, I think that would be fun. Like set an hour limit. Then you could have a true shot clock, like 60 hours on the clock and it's just ticking down. That would be crazy. That'll turn into like, I mean, that'll move it along though, for sure. What's El Chapo say? I'm sorry, LK Chapo. Doug might be YSL's ghostwriter with that pen work. I like it. I like it. I like it. I like it. That's what's up right there. All right, what we got? Oh, another. Thank you again, Will. State will do what is allowed to get by with. See, that's it. That is it. Yeah, like I'm gonna go back and say this again. What we're watching right now in Judge Whitaker's courtroom would be absolute, unequivocal pandemonium if it were an elementary classroom. If a teacher says XYZ ABC but doesn't hold children accountable for it, and children are allowed to not be prepared and not have the homework and blame little Johnny across the way or little Sally in the other chair, it's their fault, they would have pandemonium. I'm sorry, in any grade level, from pre-K all the way up to fifth grade, if you did this in a grade school, in an elementary school, it would be pandemonium. I mean, it would be insane. That's why I said I think it would probably behoove Fulton County to do a career swap with a classroom so they can kind of see. Because I think Judge Whitaker would really benefit from seeing what it's like to manage, because all of these shenanigans, all these motions, all of these briefs, when you go to an elementary classroom, those are little tiny humans. So this motion right here that Doug just filed, that would be a little human. What are you going to do with it? Or the unpreparedness of Adrian Love, that's a little person. What are you going to do with it? The way she's dealing with it is not tenable in a classroom. And I think it is transferable to be able to manage all of these motions, all of these little wrangling. I used to say, I'm a cat herder. I'm a professional cat herder. And I'm just trying to get all the little cats going in the same direction and praying I can do it again tomorrow. And it's funny because I have allergies and I'm definitely allergic to cats. So people knew, like, Jason trying to get these cats getting away from them as quick as possible. I just don't think that it's a lot. To your point, thank you, Will, for the very kind super chat and the support of the channel. You can't do this in a classroom. It just wouldn't work. Judge Whitaker's hair would be flying all over the place. She'd be pulling her hair out if she was a classroom teacher. She gonna be lying at the podium. I know one thing for a fact. I don't know if she gonna be lying, but there's gonna be some finessing happening up there today for sure. There's gonna be some finessing going on. How do they punish the state? You can't, you no more. Make them, when they don't bring their homework today, then therefore they now lose opportunities to bring up more witnesses. Or, for example, if they don't do it, then this witness is done. We're finished with this witness. Imagine if Judge Whitaker said, we're done with Woody. You're done. It's over. State, go have a seat. Doug, Brian, y'all ready? Cross-examine. Let's go. I bet you they would stop now then. They get their ducks in a row. Because also remember, they're supposed to submit a witness list. Shaded Shabazz, thank you so much. Shadid, Shabazz, they're supposed to submit a witness list and say what each witness is going to do. So if they look at it and say, wait, hold on, you got 5 people from the Hertz rental car company? Y'all don't need no 5 people. You need 1 person, and that's it. That's how you punish the state, in my opinion. Yeah, most of us, if you're not prepared for work, you got a little, let's just say that you won't have so much bread in your pocket. Okay. That's pretty straightforward, but they get away with, they get to do it like wholesale. There are no consequences for them. Because trust me, as sure as my name is Jason, if the defense was as unprepared as the state is right now, they would be raising Cain. If Brian Steele was like, oh, I don't know what I'm going to say. I don't have this, that, and the other. They would be raising all kinds of Cain. But and I just want to make sure I say this again. I've said this on other streams before. They don't really have new evidence. There's not new evidence. Those videos that we're watching are from 2014, 2015. You mean to tell me that y'all couldn't have gotten that? Fulton County cannot get an editor. I own a podcast studio. I'm here at my house, but I actually have a podcast studio on the Marietta Square. We have editors. You can go to Fiverr, for crying out loud. We have editors. You can have an editor. Fulton County can't afford an editor. So that's why we're watching all of this painstaking death by 1,000 tin can videos. That's what they're saying. Okay. There's a lot of room to rein in the state. What does she say? What does Texas T say? Whitaker is going to let Love get away with it again. Come on, don't say that. I kind of believe you, but don't say it like that. It hurts. Because Weinstein was cooking here. He was cooking right here. You know what, Texas T, I got to disagree. No, I'm going to hold out hope. I'm going to lose that bet. If I lose it, I'm just going to lose it. But no, I don't think she's going to let that slide. Because it's too clear. And she's also irritated. Judge Whitaker is not cool with this. She's not. She's irritated. If you listen to her early on to how she sounded on Friday, her voice tone has changed. It's kind of like your mom when y'all playing in church and she looked back behind you. She giving them that proverbial stare like, y'all about to get it in this fellowship hall in a minute. Wait till we get out in this car. And she's giving it to him. I'm not gonna. No, T, I can't let it happen. No, I can't. What does Regina say right here? Love will have a computer glitch. Because you know that's gonna happen. You know it's gonna happen. Judge Whitaker knows what to do. She won't because the ghost of Glanville. Stop it, Regina Supreme. Stop it. Because you're probably right. You're probably more true than false. I mean, you and Texas T, y'all probably right. But I just don't want to give up. I just don't want to give up. All right. If the judge rules the state violated Brady, then the mistrial would be in order and then it would be with prejudice. I agree. I don't know why she won't do it. I'm sorry. I have no idea. I'm trying my best to explain nuclear physics and I'm a snail. I don't understand. Yes, and they do file these motions to preserve the record for appeal. I agree unequivocally. That is true. So they're there. Anything not objected to in trial is waived. Yes. So what Will is saying real quick, what Will is saying here is by Doug Weinstein writing this motion, delivering this motion, saying that, hey, we need this thing to move on, move it along. Even if Judge Whitaker says no and just lets it slide and lets the state keep slow dragging through here, it's now evidence and in the record. So whatever happens, when they go to appeal, this will be front and center in an appeal. So I agree with you 100% there. I was not able to see the courtroom popcorn machine. I'm going to tell you right now, it's not a courtroom popcorn machine. Maybe I'll bring one tomorrow. Oh my gosh. If you were eating food in there, Man, you probably would, because it's quiet and you in here eating some popcorn. Man, I don't want to be sitting near you because you're going to catch it. They are reintroducing evidence. It's things they already argued. It's unorganized and they can't even follow it. I agree. These clients are in jail. Yes. I mean, that's something I don't think. And again, I think Doug made it really clear. Like, y'all get to go home. You get to go to the crib. But these guys are in Rice Street. These guys are in jail. While you are enjoying your weekend, their weekends are in jail. Man, that's messed up. I agree with you, man. He did a great job of making that very clear. Boy, LK Chapo said the only thing the state is prepared for is for their excuses. And that is true. There is no dearth of excuse management up in this piece. This is what happens when you have nothing solid. I got to get that little meme of the little character kind of looking off to the side of the little boy, because that's it. Like, if you had something solid, trust me, if you had a solid case, you would have given that. If you had solid evidence, you'd have given it. What do we have? Yeah, this is what we have. I have no faith in the new judge. She's protecting Glanville. Again, like I tell everybody, 3 weeks ago, I would have disagreed with you tooth and nail. Catch me outside. Now I'm her. I can't disagree. I can't disagree. Wait, by the way, thank you so much for the very kind super chat. What does he say right here? Oh, I'm sorry. I got some new members. Join the cool club, kids club, by liking this video. Thank you so much, Mandy. I appreciate you. And Kristen as well. Best chat fam on the YouTube sphere. Thank you. Oh, and by the way, Amethyst Angel. If Wit raises her kids like this, oh, come on. You know it. Oh my gosh. That would be painful. If this is how your house is run, ooh, I know what you're doing there. Like this, our future is doomed. Please don't do it again, son. Repeat, repeat, repeat. Yeah, Mama Dear Woe Christian wasn't repeating herself that many times to little Dear Woe Christian. I was catching a crutch real quick. But yeah, she definitely is handling this very differently. I don't think this is in my opinion, a very good parenting strategy. I'm just going to say. No, the jury is not here at all for this week. It's all for a week. And nobody could explain exactly why. I wasn't certain why it was scheduled. I just don't know why. Like, why are they not here? I thought they were going, because I thought there was a judge conference and maybe Glanville had budgeted in. They was going to go to the judges conference, blah, blah, blah. But Whitaker's there. So maybe they're not going to the judges conference. I don't know. So some reason or another, the jury is not there. So all this week, today they're starting at noon. Tomorrow they're starting at noon. I think it's normal time the rest of the week. And they're just kind of horse trading, going through motions, hopefully paring down this witness list and getting down to some very salient points, maybe installing the shot clock behind Judge Whitaker. And they got like 50 hours. And okay, here we go. You start with, I'll give you 75 hours. You got 75 hours left. Okay. However, every time you don't have homework done or every time you get a slap on the wrist for doing something, so much time is deducted from the 75 hours. So let's just say no homework is a 5-hour penalty. So they come in tomorrow, they had 75 hours, they don't have their homework done, they were supposed to have pared down the witness list or got to the salient witnesses, they don't have it, 70 hours. Excuses, 1 hour. Just Brady violations, technical foul, game over, whatever. But I do think they should install a shot clock. A shot clock would be crazy, but let's just tell the truth. It would be very entertaining. Yeah, I don't think, again, I'm not convinced that they're writing it down I'm not convinced that they're writing notes about what's going on in court. But even more than that, to Melanie's point, writing it down doesn't mean you're going to remember why you wrote it down. I can only tell you how many times I've done that. I write something down like, what the world was I thinking? All right. That's a very interesting conversation. Thank y'all so much for jumping into the chat. I appreciate the back and forth, the family reunion, stuff like that. The defense doesn't want more delays. I don't think the defense has ever wanted delays. But I mean, there's some delay tactics that they've used. I will say that. They've done some things that have been a little slow it down a little bit. But it's not because everything was moving fast. So let's just say that. why are they giving them so much time? I don't know. I want her to make a decision today. But let's, you know what? To her credit, she might not make a decision today, but she should make a decision before the balance of the week, before the jury comes back. Because technically, literally, they're not going to do anything until the jury comes back. They're not going to really make progress until the jury comes back anyway. So therefore, I'm pretty sure she's going to at least punt it till tomorrow. She's going to say, oh, I got this and I read it. Now, if she comes in and surprises us and makes a decision, I will be thoroughly surprised. I'm not really hoping on that, though. I'm not betting on that. Why are you like this, Bora? Why are you like this? Bora said Atlanta's going to honor these jurors with a parade after this. And the bad thing is I could literally see it in my head when I read it. That is hilarious and probably true. I hope it's not. All right. I appreciate y'all so much. Now, court is going to start at, let me make sure I got that ready. Court is going to start at noon today. Now, this question has been kind of going around. Does that mean she's going to go all the way to 6 o'clock? They're going to get a lot of work done. They're going to get a lot of work done if they go from 12 to 6. That's going to be more work than they've gotten done in a long time. So I don't know how that's going to work, but we will truly see for sure. They need some hallway benches. In the hallway, there's benches in the hallway. Yeah, there's benches in the hallway. There's quite a few actually in the hallway. The problem is, I don't want to say the problem is, you can't see or hear court at all. It's very similar to like, like a movie theater, you can hear music and you can hear that stuff in the hallway. I don't know how to describe it, but you can't hear anything that's going on in court in the hallway. So you got to be in there to hear it, which is interesting because their audio and acoustics, maybe they've improved those in the courtroom, but yeah, you can, there's benches out in the hallway. Once you leave out, you can go sit on a bench and whatnot, but you cannot in court. All right, let me see. Wait, I second that, Rain. What happened? Did I miss something? I feel like I might miss something. I apologize if I missed something, Kristen. I mean, I would definitely be doing some voice notes. Maybe they have access to their phones when they go to the jury deliberation room or whatnot. It's not deliberation. If they go to the jury room or whatever, maybe they have access to their phones and they could do like some voice notes and whatnot. But yeah, I mean, being a juror in the longest trial in American history, or at least in Georgia history, that would be pretty, I mean, that would be compelling for sure. Truly everybody in that courtroom could write a book. I mean, the judges could write it. The court reporter, the clerk, witnesses, the juror. I mean, everybody's been held hostage in this thing. I think Little Woody did. I don't think it's okay. I heard a song by Little Woody called I Don't Recall. It wasn't about the trial. It was just about just life stuff, if you will. But I want to make sure I didn't commit it to memory, but definitely was a wild process for sure. Yeah, I mean, there's not many teachers that would get away with the stuff that Adrian Love is doing. If you were a teacher, I'm sorry, you would not be getting a contract. You would be put on a PDP. You would have to have a co-teacher. They can make your life miserable. The stuff that Adrian Love is getting away with would not fly. Even in the worst run elementary schools. I mean, that right there is not going to fly. Ooh, that'd be great question. If the state only had 1 week to present their case, who would their witnesses be? I like it. I don't know that, but I think that's what I'm saying. Like, if they had a shot clock, you got, what's that? 5 times 8 hours, so 40 hours. You got 40 hours on the clock. There's a big old shot clock behind Judge Whitaker, and you got to go. Because by Friday, when it hits 0-0 or whenever it hits 0-0, you're done. But this is the only thing though. Usually each witness gets direct and then cross. So how does that work? Would the defense also have to move it along too? Because I can see the defense. What if the defense takes too long? That's the only thing. We got to work this out though. We're going to come up with a new idea. Shot clocks in court. Monica said, can the people following this trial give your opinion about the guilt of the defendant for murder? The victim is lost. I am not convinced watching what I've seen so far, Monica, and I'll just answer it. And we got about 20 minutes before court starts. And because I'm going to end this stream and then we're going to start the next one. I am not, well, first of all, I do believe that somebody was unalived. I do believe that Donovan Thomas was murdered in, was that 2014? I'm not 100% certain that all of the 6 defendants were involved in that. I have my own theory what may have happened, but I don't believe that those men of Donovan Thomas's unaliving. Now, are they a gang? Were they doing gang type stuff? I believe like there's more evidence to that, but again, still, I'm not conclusively convinced that they were a gang or they're doing gang stuff. Were they doing things? Probably. Let me say it like this. They were not Vacation Bible School students. Okay. They were not out here, helping little old ladies walk across the street and rescuing kittens out of trees. No, I'm not pretending like that. Are they as bad as the state is trying to make them out to be? I don't know. And I think that's part of the problem. We don't know because the state has done such a terrible, terrible job of prosecuting this case. So I don't know. I'm not convinced that those men did that. I have a theory again about what happened to Donovan Thomas, but that's beside the point. Some of the things that they're being accused of, they probably did do that. But a lot of that stuff they're making them guilty of, or rather accusing them of and saying they're guilty of doing, is stuff that we all did. So I'm like, I don't know. I'm not seeing the connect between this is a gang because they did X, Y, Z. I'm like, we did that too when I was a kid. Like, what are you talking about? I don't get it. So a little 2 cents, but thankfully I'm not a juror. Thank God I'm not a juror. Thank you. Oh my goodness. Thank you. The argument on the side of the DA for unlimited time should be a bunch of love stutterers and stammers. Now that right there would be crazy. A hot take of that would be great. What's going on, Cat Not Williams in the building? Good to see you. Thank you so much. Fantastic content creator. If you're not already following, most of y'all probably already know who Cat is. She is excellent with these motions and reading through these. I've learned a lot from her. Shout out to Cat. If the moderators have not already, put Cat's channel in the chat. Could you please do that? Thank you so much, Cat. Thank you so much for stopping by. Behoove, my favorite word. My children knew I'm in business when I said behoove. So one of my things was that we would always pick new words to use. And literally I would dial it in on my lesson plans. I still put it on my YouTube scripts that, put a new word in there and we would just do it just to have fun with it. And the kids didn't know what it was. Like, Mr. Whitaker, what does that word mean? Well, go look it up. You could spell it, right? Behoove. How do you spell it? They would tell me what they thought it spelled. I'd go get a dictionary and tell me what it means. So yeah, those are fun things we would do for sure. Yeah, thank you so much to the moderators for shouting out Kat, making sure that her, yep, there we go. Thank you so very much. Retired, I appreciate it. A shot clock would be hilarious. Wouldn't it be, at least it would add some, a big giant shot clock right behind Judge Whitaker's head. That would be crazy, like this. And just imagine that, it's out of focus. But just imagine a big shot clock back there. That would be hilarious. With closing arguments and Karen Reed, I laughed so hard when the judge told Lally he was out of time. See, that's what I'm saying. Like, and a big buzzer goes off. Come on. That would be the best. Oh, that's right. They had 30 witnesses they had to bring in today. If you believe Adrian Love's going to have all 30 witnesses, let me tell you something. I got this land down here in Swamp Valley that I could sell you for a song. It's not going to happen. I promise you. She is not going to have all 30 lined up and ready to go. Once Woody gets off, the next one, don't even waste your time. Don't even hold your breath because you're going to pass out. As a teacher, what would you do if a student didn't have homework Monday through Thursday and then Friday morning, no homework again? Would you let that fly? Absolutely not. So as a teacher, you have opportunities like you have to do the homework during lunch. You have to do silent lunch. You got to, of course, recess. You could always take away recess or make them write or do their homework during recess. And a smart teacher would say, hey, I'm going to split this in half. You had to do 20 problems. You didn't do it. You have to do 10 problems before you go play in recess. That way the kid can still go run around, because you don't want some kid that's sitting there, has not been able to run off all that energy sitting in your class the rest of the day, because they're going to make your life crazy. So you got to come up with a compromise. But then on the same note, your mom and your dad are going to be contacted. I'm snapping a picture of it. I'm emailing it to your mom and say, little Johnny said that this was eaten by your dog. And so mom would reply back, we don't even have a dog. That kind of stuff like that. I want to make sure that you're fully aware. But we wouldn't go through Monday through Friday. That just wouldn't happen. We would have put a nip in it by at least Wednesday, because I'm going to make sure everybody knows that you're not doing that homework. But that's what Judge Whitaker needs to be doing. Great question, Will. Yeah, if you got a question, comment, concern, you don't like what I said, please make sure you email management. I appreciate it. See, Chapo right there. Bonnie can pay for other people's vacations, but she can't pay for an editor. I'm just going to walk away. I'm not going to say nothing. She gave Nate the money, but Nate needs to know how to edit then. They could have got a lot of these problems resolved with that audio. I mean, you can have an editor take out some of the high-pitched noise and some of that yelling when I think it was Gaither or one of them was yelling at Woody. It was just like noise. It didn't make any sense. There's a lot that they could have done. Just all you gotta do is hire an editor. Well, let me say it like this. And what I mean by editor, of course, everybody's aware of what is being removed. Like when that section where Woody is like taking a nap is actually 45 minutes long. And they wanted to allow that to stay in there because periodically Woody would just turn over and say something. And so they wanted people to be able to hear the something he was saying while we're watching adult nap time. Cut the naps out. You could cut that out. Nobody needed to see that man doing that. There's no context that was going to help you. But let me also add this. If that's your evidence, that's what's going to throw these men in jail, is watching a grown man lay on the tabletop like that. That's what's going to throw these men in jail. Baby, you don't have a case. You don't have a case. Right, JC. She says I'm sorry. She says she's irritated, but her actions don't show it. I want to keep hope too, but it's hard. So I think this is it. Doug Weinstein up there. Uh-oh, the case has started. Let me go ahead. You know what? We already here. Let's just do it. We're going to just stay right here. There's no reason to change. Let's just do it. I'm going to go ahead and add this to the stream just to make sure. We already here, so let's just have some fun. We just might as well. Okay, it's because they done turned the clocks on. So I'm going to go ahead and cancel that previous live stream. So give me a second. We're going to just go ahead and change this to, this is now the day 14, day 114, please forgive me. Might as well. No reason to change it. Why not? All right. All right. What's it doing? Okay, so today's live is now live. All right, so we are waiting for court to start. They've already got the big clock. They already got this, they already got the Georgia seal up. Shout out to the Georgia seal. So in my perfect world, I would change this and they would have a ginormous shot clock right behind Judge Whitaker's head. That would be the best. Oh, that would be so funny, man. A giant shot clock right there would be out of control. That would be just out of control. Uh-oh. Who's this? Shout out to I Don't Recall. Thank you so much for the $2 super chat. He said, who there called my name? Nobody called your name, and we don't recall who called your name. How about that one? Shout out. Thanks for the super chat and the support. I don't recall. I appreciate you. Okay, so let's see what we got. A juror requested time to take his or her, I think they mean child, to school and will return Friday. So Judge Witt gave the entire week. Oh, because I guess this is school season. Okay. Really? So they gave everybody off because somebody had to take their child to school. Wow. Okay, that makes sense. Okay. Oh, hands down, DJ Swift, 0707, they were definitely stalling. I think Johnny Depp and Amber Heard case, each side had time limit. Really? So I think this is, I wonder if they did. There's a lot of people who followed that case. And so I would love to hear what they say about that. No, Woody is not finished. There's still some of the interrogation video and a jail call still. At least one jail call, I know. So maybe it's more, but that's still, yeah, that's crazy. How do you write down and translate gibberish? I don't know. That's what I'm saying. I'm not given that the jury is taking notes so much as they might be just writing just to keep themselves awake, keep themselves engaged. Because I'm sure it's probably a bad look if somebody falls asleep in the jury box. I mean, I'm sure that's going to be a problem. So, oh, somebody else said this as well. Take the child to college this week was one of the reasons. Okay. Okay, cool. That helps out a lot because I had no idea. I ain't gonna even lie. I just had no idea. But there is a judge conference this week too. So I was thinking that's what was maybe the reason. So taking a kid to school, that's worthy. You have my permission to do that. Tawanda, thank you again for the super chat. Thank you so much for supporting what we do over here, Tawanda. Thank you so much. It's been a fantastic pillar of this channel, I might say. Thank you so much. I appreciate it. Oh, got you. I mean, hallway benches in the jury's box. I got you. I think I don't know this emphatically. They probably have more comfortable chairs than the people in the gallery. The lawyers' chairs are very comfy looking. I would be struggling to stay awake sometimes if I had those chairs. So that being the case, hopefully we won't see the Mondo board today. Hopefully we won't, but I would not be surprised. But that being the case, the jury chairs look comfortable. So yeah, I mean, I just hate that these people are being held hostage in there, man, because it is amazing when you think about like, yo, I can get up and walk out. I can go to the restroom. I can go and say, man, I need to go get something to eat. The jurors, not so much. What does Turtle Man say? Predictions. Will there be fireworks today? Okay, I'm gonna set my expectations. I'm gonna say no fireworks, because Adrian Love is gonna have all of her homework ready, and Judge Whitaker is gonna give serious consideration to Doug Weinstein's motion, but she's gonna roll it to like Tuesday or Wednesday. All right, so no real fireworks today. That's what I'm gonna say. But I'm telling you right now, I am praying and I'm wrong. DA won't be prepared. Not much work will be done. Maybe some defense motions with Love arguing charades. You're probably right. Let's just tell the truth. You're probably right. I mean, you could have an entire book. I know that they collect their notes. That was a big deal about the whole Woody thing, was how are they going to strike what they wrote if they wrote something down that needed to be stricken. So that was actually part of the big horse trade. So part of the reason why court started slow on Monday was because they were redacting the notes, which was crazy, but Yeah, I don't think we're going to go through transcripts today, but look, I'm telling you right now, nothing is surprising me, okay? Yes, this is not the longest trial in American history. It's the longest trial in Georgia history, and one of the biggest, definitely. So the McMartin preschool trial was 919 days. Wow, that is 3 whole years. Wow, that's wild. Now let's not forget though, there were rumors that this case was going to go that long. I mean, Atlanta News was reporting 2026 without even blinking an eye. So they've changed that since, but because Judge Whitaker's here. But under Glanville, the rumor was that this case was going to take till 2026. I don't even know what you said, but the way I started reading it just made me laugh. Bet you judge will have the nerve to tell the defense to move it along when it's their turn. Bet. I agree. I agree 100%. Yeah, don't be talking about I don't recall his name. Shout out to you, man. Thank you so much for the super chat. All right, un momento, por favor. And I'm back. Thank you so much. Nah, they weren't choir boys. I'm not going to pretend like they were. I'm not going to do that to them. Oh, thank you so very much. Be smart, smart Christian channel. I appreciate you. Let me see what he's saying here. Shout out to Corey. Can I get you to just show the bald head once? Stop being ashamed of being a bald head. Y'all, see, Corey from Smart Christian Channel, if I could have the moderators drop his link in the chat. Corey is a fantastic content creator, but Corey is one of those people that refuses to embrace the chin crown. But Corey's bald, so you know he's got to at least be high value right there, because bald guys are high value. But he refuses to embrace the chin crown. He refuses to just let the chin grow. So we got to reach out and encourage Corey to grow a beard. Grow a beard, Corey. Come on, man. All right, I got it ready, y'all. So it's not me, it's them. So we wait for them to get it together. Okay, we got good feelings about today. But again, Corey, thank you very much for the very kind and gracious super chat. Thank you very much, man, for supporting. If the moderators could please drop Corey's link in the chat, as well as my sponsored link to Evan Alexander, because Corey needs to grow a beard. So at least he can get some good skincare and beard care products from Evan Alexander. So if you drop that in the chat as well, that might help him out. Help the brother get his beard game going. Because beard lives matter, Corey, for real. I hear some people saying some positive, they feel good about today. Okay. I'm optimistic. Let me say it like that. Again, I just saw a couple words. Your expectations on love, having her assignments done are a lot higher than mine. I'm trying to be like contrary to like push. I'm trying to push the encouragement in the direction I really want. So I really don't believe she's gonna get anything done. I promise you, she's gonna say she had choir rehearsal or something. She's gonna come up with, my dog ate my homework, my computer overheated. I promise you, she's not gonna have it done. But I'm trying to like sway the argument to that point. So no, I don't believe it. As I like to joke, if I were betting, trust me, I wouldn't put 10 cents on Adrian Love having all of her work done. There is no way. Oh, I see Judge Whitaker. Let's go. Okay. Let's go.
One more minute before it's afternoon.
One in the chat if you can hear.
Anybody know where the state is?
The state is not there. One in the chat if you can hear. Okay, cool. All right. Oh. Ooh, he eating. Don't be eating in there, man. Come on now. The state just say they protesting. Oh, that's messed up, Dominique, but you're right. They said they can't get a delay of game if they don't come step on the court. No delay of game. Great question, Amethyst Angel. Thank you very much for the $5 super chat. Does anyone remember what they talked about? I mean, who they talked to, when, and what was said 10 days ago?
Invite them to come back to court.
Westmoreland in the building.
Yeah. Thank you.
She needs some after school detention. Yeah, absolutely. We over here with fashion going on. I don't know that guy's name, but he's always dressed well.
Thank you.
I have to admit. What's up, Doug? I see you over there, Doug. Mr. Kendrick. How did I do that? There go my boy right there. Matthew's in the building. He is real down to earth. I can't wait to, hopefully we'll interview him tomorrow. Him and his son. He is real cool. Very cool. Just super laid back. And he's a Morehouse graduate. Let's hear for the house. Love is going to be a pretend victim. Oh, absolutely. Lil Sis is my friend for sure. I'm team Lil Sis. No question about it. Yak Gotti. Thank you so much. I need a YSL name. I need to work on that. Because these names are hilarious. Oh yeah, his beard is on point. I'm sorry. His beard is on point. And his son's beard is on point as well. I mean, they're not there at all. Look at that. That whole table's empty, like they didn't even check in. Yo. Are they just protesting? They can't even get to court. Y'all are not playing with them. Y'all are not playing any of their shenanigans. Y'all are not playing with any of them. I'm going to read these comments all day. Y'all are the best. What in the absolute world? They went on strike against themselves, right? Can you do that? They dropping the case. They need to. Yo, this is, oh my gosh, this is crazy. Dude, do you realize how bad I wish I was there to see this? But no, you know what? I'm glad, never mind. Because y'all are much funner. Because I would have to be quiet in court. They thought they were the jury. That's it. They were like, oh, everybody's gone today. Yo, I mean, in all of the defenses there. Well, is Shard back there? I don't see Shard back there. Maybe they like, Shard ain't there either. I need a seating chart. You're right. I'm the worst. Tawanda, what is going on? Apparently the defense, I mean, the state is calling it an audible or something. There's no way. I need to bring that Marshawn Lynch in there. I'm just here so I don't get fined. Short. I mean, that's what we're looking at right here. Yo, this is crazy. What are y'all doing? That is wild. I mean, they are not here at all. They said, oh, we taking off with the jury. What did Freeze say? Y'all, this is high level stir fried foolishness. Alarm didn't go off. There you go. DWC, your YSL name should be YSL Doc Woke. I kind of like that. Mia? Okay.
Between the state not being here yet and the fact that apparently none of the defendants have been fed lunch yet, we're going to break, let them quickly be fed, wait for the state to get here, and then get started. So we'll be in recess before accomplishing a single thing.
Where are they? I'm done. I am so done. What? Gosh. Please, in the chat, please, especially if you've watched this for more than just 10 minutes, please write for me what job would allow you to be this incompetent. Please tell me what job, because I need that job. I need that job because those people make Love and Hilton and Atkins, they make good money. I'm just a small business owner. I will go apply for that job today. Today. What job can you be this incompetent at and get paid the amount of money that they get paid? I need to go get that job today. I'm on Indeed as we speak. Y'all, I'm logging in Indeed. I'm ready. Just please, I'm gonna refresh my resume. Yo, this is the whole table is empty. Like, they didn't come in and drop their stuff off and then run to the restroom. They're not like, hey, let me drop my stuff off and run and pay the parking meter. They literally have not shown up. And you know it's got to be coordinated because they don't ride together. And am I wrong? Aren't there offices in the building? I might be wrong. That might be reaching, Jason. I think their offices are in the building, though, in the courthouse. They took a time out. They just didn't even come in for time. Yo, that is, and you know, please let Judge Whitaker come down on them. Please do not give them a pass. Please do not give them a pass, Judge Whitaker. This is not acceptable. None of them were there. Nobody was there. Let me, as far as I know, I'm going to see if, none of them were there. The tables were totally empty. And there was no reason to believe that they were there. None of them. They clowning as they always do. By just reading it, it sounds insane. So no, one member of the prosecution team got the memo? Like, that's just crazy. Please, dog ate the whole alarm clock. I agree, Richard. The whole alarm clock. Bring love in shackles. They literally started and ended. That's crazy. Oh, wait. Somebody moving. No, I think that's the cameraman. Just so I can see. The cameraman walked in front of the camera. I'm gonna leave it up just see. Yeah. Whose head was that? Oh, wait, okay, that looked like Hilton. This is embarrassing.com. Like, this is some stir-fried, unacceptable foolishness. Yo. Don't try to get up in here and pretend like you was there, Simone. Don't even try. Please let them hold. Do not let this slide. Okay, not sounding happy and being mad. I'm sorry. It's gotta be, there has to be consequences. When I was a classroom teacher, I told my students, I never make threats. I only give you promises. So I would never threaten, oh, I'm going to make you never go to recess again. I'm not going to do that. Never going to do that. I'm going to promise you, you will sit at silent lunch today. You will be at silent lunch for the rest of the week. But never make threats. So if Judge Whitaker is going to do something, she should, she must, it is imperative that she does. I mean, they literally did not even show up. They went to Chicago. They would be better off if they had. They got to be sanctioned. There's got to be something. There's got to be some kind of pain. Holding their feet to the fire. Do not. If she just lets it slide, that's an embarrassment. More of an embarrassment. No threats. There's never a day like I'm right there with you, President Not Perfect. I would never have thought we would have saw a day where the legal professionals who are paid in excess of $150,000 to slow drag through a case, none of them would show up. I never thought I would see that. And if I'm not mistaken, I think they're in the building though. They did not show up, Caustic Chameleon. They were not there. Whitaker sat down. Let me roll the tape back so y'all can see. Because this thing has got to be high levels of comedy. Okay, look right here. Like literally, the table is empty. They didn't even come in and drop their stuff off. That's craziness. This is crazy. Nobody showed up. They're like, look, we got other stuff to do. Okay, I don't want to, just in case they start up again. But yeah, they literally did not even show up. It's over.
Between the state not being here yet and the fact that apparently none of the defendants have been fed lunch yet, we're going to break.
So you can see right there, it's totally empty. Look. Totally empty. I mean, they don't recall that they were supposed to come to work. That's what happened. Yo, they literally, this has got to. And the bad thing, Gibbs, is Doug just said this. Doug just said this. So this is going to be on the, again, something has to be done. That's crazy. They just said, yeah, we're just not going to show up. I just want to let y'all see that again. They just said, yeah, we're just not going to show up. Yo, like you could just literally not show up. Only government jobs. Now that I can agree with. Is a prosecution in Georgia. I would hope so, but at this stage of the game, it's just so insane. I can't even think of what, I don't know. This is a global clown show. people are watching this globally. They're watching this, and they are watching, just phone it in. Just throw it in. They said the DA's office. I want that job too. Well, as soon as I'm filling out my application on Indeed right now, on jobs.com. As soon as I get an interview, Joanne, I'm going to see if they're like hire one and get two free or something. I don't know. Because we all need this job. Oh my gosh. Weathermen are now the only job where you can get paid and be wrong every day. Well, apparently not. Well, now apparently you don't even have to come to work. This is embarrassing. And they don't even say how long lunch was going to be, which is kind of interesting. She just said we're just going to recess till lunch. So how long will it be? I don't know. Wow. We on McDonald's time they talk about. This is so crazy. Yo, I see people walk around. I'm waiting just to see. I was wondering, and I'm going to ask, but I think their offices are actually in the building. I really think their offices are in the courthouse building. And if it is, that's actually more of an indictment. I really think I think they are. If their offices are in the building and they could not show up on time, but I believe it was coordinated. I don't believe that. Again, if you drove in, I'm probably going to arrive at a different time than you. So I might come in, drop my stuff off and go give me something to drink or go wash my face, whatever. But none of them were there. I'm sorry. Please don't let Whit put up with this. I am with you 100%. Because if this was the defense, can you imagine if all the defense was MIA and it's just the defendant sitting there and none of their attorneys, none of their counsel was there? Amazing. That right there, that stole the cake. I'm sorry. Cake. Because that just stole the cake right there. I can't think of anything else they could have done. Like, what in the world? Like, that's, and when you, I mean, wow. That is, yeah, I don't even know where else to go with that one. Yeah, what's saying? Okay, here we go. Judge Whitaker is going to reach out to the best live chat on the planet. And she's going to say, what should be the sanctions for the attorneys not being there today? In the chat, tell me, just put hashtag wit. And then tell me what is the sanction. I'm writing mine. Put in the chat, what is going to be your sanction? So Judge Whitaker calls this best live chat because the jurors are in the chat. We already know that, right? We already know that. So what's going to be your sanction? So my sanction is she's going to have to write a 17-page paper on professionalism and buy the defense lunch. What do you guys say? The judge is going TI. Oh, contempt of, yes, there we go. Contempt. Oh, you're going to give a mistrial on that? Wow. Hey, it's fine. We're going to throw some options out there. We're going to say, these are some options for you. It's extremely disrespectful. I mean, the whole camp is gone. Not just one person has shown up. Somebody didn't drop their purse off. The cart probably wasn't even in there. Man, that is crazy. All right, what we got? $1 for every minute wasted. Okay, I got you. I like it. Wit, held in contempt for 20 days in prison and be served in the next 10 weekends. I see what you did there, CJ Landing. I see what you did there. You ain't playing no games. Judge Witt will give them until Friday. No, we need some real, come on, button brass. We need some real sanctions, some real things. Fulton County DA's office is at 130 Pryor Street. Hold on, let me see something. All right, hold on 1 second. Okay, y'all are wondering, like, why is Dear World Christian laughing? What's he laughing about? I'm gonna show you real quick. Somebody just gave me the address for, board just gave me the address for the Fulton County DA's office. This is the Fulton County DA's office. This is where it's located. 136 Pryor Street, floor 3, Atlanta, Georgia. You know what the problem is? This is the courthouse. So they are literally in the courthouse. And they could not get there on time. Hopefully. I hate to say I hope you're wrong, Bora Bora, because you ain't been tricking Dear Woke Christians. So I don't think you're gonna start now. That is an indictment. If they're literally in the building on the 3rd floor and they couldn't come down stairs, at least and drop their stuff off. At least put their purse down there and say, at least push the card in real quick and be like, hey, I'll be right back. I'm running to the restroom. I gotta go upstairs and get some sticky notes, whatever. If they literally didn't do that, man, what are these sanctions? They said, GM Gregory said, you fired. He ain't even playing no games. Queen Pretty ain't playing. She said, mistrial. Ooh. Oh, that's something else I want to ask y'all. Okay. Let's say that the jury gets this right now and they come back not guilty, they're acquitted. Should Young Thug and the others be compensated monetarily? Just think about it. Don't even comment yet, because I want to finish looking at some of these, how y'all throwing a book at these people. But I'm just wondering, like, should they be compensated for this? Fired. Wit. Sit the weekend in jail and learn learn how to tell time. Wow. With a sundial. Contempt. I got you. Dismissed. They threw in the towel. I guess. Why are you shunned? You're not shunned, Grandma. What happened? It'll take 17 years to write a 17-page paper. Yeah. Wit. Same section. Judge Glanville gave Brian Steele. Oh, the same sanction. Okay. Contempt. Then I agree. I can rock with that. Wit. Usually in my state, you automatically lose your case. Wow. Can you imagine? Okay, wait. Imagine them losing the case. Let's say, I like what you said, Adventures with Red Man Bone. Imagine losing it and you was just upstairs playing around the water cooler, playing Candy Crush. Yo, that would be the worst. But at this point in the game, I don't know what to say. By default, the DA's office has decided not to participate and everyone goes home. Case over. Wow. Reimburse the defendant's attorney fees for the day. Oh, for the day. I like that. I like it. I'm still just, wait. I'm really hoping and silently praying that their office is not in the same building. At least put them on another building where they had to at least walk outside in the elements. Because if they were in the same building, no, we know they're in the same building because they got the Mondo board the other day. Remember when they got the big Mondo board, they said it's upstairs. Doggone it. They literally are in the same building. That's where they got the board from. Boy, you cannot make this foolishness up. Okay, let me real quick check, make sure I ain't missed court. Okay. While I'm over here talking trash. No, but they didn't say when lunch was going to be till. That is, okay. What are the sanctions? What's Doug? Day 9 says Doug is going to be hurt feelings by Doug using bad mojo. He must be jailed. What? They're gonna throw Doug in jail? Don't throw Doug in jail. Okay. And I heard, wasn't Melnick suspended for 6 months for not showing up? There was a lot of little complexities in that story with Melnick. There was a lot of things in there. And it was also, I don't think that was fair. I don't believe it was fair now. But that's beside the point. It wasn't just that he didn't show up. There was more to it. And he had actually already been dealt with. So anyway, mistrial. And all of you are fired. Wow. Sis Wit, rein these people in. Wit, no. Tawanda, no. I refuse to believe that. No. No slap on the wrist. No, we got to get some real work done. No, I'm not taking that one. Nope, I'm not accepting that one. Maybe the state will get an award. They are so great. I hope. No. Now, this is interesting. She did say this, and you're right, Brittany Gibbs. She said, remember the judge said, we're starting even if all attorneys are home for one side are not here. So the state was like, well, none of us are showing up. I guess you are right. I need to find that clip. Somebody's going to drop the link in it or send it to me. Email me, dearwokec@gmail.com. Let them sleep. They're in hibernation. Ex parte is now allowed in. Oh, now that would be insane. Okay, since y'all didn't show up on time, all these motions from last week are all included. That would, oh my gosh, that would hurt them in the feet. Oh, that would hit differently, especially. But okay, hold on. Oh, the camera's moving. Let me make sure just in case. The only problem with that is we still got to get there. We're still about a week and a half away from there. I want some sanctions today. I want some pain today. Now, knowing that they could do that is also true, but I want some kind of ramification that can hurt them right now, today. But I like that a lot, though. I do like that one a lot. She will yell at them and start laughing and give no sanctions. Come on, Project Manager. No, we don't want that. I don't want that. I do not receive that. No, I don't. I like this one, though. Darn it, they do work in there. So oh my gosh. The amount, what is it called? Secondhand embarrassment? The amount of secondhand embarrassment that I'm feeling like you cannot be telling me you're literally upstairs and you could not come down here on time. Man. That's embarrassing. Push-ups. You got them doing push-ups? And no. Oh, you're gonna suspend them for 6 months? Wow. I definitely believe bond though. If you suspend them, you got to give the what's called bond. Or if you suspend them and you just throw out the case, or you suspend them and declare mistrial with prejudice, I'm fine. But if you suspend them and they're gonna come back in 6 months, then you gotta give them. Yo, can you imagine? Wow. I really want to hear what is their excuse that they're using. The prosecution has to do the rest of the trial without any of the usual bull. I can agree with that. Well, hopefully they won't be doing that now because of Doug Weinstein's motion and Judge Whitaker's going to lease. But this has got to, that motion is going to hit differently now. Doug's motion is going to hit differently now that they did this. Like, you literally could not come downstairs on time. Okay. I was got tagged to something, brother. Okay. Let's do this because I see we're gonna look at it. We're gonna dive into some political haze. We're gonna get into the haze of war here. And I think it's interesting because, of course, this trial has been a living, breathing dumpster fire. Okay. And in my opinion, it definitely needs to be reconsidered. Okay. Hold on one second. All right. This trial definitely needs to be reconsidered. No question about it. No ifs, ands, or buts about it. So I thought it was interesting. And most of y'all probably saw this week. Oh, wait. Whit's back. I'm glad I didn't log out. Whit is back.
Maybe the first things we need to tackle are whatever the evidence is going to be with our next few witnesses following.
One in the chat. One in the chat.
So I know that co-conspirator statements, as well as all of the other evidence that y'all, the state, intend to introduce with the next several witnesses, has been provided now in detail. So I would propose that that's where we start, unless somebody thinks something else would be more efficient. That work for everybody?
Did she not chew them out or something? Nothing?
Okay.
What?
So have y'all been able to get together on any of it to come to agreement on anything, or are we going to litigate all of it?
Your Honor,
Yeah.
just for clarity, are we discussing the evidence that was shared by Mr. Atkins on Friday night? Is that?
I mean, I think there have been a couple of different shares. There was, I also don't off the top of my head know exactly when. There was one, and then there was the supplement, and then there's also, I think, something that Ms. Hilton shared that's in a spreadsheet, which I think covers the same things that Mr. Atkins provided already.
So I think there's multiple, God bless you, there's multiple things. We sent the evidence regarding upcoming witnesses a few weeks ago, according to Mr. Atkins. What we sent on Friday, Your Honor, was the co-conspirator statements, making sure that the ones that the state intends to use were provided. And then yesterday, what I did was I provided a spreadsheet of the co-conspirator statements that are found within Mr. Garlington's wiretap, which had already been provided, and Mr. Sumlin's wiretap that had already been provided.
Okay.
So I just specified which statements from those wiretaps we intended to use.
Okay. So that's a subset of the bigger set.
Yes,
So,
Your Honor.
I mean, we can start there if y'all want to start there. Or are those going to come in later in the trial?
Those are going to come in later in the
Okay,
trial.
well
Your
then we'll
Honor.
set those aside for now.
Submitted the 31 through 60 witnesses.
Right.
Oh, I'm sorry. We submitted the 1 through 30 witnesses on August 8th, 2024.
Okay.
Judge, there was one matter with respect to the PowerPoint. I did send over the redacted one. And I spoke with, as I informed the court, I spoke with Mr. Williams about Mr. Ryan's statement and our intent to not use that.
Right.
So those two matters were off the table.
Okay, so yeah, we don't have to deal with a motion to suppress Mr. Ryan's statement because the state does not intend to use that. And I've also been informed that Mr. Kendricks is not going to be filing a motion to suppress the first hour and a half or 2 hours or whatever of his statement. So we don't have, that's also off of our to-do list.
Your Honor, on
Yes.
behalf of Mr. Ryan, and what was received on Friday, I think was our updated list of the people they actually intend on calling and co-conspirator statements, I believe. So we'll have Mr. Ryan's motions in limine, the basic ones of this is inadmissible hearsay, those types of items based on what we just received. I don't know if those are in the immediate upcoming witnesses. We're going to prepare it as fast as we can. We're just kind of, as you know, getting the rolling. This is what's actually being introduced.
And so we, in my speaking with Mr. Williams, I did let her know that if she had specific objections, there may be things that we could agree to. She did name some and I agreed with her. So we were continuing to discuss those. So if after those conversations, Mr. Bossi and Mr. Williams feel like there's still more to litigate, that'll happen. But that conversation and that dialogue has started regarding those things that have been turned over to Mr. Ryan.
I think what probably would be the most productive is things that we have issues on, we make note of and make a record. This is the defense raises this issue, state agrees, so that they've been addressed and it doesn't, something got missed from the list or something like that. Raises this issue, state agrees, so that they've been addressed and it doesn't, something got missed from the list or something like that. So let's do that.
That's fine.
We'll get that to the court as soon as possible. I don't know if they're in the next few witnesses category or not.
I mean, I don't either right offhand, but if it is, we're litigating that stuff this week.
Right. Could the state provide a little bit of guidance?
No, Your Honor, the stuff for the Jamari Holmes are not within the next 10 weeks.
Okay.
Okay.
All right. That works.
Thank you.
How about Mr. Kendrick's statement that there's the Bruton issues on, right? And when's that going to get introduced?
So not in the next 4 weeks, actually, based on who it is that we intend to come before the witness that would introduce.
Okay. What witness will that be with?
Investigator Thor.
Well, y'all got him listed as witness number 5.
We do, but he has had, he will be moved down based on some circumstances that have occurred in his.
Okay.
He has some personal matters.
Okay. So is it still going to be Burnett, Sledge, Zachary, Dean, Morton, Sprinkle, the phone custodians, Bernie, generally?
Generally, yes.
Okay. And then I guess Thorpe will be at the end of those now? Okay. And that PowerPoint, that's
with Dennis.
Well, that's with Dennis, okay. So he's several out. All right, so great. That'll give y'all some time to get together on that statement to sort Bruton issues. Mr. Steele, you also seemed to kind of be making a broad argument that nothing in his statement, in Mr. Kendrick's statement, even if it doesn't directly implicate your client standing alone, needs to be redacted, or there needs to be a limiting instruction about that. Do you have any law to back that up?
I'm trying to get proper law, but in this case, there has been over objection the announcement that YSL is a criminal street gang that Mr. Williams, according to 3 supposed experts, is a member of, in addition to Trintavia Stevens, said that Mr. Williams is a member of, in addition to Mr. Walter Murphy, had Mr. Williams allegedly as a member of. There may be others. And then in Mr. Kendrick's statement to law enforcement on October 6th, 2015, he discusses YSL, the crew, the gang. So I think that under Bruton, it's an element of the offense of criminal street gang as well as RICO, that I believe that that does not indirectly, but directly implicates Mr. Williams. But I'm looking for law on that, but that I do not want to waive that issue. In addition,
Well, yeah, just get me some law and we'll take it. Sounds like it's not quite as time sensitive as we thought it was, but we still need to get moving on it. So try to get me the law that would cover that.
in
as soon as you
addition,
can.
I'm sorry.
Go ahead.
No. I thought
Go ahead, I'm done.
you were thought the sound record was done. Yes, I do want a limiting instruction, and that comes right out of the cases that I did cite, because that statement I cannot cross-examine. Mr. Adams cannot cross-examine Mr. Kendrick. That statement should be his alone. And it's a confrontation clause, so it does not move the conspiracy forward. So it's not a recognized exception.
Okay.
So the second part of the question was, do you have law for the limiting instruction? And I already provided, but I could provide more.
Okay. And then I do want you to get with the state to try to come to an agreement as to what needs to get redacted to avoid Bruton, at least the classic Bruton issues, and we'll have to take up whether any kind of talk whatsoever about YSL gets included within that or not. But as to sort of the classic, Mr. Williams did this, which I doubt if he says something like that anyway, but something that would directly implicate your client standing alone. Y'all, the state ought to know what that would be and be able to redact that out. And it's going to be played as a video statement, right? So, right or no?
We intended to ask questions
Okay,
versus.
that's fine. That's fine.
And Your Honor,
Yeah.
I did that in my motion. I was specific, and I give the timestamp where it starts. And I did it not only for Mr. Williams, but I did it for anybody else that I saw. And I did it for Shannon Stillwell. He's mentioned a great deal
Okay.
as well. So I believe that I flagged. If I missed anything, obviously, I'd like somebody to tell me, but I believe I've already done it. If the state agrees with it, then we need to figure out, make sure that the witness or witnesses know.
Sure.
But other than that, that's been done, Your Honor.
Okay. Thank you.
And Your Honor,
Yes.
while we're on this topic, just an additional issue. Not only are there Bruton matters, but there's also just typical evidentiary rule matters, such as speculation. At one point, Mr. Kendrick is asked who he thinks may have done this, for instance, and he names some names. That's the sort of thing that would need to come out, Bruton or not, if we're asking about speculation.
Okay, well, it sounds like it's not going to be played as sort of a running statement. It's going to be more targeted questions to the, I guess, investigator that conducted the interview.
Correct.
Okay,
So that would not even be an issue, putting in or trying to redact out
okay,
kind of comments.
all right, good. All right, so let's turn to some of the specific then evidence that's going to be coming in with these next witnesses. So there's not anything controversial with regard to witness Burnett's evidence, right?
Not on behalf of Mr. Williams.
And everybody else is silent, so I'm going to take that as a no for everybody else. All right, so Mr. Sledge, there are some co-conspirator statements from him. We already did his interview, right? Okay. Did we do his jail calls, or do we still need to do that? Maybe I can look at the more detailed exhibit list that y'all provided to everybody.
Your Honor,
Yeah.
before we discuss the jail phone calls. I do have one possible issue. I'm not sure how the state plans on doing this. I see the fifth row down on Mr. Burnett, comparison photo infinity Q5 or Q50 and gas station still photograph. I don't know exactly what that means or how the state anticipates that presentation to go in court. I don't know what Mr. Burnett's qualifications would be to compare two photos. So I'm just wondering how the state anticipates that playing out in court.
Okay. So are you looking at the first 30 witness list? Is that what you're looking at?
I believe I'm looking at the same thing. It starts with 81 and then Copeland under the witness.
No, I think you've got a more detailed one than I do. I need to find the more detailed one. That was a Dropbox link, right?
Correct, Your Honor. And in regards to what Mr. Shard is addressing, Mr. Burnett, both back in, I forget the exact date, but during Deputy Sprinkle's investigation, he worked at an Infiniti dealership. He's worked for Infiniti for over 20 years. So it's lay opinion testimony. Obviously, the state has to lay the proper foundation when he's on the stand, but
Right.
his ability to recognize Infiniti vehicles is through his 20 years, and he personally has driven Infiniti cars. So obviously that has to come out, but it's not scientific expertise. It's
He's an
classic lay
expert
opinion.
because he's got all kinds of daily experience with it from the last 20 years. Or
Yes, Your Honor.
Okay. Okay. So does that answer your question, Mr. Sharp?
It does. So I guess Mr. Atkins, you are going to ask him in front of the jury to compare the two photos and testify whether they're the same type of car. Is that
Correct, Mr. Shard.
okay?
As one piece of his testimony. I mean, essentially, after the foundation is laid, he will use his lay opinion as a 20-year Infiniti rep to state his opinion of what specific vehicles are in both exhibits admitted and, demonstrative photos that are included in that Dropbox link.
I don't know. I would like the Honorable Court to look at the photographs. I don't know if we need a individual lay person to say that these are similar.
You, Mr. Atkins, are saying lay, but then you're describing something that I would think if this is beyond the ken of the average juror, it's expert, even if it's based on his 20 years as an Infiniti rep. So which is it?
So, Your Honor, he can be, his experience as an Infiniti rep, if he needs to be deemed an expert to state what the vehicle is in specific photographs, it's all through his training and experience of working with Infinitis hands-on for 20 years.
Okay, well, that would probably then be expert, but do you want to show me what it is that y'all are? I see that one of the things listed is comparison photo, Infiniti, Q50, and gas station still photograph. Is that what you want me to look at, Mr. Steele?
And Your Honor, some of these exhibits, so there's the exhibit of the drive-by shooting that resulted in Mr. Thomas's death that is at nighttime. And there's also a lit up the Texaco gas station that's like 50 feet from the crime scene location. So that Infiniti vehicle, in the state's belief, is the same vehicle seen in the kind of more lit up gas station and also the vehicle that did the drive-by shooting. And so it is not as easy for just a juror to decide, because of the quality of this 2015 surveillance video, what kind of car that is driving down in either of these.
So are you going to have Mr. Burnett look at the darker, more grainy drive-by and say, I can identify this as an Infiniti because of X, Y, and Z things?
Correct, Your Honor.
Okay. And then you're gonna have him look at the same thing in the gas station photo and say, in my opinion, this is the same Infinity because of X, Y, and Z things?
He will speak about the make and model of the
Okay.
vehicle. He won't be able to definitively say that's the exact same
Okay.
car.
Then what's the
But
purpose?
you anticipate he'll be able to say, this is the same make and model as the one shown in here, and here's how I know that, here's how I'm able to determine that?
Correct, Your Honor.
Okay. I mean, that seems legitimate. And then obviously the jury will be instructed they can believe it or not believe it, but that seems okay. Okay. All right. So then we have Mr. Sledge and his jail call. Did we already do his jail call?
We haven't. I've listened to the jail call. I would object to the jail call. It's Mr. Sledge talking to his fiance or wife about what happened in court, and
Okay.
it's definitely
Is there
not
relevance objection?
it's not relevant. It's speculation. It's definitely not furthering any conspiracy. I'm not sure why that would be admissible.
Okay.
I agree.
We would not play that jail call unless there was something that Mr. Sledge said on the stand that contradicts something that he said in the jail call.
Okay.
So, I mean,
So that's just potential impeachment. That's
Right.
not going to come in during his.
right.
Okay.
Right.
All right. Well, I mean, it's still out there as impeachment if that becomes an issue. But we won't. Yeah. It sounds like they agree. Okay. And is that it for Mr. Sledge? We already did his interview. So that's the only jail call.
Right.
Okay. All right. So then Mr. Zachary, and we've done both of his statements already. Jail calls and social media. Yes.
Is there an updated, can I ask the court to inquire whether there's an updated contact or address or both for Mr. Zachary? Somebody said that he's in North Carolina. I don't have any contact with that.
Okay. Can you provide, if his contact information has changed since y'all last provided it to the defense, can y'all provide updated?
So the last time before last that we spoke with him, someone indicated that he was, but it appears that he is still in
The same
Same
place
location.
he was. Okay. All right.
The last week, I just need you to know if it matters to the court. Hold on, can I ask this question? We were told that he's very ill. That's what I was told from the detectives.
Okay.
And I was told that he's in a hospice. That was dated June 4th, 2024. So we haven't bothered him at all. But if that has changed, and I heard what the state said, it's information on
we
witnesses.
can discuss that aspect of him at the bench or something like that. I don't want to put personal information about anybody out.
No, I agree. Is that
now she
something
don't
we
do it.
need to come up now and discuss?
We can.
Okay, let's
Why
do
is
that.
this a thing? How is this a thing? Why is this a thing? I'm sorry. The Infinity guy, that is just a lap too far. You do not need an Infinity expert to tell you that this is an Infinity car. I'm sorry. This is just, if the gentleman is in hospice, let him go to get his eternal reward without fooling with y'all fools. Please. This is embarrassing. And let's also just talk about the fact that you didn't say anything to these people. Maybe she came down on them off camera. Maybe. Yeah, like what if the guy comes in there and says, no, that's a Honda. That's a late model Chevy. I don't know. I mean, this is insane. This is so embarrassing. She likes flipping her hair. I want her to just stop this. Who was it? Who was it in hospice? Basically, is a witness for the state. He's up in North Carolina, and I guess now he's moving on in age, and for whatever reason, and now he's in hospice. This is wild. The infinity expert was no, I don't think it was the infinity guy. Yeah, this is just silliness at this point. The only thing is though, if they record it, it's just like the Woody call. Like you can't not impeach it. You can't cross-examine it. So this is just let it go. Come on. This is so embarrassing, man. I don't care what you tell me. Atkins is on Indeed. He's on Indeed right there. Y'all look real quick. He working on his resume. He like, these chicks about to get me fired. I need to get my life together. That's what he's doing. Oh, that's a good question. Who are the next 30 witnesses? Rain, that's a great question. I'm going to put my money on it. Like I said before, I doubt highly they're going to have it ready. What is Shard doing? Why is Shard looking at us? Yeah, this is a great point. And it's sad because they're probably not going to get any kind of sanction. My brother is texting me, bless his heart. They're probably not going to get any sanctions, anything. Shard is over it. Shard is like, look, I'm just standing up here checking my collar, checking my shoe shine. When you start calling, we watch YouTube. When you start calling witnesses that are hospice, what are you supposed to say about your mental health? I mean, yeah. What is that supposed to say? No homework again. Like, we're literally doing study hall.
Okay. So with regard to Mr. Zachary, on the kind of detailed witness list that starts with Copeland at 81, all you have listed for him is the 2 interviews. On this other thing that we all got several weeks back that just kind of had the order of witnesses, you also had social media and jail calls. Is that something we need to sort through? Or do you not intend to use those anymore?
We do intend to use them. We did provide the social media postings that he has.
Okay. That's in that other Dropbox, right? Okay. So let's go to that then and sort out whether there are any evidentiary issues with regard to all of the things you think you might use evidence-wise with Mr. Zachary.
And this is the Dropbox. What day?
On the 8th of August.
Yeah.
We put all of this in there.
Zachary folder. So we've got a group of social media, and then we have a couple of, well, I mean, we probably should just make sure while we're here in this folder that there's not going to be an issue about any of the rest of it either. But let's all open up the social media folder first and voice any objections to any of what is in that folder so that I can take those up.
I object to everything.
I mean, I can see that everybody can see them, right? As long as we are looking at the same thing. Which if we're all looking at the same folder, we ought to be looking at the same thing.
What are you working on?
And like presumably everybody has already looked at all of this because y'all have had it for a couple of, week, 10 days, 2 weeks, something like that. So are there any objections to any of these social media postings and screenshots?
Just as a general objection, Your Honor, it's not a huge deal with this first photo, but the way we've been doing it is any non-testifying witness, if they've made comments on social media, and I'm not talking about the poster, but just other people, we've been redacting that. Again, it's not a huge deal in this case. Someone named No One Trusted says where you at, but generally moving forward with all the social media, we're gonna ask that the state redact anything that's not said by a testifying witness.
All right. And I mean, if there is some reason why that's relevant, you can bring it up, but otherwise I think that's a reasonable way to go about it. So that's how y'all will operate.
Yes.
Okay. All right. So beyond just that clarification, are there any issues with regard to the things in this folder? There are 23 different items in the folder. Like y'all ought to be ready to go with this, because all week last week I said this is what we're going to be doing. So I can't tell whether y'all aren't saying anything because no, you don't have any objections, or because you're fiercely scrambling to look right now for the first time, which should not be the case.
Refresh my memory.
Okay. It is.
All right, so they're still horse trading, and I have no idea if they got anything done as relates to the motion by Doug Weinstein. Somebody said it was probably just for the record. Man, wow. Yeah, this is some high-level Glanville stuff right here. Cuzzo 24/7. I agree with you 100%. So State had forever to give info. Defense had a weekend to review it. That's a good question. I don't remember that emphatically. Q. Yeah, that's interesting. That would lend itself to the two car theory that's floating around here, that there were two infinities. One was a rental and one was owned. That would lend itself to that then. I'm going to actually look while they are horse trading. Yeah, I'm going to check that out. I think you might be right, Q. I
Defense
vaguely
counsel,
remember
we're
that.
not going to be able to take this amount of time before every, sub piece of evidence, because we have, as y'all know, a lot to get through.
Who opened up a pop? Who did that? Judge Whitaker. Oh, sorry. Okay, so for whatever reason, Judge Whitaker seems super perturbed with the defense, and a lot of people are commenting, like, why is she upset with them when they truly are not the case, if they're not running the show and whatnot like that? I have no idea. At this point, I have no idea, man. It is doing whatever. Hold on one second.
As a group, our stance is a lot of these are just social media posts that do not touch upon any allegations. And we're just essentially most of these cumulative, irrelevant, 403. And so I know that Your Honor maybe didn't want to do it this way, but if we could maybe just put them on the screen and litigate one by one, I think that might be easier, because there's several that are objected to.
Okay, so which ones are objected to, and we'll put those, we can all look at those.
Two,
That's 10/2015-57, that one? Is that what you mean? When you say two, you mean the second one in there, right?
the second one.
Okay.
Yes.
All right, and assuming the comments aren't there, this is for all of these, unless you tell me differently, this is a relevance and cumulative objection?
It's a relevance. It's a relevance objection on this one in particular. From what I can see, it's video. It's very dark. I presume it's Lil D. I don't know that for a fact.
Okay, that's fine.
Yelling
He
about
said somebody.
Club Crucial and cussing.
Oh, Club Crucial. Found that section of the opening statement where she talks about tinted windows in a rental car. Apparently it wasn't the Donovan Thomas though, but she does talk about tinted windows in a rental car, which seems crazy because nobody would actually do that because you wouldn't be able to get your deposit back. I mean, that's changing a car.
Judge, this video,
I just dropped the link I put in here as well.
if the objection is relevance, so if the court was able to hear what was being said, this was a public declaration by a YSL member on his social media page that it is Big Brucial. They're at Big Brucial, which is Club Crucial. The substitution of the C and crucial for the B is evidence of what our gang experts have testified to regarding what blood gang members typically tend to do. Okay. Mr. Zachary is referencing not only himself, but slime takeover at Big Brucial, YSL. They're using YSL jargon. It is evidence of the existence of the enterprise, the existence of the nature of the enterprise, the associations within the enterprise, and the gang itself.
Okay.
Your Honor, we've beaten the dead horse of B's replacing C's a long time ago in this case. The state has played numerous videos of young men like 13, 14 years old hanging out in a parking lot saying B instead of C. And I mean, at some point, this is just,
okay.
We've talked about this.
All right. So is the point of this that it is from Mr. Zachary himself and it is relevant to his credibility as to whether you tell me, so why is it not cumulative?
It's not cumulative, one, because no one, I think, in here is going to concede or stipulate that YSL is a criminal street gang. So one, the associations that, and the substitutions that Mr. Zachary, who is an associate and a member of YSL, uses that tie himself and YSL to criminal street gang activity and criminal street gang customs is relevant in itself. Mr. Zachary is an associate and a member of YSL who is testifying. The fact, unless they're going to stipulate to these things, to the fact that YSL is an enterprise and that this is the nature of the of their behavior, of their actions, then none of this is cumulative when Mr. Zachary hasn't testified and the jury hasn't heard from this witness.
Okay. All right. I think that it is probative to show, on the issue of his credibility and what he may know about the gang, because I assume that there's, there might be some argument, oh, well, this is part of his plea deal and this is something that occurred prior to any of that, that arguably shows his connection. Now, if the next 22 all do the same thing, then we'll have a cumulative issue. But this is the first thing from Mr. Zachary that's not, him sitting on the stand saying it. It shows. So
he didn't enter a plea. He's not.
Okay. All right. So I'm going to overrule those objections. What's the next
Of course you are.
item that y'all have?
Number 3, relevance.
Okay.
And yeah, relevance.
Let me. Okay. What's the relevance?
Judge, in number 3, I point out that Mr. Zachary's social media name is YSL_Lil D. He is in the picture with Shannon Stillwell. I believe that's Demekion Garlington in the back seat. Mr. Stillwell is throwing up the YSL sign. And what Mr. Zachary says in the post that is made on May 5th, 2015, all my dogs dirty, check for mains. I mean, I think it's self-explanatory, but the association, the nature of the
What?
What?
I'd ask the state to explain what they think that means, because
It's not self-explanatory to me.
okay.
I mean, all my dogs dirty might be, but check for mains.
Well, that part.
Check for
the check.
mains.
Like you check what? All my dogs dirty. I mean, check for mains.
No, don't say it again. Tell us what it means.
The all my dogs being dirty is a declaration by Mr. Zachary. And we would argue that it relates to him, his friends, his cohorts, YSL members. Mr. Stillwell seated next to him, Mr. Zachary, Mr. Garlington seated behind him. It is an assertion of who they are and how he perceives them as a group. He is associating himself with them. He's saying they dirty.
Okay. Well,
What is
so
dirty?
The check
They
for
didn't take
mains
a bath.
part remains unexplained, but
I don't know why Mr. Zachary proclaiming all my dogs dirty would have anything to do with this case.
yeah, well, I mean, it might make something more probative than it,
No,
more likely
come
than it would be
on.
without. So I'm going to overrule that.
Wow.
It may or may not mean what she asserts it to mean too, but that's for y'all to argue.
Wow.
Okay, which one's next?
Number 5, relevance. And I'll just point out that we have already through 3 and 4 and 1 and 2 established that YSL Lil D is his handle at this
Okay.
point.
Yeah, so we don't need it for that anymore, but here we've got stack of money and a firearm.
I don't,
He said 5.
I'm sorry, 4. I'm sorry.
Okay, well, I'm looking at number 5s. Let me get back to number 4. All right. State.
We don't need number 4.
All right, 4's out. Is 5 next, or what's the next one?
I don't, unless someone else on the team or on the defense speaks up, I'm okay with 5.
Okay. So what's our next one we have objection to?
Number 6, there's no objection, assuming the proper redactions are made. Number 7, no objection. Number 8, irrelevant, and also, so 401 and 403.
All right, let's look at number 8. All right, they're not going to use 8. I want y'all a little more ready to go tomorrow, okay? I feel like we're looking at them right now and making the determination, and that was supposed to be done before now.
Number 9, same objection. Well, relevance.
Response? And also, to the extent y'all can get together and agree like you did for a couple of the statements, that would save court time as well.
I can take that.
Okay, see, this is 3 already that y'all objected. They said, yep, okay, we won't use that. So if y'all get together, maybe we can do more of that.
I'm sorry,
What's
that's
next?
very condescending.
Number 10, relevance, 401 and 403.
So this, I think we may have, number one, we may have already put in a picture, but number two, it is the association with not just Mr. Stillwell. Here it is the witness in the elevator with Mr. Or in the photograph with Mr. Williams. And I believe this was Oakland standing in front of them. And this was posted January 2nd, 2015, 8 days before the Diamond Thomas murder. And the caption is, at Woody 372 at SB _live and lovely at Thugger 1 a heart and the green snake emoji for the YSL gang. So our argument is that this shows an association.
All right, I'm going to allow that over objection. And I've run the 403 analysis and overruled that. What's next?
This appears to be actually my client's post,
I don't know which number we're looking at.
11, where he's, I'm presuming, standing next to a gentleman that goes by Trouble, who I believe is deceased now and is, oh, okay, it's a different Trouble, I'm sorry. He is not deceased, but I don't know, his name has never come up in this case at all.
Okay.
So I don't know what the relevance of that would be.
Relevance?
Judge, you don't have to introduce this photograph.
Okay.
I love how she thinks she's accomplishing something.
Number 12, I'm going to acknowledge that it shows Mr. Kendricks in the photo, which if they're going to argue association, that's fine, but this association is being established through 12. So I don't object, but
Understood. If the next 5 do the same thing, it'll be different. All right, so.
and number 13 is relevance, 403 as well. All it's doing is showing Mr. Stillwell, Mr. Zachary, and Mr. Garlington in a photo together. And this has already been, association's already been established, I think, in picture number 3, maybe.
So, Your Honor, understanding that the defense feels that one picture is sufficient to establish a photo, and at some point maybe past one is cumulative, but this particular picture has a caption on it, the date of it being 2/17/2015, from top to the pen to the grave, wherever life takes us. Y'all gonna forever be my little bros at 30D at YSL little D. Y'all go and follow them, by the way. So, Your Honor, our argument would be that the caption itself is relevant and the date of the association.
I would think highly relevant. I'm going to overrule the 401 and 403
Whatever.
objections.
Whatever. Just because you put a caption. So now captions are RICO. Don't y'all put no captions down in this chat. Don't put no captions in the chat because it's going to be RICO.
Number 14 is is a post by YSL Buck. That individual, to my knowledge, has not come up in this case at all.
Yes.
So I'm.
All right.
Oh, is that Buck?
Yes, it is. Okay. All right. So are you?
I don't know what the relevance is. Buck's not charged. He's not testifying.
Why?
He was mentioned in a incident from 2013. So I'm not certain what the relevance is of showing a picture of Buck or a video of Buck holding what appears to be a firearm.
Mm-hmm.
YSL bitch, slash shit. Yeah, ho. I'm motherfucking playing, ho. You don't have a deal with big bullets, bitch. We ain't play with her. Yeah, ho. That's how the boy bills. What they doing? So that's how the boy bills. My motherfucking big bro Snake.
If you hit play, the first person you see as they're talking about YSL, big B, little bitch, is Quindarius Zachary. So that's further evidence with the gun. It's further evidence of the association and the nature of the enterprise and the nature of the association. One more.
I know they better not be any. You do realize that Love and Hilton are both in sororities. Real quick, I know
And
Hilton
also,
is. Can somebody confirm if Love is in
underneath
a
at
sorority?
the bottom, you see the hashtag YSL Real Slime with the snake emoji. This is this outward display of aggression, this outward display of, firearms. We would argue go to proof of the nature of the enterprise, the nature of the association, the nature of the gang itself, and the nature of the activities within the gang.
All right.
Your Honor.
Yes.
I mean, we've been hearing that explanation for months now. The nature is, we're talking about videos posted on the internet by someone who's not charged, that has in the video someone else who's not charged, who's cussing and pointing guns, and I think they say YSL in the video, that at this point, any probative value derived from playing this video at this point in this trial, after all the other videos that have been played, is marginal at best, and it's outweighed by confusion of the issues, prejudicial effect, and the like. I mean, it's just overkill, and all these videos, I'm not going to say all of them, but a great number of these videos have absolutely nothing to do with the issues involved in this case, and this is why this case is taking so long.
Well, I mean, I think it is probative of the assertion that YSL is a gang willing to commit criminal acts. Now, how many? So this is Zachary, Buck, and who is the other? Who is the third person? Do we know?
Not off the top of my head, Your Honor, but I wanted.
Buck is asserted to be an unindicted co-conspirator.
Yes, and to be clear, Buck has not only has his name come up multiple times, he has been in video. He is his voice was played over a jail call. He recorded one of the videos with Trontavious Stevens and Mr. Williams. So yes, these two are YSL Associates members. And also, just as to the point that Mr. Sharp made about the number of videos, the constant cross-examination and sort of rebuttal against this idea that it shows an association, and the nature of the gang is that it's promotional, it's music, it's art, it's something that's not related to criminal street gang activity. So our position on that is unless there's this stipulation regarding that, which we assert that it's relevant to prove, that every time that they argue that a particular video is promotional or it shouldn't be taken literally, they are creating a need for the state to show the jury evidence otherwise.
Okay, do we have a video similar to this
So
one?
it's your fault,
in
Shar. It's
already?
your fault.
No.
Do we want to dispute that and point me to what is?
At this point,
When you say similar, I mean, the state played.
I mean, not like a music video,
The
but
state played, I believe twice they actually played it. About 13-minute video of young men talking about YSL and slime in a parking lot outside apartments.
are they pointing guns at the camera while threatening to do things in the name of YSL?
I'm being told that guns were pointed in that video.
And is it I don't mean a music video.
It's not a music video. It's a video of.
And who are the people?
It was Walter. It was Trontavious Stevens, Lil D, Mr. Williams, Walter Murphy.
But not Buck or Zachary?
Lil D, what was that? Okay, so Zachary, I'm being told, was in it. Buck was not in it. I don't know what is important about Buck.
All
Quite
right.
honestly.
If y'all want to tell me exactly what, exhibit number that is, or give me that to look at, but my inclination is that this sounds different enough and not cumulative. So I can look at it and, I may change my mind, but at this point I'm overruling the 401 and 403 objections.
We'll get you that exhibit
Okay.
number. 15 is my client's undated Instagram post showing a picture of Mr. Zachary. I believe that's Mr. Zachary, although it doesn't quite look like him. I believe that's him. And he's standing next to a platter of pastries.
platter of pastries, man. That's gang
So I think
activity.
that's a relevant subjection.
And cumulative, because the association has been shown.
Okay, what does the state say about that?
Judge, we don't have to use this initially. We believe that it could rebut a particular line of cross-examination, but right now we won't use it in our direct of Mr. Zachary.
Okay, so there may be some cross-examination about whether they went to a bakery one day, and then this might be relevant. Otherwise,
So thuggish.
they're not going to use it.
And Your Honor,
I'm kidding. I mean, it may be relevant to something else, but who knows? I don't know.
so it's Mr. Stillwell's post
Right.
of Mr. Zachary, and his commentary about Mr. Zachary is
The
what we
pastries
were
is-
looking at. That
Come
was
on, teachers.
He's commenting my dripping. So he's commenting on his clothes.
He's dripping in blood. There's a red jacket that he has on, and that jacket, our argument is that that's what he is referring to.
No, the term
Okay,
dripping
well,
don't
at this
mean
point
that.
in time, we're not going to be using that one.
Wow.
Okay.
What's next?
16 is fine, no objection.
Okay.
Overt gang activities. Overt gang activities. This is
17
crazy.
is fine, no objection. 18,
Thank you,
401,
Regina. Thank you.
403, the association with my client has already been shown. Not sure, Your Honor, just so you know, that is Mr. Zachary and Mr. Stillwell seated behind a bottle of liquor with large amount of cash on them.
So, Judge, this is part of our indictment talks about the purpose, and hang on, I'm going to just read the language.
Hold on, sorry, let me see. Possession of blood does mean what they said for the record. Really? Okay. Okay.
Obtaining money as associates of Young Slime Life, the defendants conspired to associate together for the purpose with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity, including robbery, theft, and the unlawful sale of and distribution of drugs. This is Mr. Zachary posting large sums of money with Mr. Stillwell and asserting their unity. One thing about my brew, again, the B replacing the C, we all eating. So he's talking about,
Yeah, we're rolling in the day. We're doing well. Do we have
Stop
other
answering
things
for
that
help.
already show this that are similar?
when you say some.
No, I don't actually think there was a cumulative argument on this one. It was relevance and 403 overruled. What's next?
Eating is now RICO, y'all. Don't eat
19.
because it's RICO.
Ms. Westmoreland.
Number 19? Is that the next one?
Oh my goodness. Eating is RICO, y'all.
That's
And who all do we have depicted in this photograph?
Your Honor, we believe that this is Mr. Zachary, Mr. Nichols, and the third person we're not certain about.
All right, this is showing Zachary and Nichols in the same kind of YSL posts with guns.
Showing, yes.
Okay.
Your Honor, 403.
So,
Highly prejudicial.
Come on,
Outweighs the
there we go.
probative value.
it does not overruled. What's next?
Man, Westmoreland.
I don't have a problem with. 21, I believe that's Mr. Zachary and Mr. Garlington. Is taking her.
Your Honor, that is who is,
Okay.
that is who is.
Thank you, Ryan. Raymond,
Show
please
him
forgive
this
me. Thank you,
photograph.
man.
I don't have a problem with that.
Okay.
Just don't eat the Oreo cookie because that's RICO now. Eating is RICO, y'all. That is
Number
hilarious.
22 is Zachary and Garlington. That's, I don't have an objection.
Okay.
You have to still on the list. And number 23 is another picture of Mr. Zachary and my client, Mr. Stillwell, at some sort of arcade, sticking up their middle fingers. I would object to that.
Middle fingers, RICO.
Relevance 403.
All right.
Cumulative.
Days,
Go ahead. What's the state's response?
6 days after the murder of Donovan Thomas, this post is made. We gangster in every city we go.
All
Oh my
right,
gosh.
This
That's
is
it right
23,
there.
Right?
25th. Oh,
20. Which
yes,
one is
number
this?
23.
20. Yeah, okay. Right. Well, I just clicked out of it.
This is insane. So literally shouting out your homies is now RICO, y'all. Make this make sense. Come on.
And the main objection is 403 on this one.
And relevance. And Your Honor, while we're at it, the state said, brought up the caption. I don't know why that caption would be displayed. That's the words of Lil D.
Yeah.
Sure, he's testifying. I guess potentially that could be impeachment, but I don't know why his out of
Everything's
court
RICO.
social media declaration would automatically be admissible.
It is the assertion, the public assertion the fact that it is made publicly to display their dominance. This is 6 days again after Donovan Thomas. We believe that they went out of town into another city following the murder of Donovan Thomas, and an assertion that we are gangster in every city that we go. The fact that you made the post, that you put yourself out there with another YSL member in itself is evidence beyond the words that are spoken.
What rule of evidence would allow an out-of-court declaration by someone who's is not a statement of a defendant or a statement of a party opponent? I don't know what rule of evidence they keep saying because he's saying they're gangsters.
I assume, is he alleged to be an unindicted co-conspirator?
Yes.
I would think that would be the rule of evidence.
Well, I don't know how this would be deemed in furtherance of a conspiracy.
Straight RICO.
Because it shows, number one, it asserts their dominance. It shows, it asserts their cohesiveness. We are gangster in every city we go. It promotes their, pull up the indictment.
We the best live chat out here. So we dominate everywhere we go because we're the best live chat on the planet. So everywhere we go,
and protects their reputation, power, and territory by the posting of messages, images, videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf. It is literally a line that I just read is literally a line from the indictment. And so this post itself is proof of that assertion and allegation in our indictment.
All right, I'm going to hold my ruling on that, and we'll see what else we've got.
And Your Honor,
Yes.
for all of these that we're going through, there has to be some sort of foundation. I mean, if Mr. Zachary says, yes, I posted something like that, then that would be bolstering, right? It would just, or cumulative. If he says, yeah, I posted that, and this is the reason why, just because it's in the indictment does not make that assertion credible. So the witness has to testify to all this before it just comes in as an exhibit. Am I wrong?
Well,
I mean,
it has
that's
to
what
be
I would be
introduced
objecting.
in some form or fashion.
It has to be introduced. That part we agree, but not that it's not permissible or admissible as an item of evidence just because he says I did post it.
Right. Okay, so I'll withhold ruling on that one. What's next?
That's all the social media in
Okay.
this folder.
All right, so
Oh, yes. What's the exhibit number? And Your Honor,
yes.
the exhibit number for that other video that's already been played states 16.
This is crazy.
Oh, I'm sorry, 60 WA.
Okay. If y'all have it handy and can just shoot it to Ms. Pursfield and I don't have to go through the former court reporter to find it, that would be great. If not, I'll try it the other way. All right, so let's look and see what else is in the folder for Mr. Zachary. Well, y'all can see the same things that I can see. Is there any objection to the other 5 items? I think one of them's, the last one's one of the interviews. So is there any objection to the other 4 items?
The second to the last one,
Yeah, I couldn't open that one.
I couldn't
actually.
either.
So can y'all maybe share that one? Do y'all know the one we're talking about?
Is it one of his interviews?
I don't know. It may be. It's 3.95 gigabytes. So maybe.
Wow, that's a
It
doggone
just seems
movie.
to be in a format that.
That's a whole movie.
It's an evidence review or interview.
Okay, so it's the other interview. Okay, that's fine. All right, so then objection to the other 3 items. Anybody?
Oh, I'm sorry. I didn't realize you were asking. No objections to the
items.
Okay, and you're speaking for, I guess, no, everybody else's silence is assent here. Okay. All right, so that's Mr. Zachary.
He's still testifying. He'll be back
Should we
next
look
week.
at, is Mr. Sledge, let's look at Mr. Sledge. He's going to be either right before or right after Mr. Zachary. Okay, let's see what's in his folder. All right, we've got a jail call folder, a social media folder, a tattoos folder, and
Oh my
then
gosh.
some other items. Have we already dealt with any jail calls for him?
Your Honor, that's the one that
Texas
the
Cal,
state
thank
said they would only play for impeachment.
Okay. And that's the only thing in that, yeah, okay. So that's all right. And then how about social media? Do we need to go through his social media? I would suspect.
Yes, Your Honor.
Okay.
Thank you for the very kind super chat and funding the RICO Defense Fund, because I think we're going to all need it.
Excuse me, Your Honor.
Yes.
Could I have 5 minutes before we begin that process?
Yes. If anybody else needs to use the restroom, all right, let's take a quick convenience break.
Yo, this thing right here is crazy. I'm shocked. I'm shocked. I thought Judge Whitaker was going to play it close to the vest, but I didn't think she was just going to be like outright DWC RICO. Like, this is crazy. They're able to define RICO whatever they want to, a gang as whatever they want to. That is wild. I'm shocked. I'm shocked. I mean, somebody told me before the pre-show that Judge Whitaker was probably going to shoot it down. I just did not expect it to be this bad. I don't know. At this point, KB, I take all bets off. I'm sorry. No, I can't argue. I'm sorry. I didn't think it was going to be this blatant, though. She didn't even address Weinstein. And I hope that she will, but like, yo, that is crazy. Like, she is definitely, they could literally say, hey, we got a picture of Jason holding a water bottle. That means he drowned somebody. Like, how is, I have no idea how they're doing this. I mean, it's just blatant. Yeah. The judge is nasty work. I'm sorry that I really wish we could know, and I'm gonna have to reach out to, I know Infamous Sylvia is there. Like, did they do anything with that motion? Like Judge Doug Weinstein's motion at all? Did they get sanctioned at all for coming in late? I mean, they all came in late. That's crazy. Sounds like RICO is just a conspiracy. Weinstein's motion has to wait its turn. Okay. Said, what did I miss today? All right, it's been a wild one already. Somebody asked were there going to be fireworks, and let me just say, I said no, and I was wrong. We started out with the defense was all in place. Everybody was there. Nobody from the state was there. I really got to find that picture. Let me just rewind real quick before they came in. So the state didn't show up at all initially. They were all MIA. Craziness, right? Then Judge Whitaker was like, all right, let's just go to lunch. And then out of the blue, the camera kicked back on and they were there. So they're going through horse trading, fitness, finest, and they're going through various and sundries. You know, this picture right here shows gang activity. This statement right here shows gang activity. And in my opinion, is very, very subjective. Saying that all of my dogs are dirty, check the remains. I have no idea what that means. Was it all of us is dripping? They dripping in blood. I'm sorry. I just don't see it. But needless to say, so they've just been able to kind of define whatever as whatever they want it to be. If they want to say it's gang related, they've been able to say it. And sadly, Judge Whitaker's just been letting them happen. I mean, now I do think there's some vernacular stuff. I don't think Judge Whitaker has ever used the term dripping, ever, in this regard at all. So she's taking Adrian Love's definition and just kind of giving it, okay, that's what she said it is, then that's what it got to be. Because I don't think Max Shard is arguing it well either, in my opinion. I don't think that's the right way to do it. I'm not saying that you need to be a black person to describe it, but I'm saying that I don't think they're describing it correctly. And there's other examples there as well. So just because somebody took a picture near a plate of pastries, that means they're in a gang. Like, what are you talking about? So it's been a very eventful morning. I did not think it was going to go like this at all, but here we are nonetheless. And I do want to say thank you so much to Raymond. Says, you shocked, retired educator studying law and watching the background of Hard Knocks. Watching a background of Hard Knocks. When you figure all of this out, give me a heads up, LOL. Look, I am learning as I go. So let me tell you right now, I am shocked. I did not think it was. First of all, I just thought she was going to address Doug Weinstein. Oh, and by the way, we did read Doug Weinstein's motion to speed this trial up. And I thought it was great. I thought, if nothing else, at least move this thing along so we can get to a conclusion sooner than later. And I thought he did a great job. But according to Monica, it's gonna have to wait. So at least it's out there. But yeah. So yeah. Q, you can't be having these meetings. You can't be having a job. You cannot be having a real job. Because does your job allow you all to come in late? I don't know. This sounds like the Oprah show where they give everybody a car. You get an indictment. You get an indictment. Everybody gets an indictment. I agree. Like, Buck sitting at home minding his own business. He might have a job and a family and doing right. And all of a sudden they bringing his name up. Like, wait, what's going on here? Yeah, this might be it. Amethyst Angel, thank you for the $2 super chat and the support of the channel. What'd she say? Get the Urban Dictionary next to Black's Law book. I got you there. Now, Urban Dictionary can be spicy, though, so don't, you just read that quietly. Don't read it out loud. No, as far as I can tell, Black's Finest, there was no punishment for the state coming in late. I just can't make it make sense. I can't. I just can't make it make sense. I really hope I really hope there's something, because it makes no sense whatsoever. Like, again, like, you're almost speechless. Like, you got to be kidding me. What in the world are we watching? Buck about to get a RICO. He ate too many pastries. Absolutely, Buck in trouble, man. I don't even know. He over there minding his own business. Why hasn't any defense asked for recusal and immediate review? The judge is definitely biased, and it shows. I mean, I don't know. I don't know. I have no idea. Talk about all this bad stuff he did, yet didn't charge him, which is interesting. I think that's, in my opinion, that's where they should have went. Like, why are we talking about Buck and this person and they weren't indicted? Then what did they do? And why did they get off but other people didn't? I said other people, yeah. Good to see you, Miss Mandy. Thank you so much for hanging out. Yeah, she came in like the Terminator, and now she's She's terminated. Like, man, it's just bad. Like, what in the world is going on? The prosecutor, all of them are at the Judge Glanville's house eating barbecue ribs. I mean, I can't prove you wrong. So it sounds about right to me. If I were a juror, I'd have many questions about this. Absolutely. But see, I thought it was interesting. She didn't ask any questions. She just said, stand up if you disagree. I mean, if you're not able to forget what Woody said. And that was it. Yeah, the tinted window part, that kind of slid past me. So I did drop the link to it in the chat. So we'll have to look into that. Like, are they honestly saying that somebody, and I'll drop it in the chat again real quick. Are they honestly saying that somebody tinted the windows of a rental car? That makes no sense. That makes no sense at all. And you know they had potato salad with raisins in it. You know they did. You know they did. That's how they get down. Glanville did it. I could see them sucking up their fingers. Now, eating them ribs. I mean, really. Because, I mean, this case makes no sense to me at all. At all at this point. It makes no sense. It makes no sense whatsoever. The state has not proven, the state has not proven to me that YSL is an enterprise street gang. In my opinion, again, it's because they're trying to do something that's too big. I think they could, if they just charged each individual person for some bad things. This person robbed the bank. This person shot somebody. This person stole a car. If they just charged them for those small things, I think they would have moved this along and we would not have this problem. The problem is they're trying to put all of this stuff together and it's just too much. It's just too big to wrap your arms around. And now you're just like trying to make stuff happen. Oh, well, this person was in a picture with somebody, so therefore it must be RICO. It's got to be RICO. Because remember, they've got a pretty big burden of proof in trying to prove this RICO thing altogether. I hope they're not on lunch. They need to get working. It was a comfort break, by the way. You got everybody on conspiracy charges. Buck is costing the state money. Yeah, he is. What does Brittany say? But they're proving YSL is a record label that includes some lost souls that were out doing dumb stuff. In my opinion, that's all they've proven. That is all they've proven. They are overzealous. Yes. And I truly believe Thug was trying to help these people. I agree. Again, I'm not trying to say that they've never done anything wrong. That's not what I'm saying. I don't think that's what you're saying, Gibbs. I think what we are saying is that you haven't proven all this nefariousness that they've done. YSL is not a street gang. It's a record label that has gang members. It's like a school. Different gangs go to school, but all students chant the school name at games. I got you. Okay. I can see it. Yo, they're eating tacos with mayonnaise and tuna. Yikes. That is not a good look. That's not a happy feeling at all. So Thug is in charge, yet no money trail, no danging phone taps, etc. Like, I don't understand. But see, if you see if you see the pastries, you are now going to be brought up on RICO. You're part of YSL. She's coming off super biased. This evidence is very weak. In my opinion, from my little quick study and understanding, RICOs are very hard to prove because it allows you to do things like hearsay. That's why we got a lot of this hearsay in there. But the heavy lifting, unless you have some real hardcore evidence, is going to be just hearsay and just it's weak evidence. You really got to have strong evidence to prove a lot of this stuff, and it's just not there, I don't think. Defendants will be collecting Social Security before this trial concludes if it continues at the pace it is crawling along. Absolutely. Young Thug gonna be old Thug. Let's just say it. Tell the truth. Who or what is Buck Buck? And where Thug? I don't know. It's somebody's name. Somebody named Buck Buck. Sure, some of them are out there probably taking lives. But I don't think this is under the direction of Thug like the state wants to make it out to be, which is all they're doing. They're just trying to say like somebody did something bad. They're tied to Young Thug. This person did something criminal. He's associated with Young Thug. That's really all they're trying to do. I feel like they're trying to do it. And it just seemed like a reach. Like, my goodness, in the morning. Yeah. All record labels are gangs. Death Row, Bad Boy, OVO, all of them are gangs. I mean, there are other ones as well. So it just seems really wild. Where's the evidence for the RICO? Don't you know? It's the evidence for RICO is right here. We are part of the best live chat on the planet. That makes us RICO by default. There you go. Problem solved. Pastry Thugs is hilarious. Here we go. Let's go.
All right, we're looking at the social media posts for Mr. Sledge. Which ones do we need to litigate?
First one is number 3.
So for whatever reason, I don't seem to have let me see if I can find the numbers. They were a lot clearer on the last group. So give me a minute to find where number 3 is.
And Judge,
Yeah.
am I incorrect? I believed that we had gone over Mr. Sledge's social media post. We did not?
I don't know what happened.
I thought that we had gone over them,
Sort of.
some of them at least, and particularly number 3, if that's the one that's labeled State's Exhibit 397Y.
397Y. No, I've never seen that.
Where we talked about the fact that it was the night of Donovan Thomas's murder. And
Yes.
he was posting.
Yeah, I
Patriots.
remember talking about it.
Okay.
We haven't reviewed this, and my objection to this is the state keeps inserting these January 10th, 2015 captions on these photos.
We don't.
If you look at every other Instagram photo, there's nothing like that. But then on these January 10th, 2015, they're inserted, and that's inappropriate in my estimation. And that's my objection.
Sustained. I don't think y'all need that. That's not what it really looks like.
That's fine. And we intend to show evidence that it was posted on January 10th, 2015. So we can take out that little square that's above
The
the.
hover. Yeah.
Yes.
Okay. All right. So that objection is sustained.
And number 4, the same thing.
Okay. They'll adjust that one as well.
That's fine. And so Judge,
Yeah.
as I said the other day regarding the other inquiry about that, as I'm asking the court, if we establish with the witness who caused that to pop out.
Right. I would think that if you are having that witness testify here, here's me looking at the social media and here's what I do to find out the date it's posted and this is what it looks like. Here's, when I hover. I mean, I think that's fine and you can show that, but I think the exhibit that goes out to the jury needs to be just what it looked like, not with the hover.
So if, no objection to that ruling as to showing the exhibit with Mr. Sledge, right? Because he wasn't the one that hovered.
Right.
But as to, for instance, ADA Sprinkle, who would have been reviewing it and who would have been hovering, screen grabbing what shows up when he is looking at a social media page is relevant, we would argue, relevant evidence of the date that it was posted that goes beyond the memory of.
All right. What does the defense say to that? Like the proposal at this point is not to have the hover part with these witnesses who posted or whatever, but with the investigator or prosecutor who I guess was in charge of collecting this evidence and who confirmed via hovering that that was the date it was posted.
If my stance, the state keeps saying Mr. Sprinkle did it. I don't know that to be a fact. So if they produce the witness who hovered.
I mean, I think that's their plan, right? Is to put Mr. Sprinkle on the stand and he will testify to that.
Sprinkle, Gaither, Dennis, whichever one, because there are multiple ones.
Or just get a better screenshot.
That's my whole point.
So yeah, whichever, that will have to come in through whichever witness did the hovering.
That is what
or
we're
just get another picture. The hovering is useless.
What else?
That's so dumb.
Number 5 is. I'm going to object to number 5.
Which one?
Can't tell what number 5 is. These aren't labeled the same way as the other ones.
On your top right of your screen, do you have something that says 5 of 37?
Okay, yes, and they're also labeled. So that's State's Exhibit 399 Yankee. So that's the video. It's 399.
Okay, got it.
So
do I need to watch the video? Because if so, I need to pick which media player
I can I can hit it. It's a regular one.
Well, I'm not on Zoom, so do I just need to hear it?
I think
I can join Zoom, but I just hadn't yet. So give me just a second.
Yes, Sean.
Do I need to see it or just hear it?
I think hearing it would suffice.
Okay.
That's.
Keith, do you want to?
All right. This is so embarrassing. Come on now.
Screen.
Another picture, right?
You lied to your mama.
I just forwarded.
But you get in the courtroom and in the investigation room and tell the punk ass people the God honest motherfucking truth. Pussy ass.
I didn't stop it. Let me try it again.
Good luck.
It's loading.
Y'all think Adrian Love did her homework?
Lie to your kids. You lied to your mama. But you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
So
I thought we did discuss this one already.
There was a prior video that's been admitted into evidence where this is my recollection, and Mr. Williams, if this is not correct, I apologize.
Oh, I'm sorry.
Mr. Williams, we discussed this one as well?
we did.
Okay.
We did.
Okay, so on to the next one we did discuss.
I know My next one I had object to is number 11.
Okay. Can y'all tell me what state's exhibit number that is?
Yes.
And number 11 is, it's State's Exhibit 406Y. And to me, it seems to be a collage of other photos with Mr. Sledge and other individuals that show up in other exhibits. There's no new associations that are revealed by State's Exhibit 11.
All right. Is the point of this one the post that goes along with it?
Yes, Your Honor. Just 1 second. We're pulling it up. You got it. Yes. Just to put on the record what it says. I love my slimes, well, snakes, and they green heart emoji me. And it's a photo grid of Mr. Sledge and other YSL members. So, yes, the post and the association and the public proclamation of that association.
All right. So similar to when Mr. Zachary is himself saying, yeah, these are my YSL people, and here's me with them. If we don't already have something, I mean, we may have these individual pictures, but we don't have this assertion yet by Mr. Sledge, then that is not cumulative. So that's admitted over that objection.
Okay. Number 13 has a similar caption.
What's our exhibit number for that one?
408Y.
Okay, thank you.
Has a similar caption, and it seems to be my client dancing.
Okay, so that one's a video, which I can't open. And I don't know why, even though I'm now on Zoom, I can see it on Miss Persifield's, but I can't see it on mine.
Ms. Hilton, if you could share via Zoom, that would be helpful.
Oh, there it is. Okay. I got it now. No. Are you gonna hit play?
Share the sound.
Yeah, if you want to figure out the evidence of yours.
Who's whispering?
So this is yours.
So is dancing now
All right.
Rico too?
Why wouldn't I?
Dancing is Rico now?
Popping up over there. But
Okay. Is there anything added to this one that isn't captured in the still, other than a good beat?
Okay, I'm sorry. That was kind of funny.
Created a sound bite.
Let's let this go. It's not funny.
The still showing all of the members of YSL and the post are the most pertinent parts.
All right. So then y'all don't really need this one, right? I'm asking, is there,
We don't need the
we
big.
just looked at number, was it 11 that was like the collage? Are there people in this still or part of this video that aren't also in that collage?
Mr. Williams, I believe, but I'm checking to see in the
Okay.
collage whether Mr. Williams
All
is in
right.
the collage. Mr. Is he in there? You can't see his face in the collage. So the still shot is in the collage from the video in the upper left-hand corner, but Mr. Williams' head is turned away from
Okay.
the
So
camera
if you
in the
want to
video.
capture a still from that video that shows Mr. Williams, then you can use it.
Okay.
Okay. Next.
Number 14 is the same thing.
14 is which exhibit number? 410Y or
09Y. I'm sorry.
409Y? I thought that's what we were just looking at.
That is, Your Honor.
Did she say LimeWire? She looking at LimeWire?
Well, no, that's a different one. Okay, that seems cumulative. Unless there's some reason that the state believes it's not.
These are different people, and this is, can you hit play? This is Mr. Sledge, trying to take his seat is right there, and Mr. Williams' sister, is showing the association, is showing, again, when they're talking about, I love my green heart, green snake, red hearts, emojis, we have jail calls that we have asserted are co-conspirator statements that involve Mr. Williams' sister.
Okay.
All of these same people are in.
I didn't know that the sister is. Is the sister?
There's another exhibit, 405Y. The state, this is an unrelated trip to the club, and now we have 2 videos, a collage, and I think 2 photos
Okay.
documenting this night at the club.
Okay, so which videos are, because I haven't, unless there's some video that you just didn't.
Well, I didn't object to it.
Okay.
It's 405Y is a picture of everyone from that same night.
As they
Okay,
go.
and does
Let's
that
make
show
it
the
up.
sister?
I can't.
Yo, don't be putting those green hearts in the chat, because you know that's
Does the
RICO.
state know whether the photo that's a big group shows Mr. Williams' sister?
Okay, 2 things. So I don't know that it's the same night as Mr. Sharp's
not.
argued, but
Well, I'm
I'm
not sure
looking at
that's
the-
relevant. If the point of it is to show their association, then whether it's the same night or not. Does this show Mr. Williams' sister with this, general crowd of people?
Okay, we're going back to 405, was it?
Yes.
Y'all just making it up, so
This group?
please don't be no music in it. Come on, help a brother out.
He says State's Exhibit 405.
It's picture number 10.
Okay. Can you go down?
Everybody's a co-conspirator, man. This is craziness.
She's not in this.
Okay. Well, then that video then shows something that's not shown already. So that video is number 14. So that's admitted over objection. What's the next?
410Y. It's some sort of meme that was shared by apparently Mr. Sledge. Makes no reference to anyone in this case.
So, Your Honor, the reason that this meme, we would argue, is relevant. You're about to get 20 years for a crime your best friend did last night. Do you snitch or take the beef? You tell the punk ass police to do their fucking job. So Mr. Sledge, in his interview, he essentially said as much. On his video that the court heard a moment ago, he intimated as much. But what he's doing in this particular posting is making a public proclamation displaying their belief towards snitching. You have not only Mr. Sledge making that lie to their mama, lie to their sister, get into court and tell the guys on his truth. You have Mr. Williams, who posted a similar video with Mr. Sledge apparently in the background, mumbling, saying, sort of signing on to whatever it was that Mr. Williams was saying at the time. We would argue this right here is more of that, this is who we are. You know, we don't snitch. You let the police do what they're supposed to do, but you don't tell on your friends. And under the circumstances of this trial, especially considering some of the testimony the jury has heard, we believe that this particular type of posting, public posting, is very relevant to explain some of what the jury has seen.
Okay.
Two things, Your Honor.
Yes.
First, the state has said they have a video of Mr. Williams saying things about snitching and Mr. Sledge saying things about snitching. So this is cumulative. Also, you know, the state keeps saying they feel this, they're saying this. Mr. Sledge owns and operates, presumably, his own Instagram account. At no point does he make any reference to anyone involved in this case. At no point is he saying he's speaking for YSL. At no point is he hashtagging YSL or at YSL, anything. He's making a comment as an individual on his individual page. And he's really sharing a meme, but I don't know why that's relevant. And it's certainly cumulative when the state just said they have other people. They have him actually giving a statement, and they have Mr. Williams giving a statement that's already in evidence.
All right.
This particular assertion, it doesn't just say no snitching. It says you're about to get 20 years for a crime your best friend did last night. So the fact that Mr. Williams has made an assertion that is very similar in nature to the one that Mr. Sledge has made, and then the fact that this particular posting references not just telling on someone, but you're about to take the heat for something your friends did. It's displaying yet another message to the public about YSL and we would argue, their willingness to stick together and stand on, you know, their loyalty towards one another. The argument, I don't know that it's so much necessary to say that it's, you know, it would be our argument that he is asserting the sensibility, the way that YSL operates. That's what we would be doing. It's proof. We would argue it's our evidence of the way that YSL sort of.
All right. I'm going to sustain that objection on 403 grounds. What's next?
All right. Thank you, Raymond, for the super chat. Thank you so much.
413.
Yeah, she's a natural. I agree. Don't stand on business.
Is this the same video that was I believe 399 and 413 are the same. Am I incorrect?
I don't know. Are those the same video?
Oh, I'm sorry. It's a different video, but he's saying the same thing. He says the same thing twice about snitching and things of that nature.
So, do I need to hear what this says?
Hey man, nigga getting to tell lies to his kids, tell lies to his mama, but get in the courtroom and tell the judge and God on the truth. Y'all pussy ass niggas, we call you whole ass niggas strip now.
All right, I just try to.
I think it's actually, and I think it's the same words. One time he's wearing a white T-shirt, it appears, and one time he's wearing a white tank top. I don't know why he recorded it twice.
We can just use this one, especially since he says black at the end.
Okay.
BLATT, black.
All right. So this one, and what's the number that you're not going to use instead?
399Y.
399Y will be out then.
What's black? What's black?
Okay.
And Your Honor, the other issue is that posting it multiple times, posting their feelings about snitching multiple times, it is meant to reinforce
how strongly they feel about it.
All right, so what were the dates of the two posts? I had understood you to say that you wouldn't use the other one, but are you now saying you do want to use the other one?
So we would ask, yes, to use both because if one is on July 19th, 2015, and the other one is on 399 is on July 19th, 2015, and the other one is on March 25th, 2015, we would ask to be able to use both.
Okay. Well, I mean, that does show that this isn't a one-time thing. I guess at least this guy wants to reiterate it. So I will admit that then.
Wow.
What's next?
416Y. Relevance.
What's the relevance of this?
I would just give up at this point. At this point in the game, I would probably just give up, man. Like, this is ridiculous.
So who else in that?
Martinez Arnold, Diamante Kendrick.
I mean, I can see the relevance. What I'm wondering is whether it's cumulative. But Arnold and Kendrick, I don't think we've had any, at least in what we've reviewed so far, the two of them.
They've both pled together on a count in this indictment. I mean, there's going to be absolutely no. No, not on this indictment, but there's a count in this indictment,
Right.
and an overact where they both pled.
Yeah. No, I'm saying we don't have any videos or photos that we've at least looked at today that have the two of them wearing YSL garb together, right?
I don't think we have.
Okay, well,
We got one. Yeah. So no, not so far.
okay. Anybody dispute that?
I don't believe so.
Okay, then that will be admitted over objection. What's next?
Number 22. It's another video that I don't see the relevance.
Okay.
417Y.
Thank you.
I don't see the relevance of this case, but I mean, I digress.
Bitch, we out doing a little shopping, bitch. How we having this shit? Yeah, turn up.
In Chicago.
So that was the extent of that. Was the court able to see it?
I mean, tell me who all's in it and why.
Shannon Stillwell, Diamante Kendrick, Antonio Sledge. And this is a couple of months after Mr. Thomas's murder. Diamante Kendrick is in the coat that he is wearing the night of Mr. Thomas's murder. And they are still very much associating with one another. One of the arguments that was made the other day by, I believe, Mr. Sharp was he objected to part of the factual acknowledgement of Mr. Sledge and argued that he would have had no basis for personal knowledge of information that had happened on a particular night. This
Okay, well, this might show that as a foundation, but that's not for the jury, that's for me. So,
No, I'm just, as far as relevance goes, it would be relevant for those purposes.
We've just seen.
Co-counsel is emphasizing that jacket being the jacket that he was wearing. Mr. Kendrick, if we need to rewind it, we can show you.
I saw it.
Excuse me, I don't believe that's the same coat. I believe it's arguably similar, but I don't believe it's the same coat.
How do y'all know what he was wearing that night anyway?
Yeah.
What evidence is in or going to be in?
It's on video. He's clearly walking into a store that's a few 100 feet away from Mr.
And that's clearly him. And so what does it matter that he's wearing the same coat later? It's his coat. I mean, why does that matter?
No, just,
I mean, seriously.
in terms of one identification, I understand that the court is saying you can see him clearly on the photograph in the surveillance video, but also he's with Mr. Stillwell, who is also alleged to have committed the act with him 2 months afterwards, and he's with Mr. Sledge. So when Mr. Sledge gets on the stand and tells the jury, or whether he does or doesn't acknowledge that he knows.
All right. Well, so then this might come in as impeachment evidence, but I'm not hearing like, oh yeah, no, we never hung out, or we didn't hang out after that night because I was appalled at what they supposedly did. Then yes, but otherwise.
And also, I think, and Mr. Kendrick filed an alibi notice as well regarding where he was at the time of the murder. So
okay, but it wasn't. This has no relevance to his alibi.
Not directly, just that it's further proof that that's him in the video and him at the location and him right there 6 minutes before the murder.
Okay, so then back to the coat being the thing that matters. Then.
Right, here we go.
Yes. Yes.
I guess if your client, Mr. Weinstein, is saying I wasn't.
He's not denying being at the gas station. It's in the video. You can clearly see that he's walking into the gas station.
What's his alibi? Then maybe I'll need to go look up the alibi notice.
He was with Miss Morton later that night.
So it doesn't cover the time of.
No, he was with Miss Morton at the time of the murder.
Okay. What time?
But what the coats have to do with this, I have no idea. What a March video has to do with his alibi on January the 10th.
Right. What's the time of the gas station video?
At the time, it was at the time of the murder. It was 6 minutes before the murder.
Okay.
Your Honor.
No, hang on just a second. Sorry. And then is Mr. Kendrick's alibi that I may have been at the gas station 6 minutes before, but 4 minutes before, through the time of the murder, I was with somebody else somewhere else?
Correct.
Yeah.
Give me 1 second.
Okay.
You can get pretty far in 5 to 6 seconds, 5 or 6 minutes.
Again, there's no denial that he was at the gas station prior to the murder.
All right. But not. Okay. So the code doesn't add anything to that.
Come on.
But it's not the same. He's like my wife, Your Honor. He buys the same style coat, but it's not the same.
Whether it's the same code or a different code,
it's
it
irrelevant.
Doesn't show anything about the viability of his alibi. And anything else before I exclude this one? No. Okay, moving on. That one's out.
Wow.
23, Your Honor. The previous photos have 418Y have continued to show an association between Mr. Sledge, Mr. Zachary, and Mr. Stillwell. That's been established through the photos already.
All right, and who is this we've got right now?
That is Mr. Stillwell, Mr. Zachary, and Mr. Sledge.
Go ahead.
I would point out the caption that Mr. Sledge makes underneath the photo, gangsters sitting at the round table with 3 green snake emojis on March 4, 2015.
And those same emojis are what justified all these previous.
Okay. So is are you making the argument gangsters sitting at the round table is like a reference to King Arthur and the Knights of the Round Table or what? Or just the fact that they're saying gangsters?
That they are calling themselves that he is calling them gangsters, because I believe at some point there will be, we've heard at least one witness while we were talking about gang say game, like GAME. So I believe that there may be efforts to distance YSL members. Well, there have been consistent efforts to distance YSL members from being gang members, gangsters. So we would argue that he is not just sort of making this,
No.
oblique reference. He's proclaiming for the public something.
Wait. So is she making a hard R?
The generic term gangster is propensity, first of all. But secondly, this, if Mr. Sledge says something on the stand that's vastly is shocking to the state and they feel that this contradicts it, then perhaps there's another discussion. But in and of itself, until that happens, I don't know why this would be relevant to anything.
So remind me, the one that gangster in every city we go, that would show the same thing.
You didn't keep it in.
I didn't rule it out. I held it.
We would prefer this one over that one.
All right, then that one will be out and this one will be in then. But they kind of get to the same thing.
So, Your Honor, could the court give me?
Sure.
Right.
Is that an ex parte?
Okay. If we're going to choose, we would choose the one closer in time to Mr. Donovan Thomas's death. So we would cede this one.
All right. So then 418Y is ouch. And if it ends up being some kind of impeachment evidence, just sort of alert us before we use that. Okay.
Oh, amazing.
What's next?
Number 421Y, which is number 26. It's another group photo.
Mm-hmm.
This is a picture that's in our indictment. I believe we may have even already admitted the photograph, but the caption is also part of what is important. So both the photograph, the caption, and the fact that it's in our indictment alleged as an overact.
What do you mean alleged as an overact?
The posting of that photograph was alleged as an overact.
As an overact.
Yes.
Okay. Then, and so, okay, you allege as an overact that they post things that promote YSL, and you showed this picture as an example, and this is showing that it was actually posted. Is that the argument?
Yes.
Okay.
I think that.
And it's the cap.
Yeah,
can see what the caption reads. I'm gonna permit that one.
Okay, now here is and when I say here, I'm talking about 422Y
Okay.
is the actual post that does not involve anyone hovering over anything that says a date.
Right.
And I know the relevance of the date and the time. And so I don't have any objection to that, but that's the way I believe that these, not some manipulated timestamp on the upper right, but as it appears in Instagram. And so I don't have any objection to 422Y, but going back to that other
Right.
exhibit, which is 397Y, I would say 422Y is more appropriate.
Okay, and it actually, you can see down there at the bottom of the post a time and a date.
This is exactly like when we were talking about the other day where we had the picture with the pop out of the one we dealt with on Friday.
Mm-hmm.
We had both the pop out and we had the date and time. When I referenced to the court, we had both. So this is the same situation. So we would be introducing this one, and since it's no objection, we wouldn't have a need unless there's this argument about what date it really was posted to show the other one.
Use the other one. Okay. All right.
So this next one, which is 423Y, that caption is already on 420Y. It appears that he's reposting something that some other individual who I don't know who he is, and I have no reason to believe that he's in this case, SMM body count with an X instead of a C, posted. And if you go back to 420Y, I believe, you see the exact same, I'll never switch up on my brew, I'm not a dub. So that seems cumulative, and quite frankly, I'm not a big fan, and I believe it's prejudicial to have a post by this gentleman, SMM body count, who we don't even know who he is.
Yeah. What's the state's response?
I'm looking at the. Okay. That's fine. We don't object.
Okay, so they concede
Or
that
concede,
they will
yes.
not use, what is it, 422? 423Y? 423Y. Okay. Thank you. Next.
So I believe that this is a cumulative.
Which one?
I'm sorry, 426Y, number 31, photo 31, is a cumulative of the group
Hang
photo.
on, that one doesn't open for me.
It's on the screen.
Too many things open. Okay, yeah, it looks like the same thing.
That's a cumulative of 405Y.
We're going to put up both.
Okay.
Okay. We won't use both, Your Honor. We'd ask that the court allows.
All right, well, choose now so that we know which one.
Choose the one that is 405Y.
Okay. All right, so they will not use 426Y.
Oh, wait, his phone.
Okay.
Okay.
I don't understand the relevance of 427Y.
So there's a relevance objection to this one.
His it's that he listed his phone number, and his phone number by I mean Mr. Sledge.
Okay. So if he refuses to say what his phone number is or was at the time,
Or we
then,
can refresh
you'll
it.
use it.
Right.
Okay. Which you could certainly just use it to refresh his
Right.
recollection. Okay. So that'll only be in that eventuality.
Or if he doesn't remember even after looking at it, then we would have to use it.
Sure. All right, any others? We're almost to the end of this grouping.
Yes, Your Honor, 430Y, which is number 34.
I don't see a 430Y, but okay. Go ahead. Who all do we have there?
Don't we have Mr. Williams? We hear the reference to King Slime. Could you play it back again? Sledge right there, Mr. Williams right there, Mr. Arnold, Mr. Stillwell, and Mr. Kendrick, Darlington, and Kendrick,
All right.
and Copeland. Oh, Mr. Copeland's in there too.
And when's this from?
This was from
And also whose account? I'd be interested.
What, I couldn't hear what you said.
I'm not sure we know whose account it's from either.
We have it from YSL_Daniel1.
Who is that? So I, the justification is for these videos has been, oh, it's showing promotion. And we don't even know who posted this.
but we have people who are in the video who can talk about the video. It's what's happening in that scene itself.
They're sitting at a table.
That he can lay a foundation for it.
Who, and this is going to be Mr. Sledge that testifies to this?
Yes. And in this particular instance, this isn't so much as them promoting their violence. This is them referring to, we believe Mr. Williams as King Slime. This is them, all of them. I don't know that we have these particular individuals all at one time in a setting together. And we believe and can later confirm that it is Mr. Williams' Sky House condo, but we'll confirm that.
Okay. I would think that would be relevant. All right, so I'm going to overrule the objection to that.
Wow.
What else?
Just 404Y, which is number 37.
And let me say, let me go back to that one for a minute.
Thank you for the super chat. And I agree with you 100%.
Sorry, since y'all don't know who posted it, I mean, if you figure out who posted it, that's one thing. But if not, we don't need to show the handle or whatever of whomever the poster is. Okay.
Yes, Your Honor.
All right. Okay. Now back to the next one.
It's the last one, Your Honor, 404Y, number 37.
All right. Have we already talked about this one?
We're talking about them all, it seems like.
Oh, this is,
Stop putting me on fucking fake pages. Cause I don't give a fuck, man. What? Anybody want to see Monto? I'm here. I don't. And I do not run for fuck niggas. You did.
This is the day after the Adele Drive shooting
okay.
that Mr. Sledge and others were convicted of.
What's the objection?
I'm going to withdraw my objection.
Okay. All right, so that.
Well, Montunk is not
grouping
on
of
trial.
Social media.
Moontunk's not on trial, so maybe that, why is he relevant?
I think I might have to go back and get into that Dropbox again.
All right, so apparently they're looking for which end is up next, what they're going to do next. I have no idea. This is wild.
All right, the next folder is tattoos, is what that.
Oh,
folder
man, the
called.
the
Or do
ink
you
is
have
Rico.
Objections to anything in there?
Man, let the brothers have ink, man. Come on.
I mean, looks like a lot of them are the same picture over again. So at least I would think half of them, we don't need the same thing twice.
I agree. Now that I agree with.
We wouldn't be putting in
Okay,
multiple pictures
beyond
of
that, any objection? I mean, I assume he's going to testify that all of these are somehow gang-related tattoos or what? Because if they're just art, then that's not relevant.
we're not going to put in all of them, just the ones that reference or pertain to his. And I mean, he'll be here, so we may not
Right.
even put him in at all. He can show the jury.
Well, I don't think I want him stripping down in court.
No.
So.
Oh my gosh.
So if he
Is
wants
that
to show us what on his forearm, that's one thing. Otherwise, I'd rather let's use the picture, okay? I don't know. I can't get an answer to that. Do you know which ones you're gonna intend to use that you believe are relevant to an issue on trial here? That he can't roll up his sleeve and show us?
That was kind of funny though. At this point in the game, they're just literally making up stuff.
Yeah.
I think we're not going to need to use Mr. Sledge's tattoo photographs.
All right.
Oh, nice.
And yeah.
Because they know they're losing. This is
Okay.
crazy.
I don't think at this time.
So I don't know what that, then there's an image that is, oh, it's a video that isn't in the other videos. What's that one? Is there an objection to that one?
I'm sorry, Your Honor,
I object to it all.
I mean, so I opened up the Dropbox and, you know, went to Sledge's folder, and then within that folder,
Okay, I'm sorry. I just clicked on it. I think that's the video. Is it the image?
yeah, 0156, whatever. Yeah. So is that objectionable?
No.
Okay. Any of the other items in that folder? And they're marked with exhibit numbers.
It's crazy.
Is the court asking whether, oh,
I know that the state's position, I assume, is y'all intend to use those and believe they are admissible. So I'm asking if there an objection to them.
So the plea agreement, I've already
Okay.
spoken about that.
Yeah, and so, yeah, it's a little more helpful actually when I looked this weekend to see what it is y'all are talking about. And I would think whether that comes in or not depends upon how that witness testifies. So
When you're saying that comes in, are you speaking specifically?
this, I'm looking at the, whatever it is, December 27th, 2022, several page. It's called plea agreement, but he's initial different factual assertions, and that's the one I'm talking about. It's 396 Y Charlie, Yankee Charlie.
Yes, Your Honor. And the terms of the plea obviously are fodder for cross-examination.
Right.
I would concede that potentially, depending on his testimony, statements that he acknowledged that would be inconsistent with his testimony could possibly be prior inconsistent statements. I would concede that fact. So I agree with Your Honor that to deal with the admissibility of the factual acknowledgement section, we would need to hear his testimony. My specific concern dealt with number 8, and just as I had concerns about Mr. Zachary and Mr. Copeland, whether they were in their prior statements, whether they were speaking out of actual firsthand knowledge or if they were speaking out of inadmissible hearsay or rumor or speculation. I don't want Mr. Sledge to be cross-examined or to be impeached with a prior statement that was based on that the basis of it was inadmissible to begin with. That's my concern.
Well,
And all I can say, and I'm not Mr. Sledge, so I cannot answer this for Your Honor, but I can say from my understanding from working on this case, that number 8 is not based on anything that my client has told him, and it's not based on firsthand knowledge.
I think that may just be something you'll have to explore because he initialed and signed a sworn statement saying, I personally know this. Maybe he doesn't personally know it and it was a lie, but I mean, they've gotten that there for a reason. And that's just going to have to be something y'all explore with regard to his credibility. You know, I mean, he is right here asserting in this document, I do personally know it.
Well,
so
I understand what you're saying. And, you know, these are not, I understand he signed it. He did not write it. And so personally knowing to a layman can mean a lot of different things.
yeah, he had an attorney at the time, right?
He did.
Yeah, so I think that, yeah, that I can't keep it out on that basis. All right, what else?
We briefly discussed the plea transcript. I don't know under what circumstance that would be admissible.
I would think that would also be a impeachment item. Right? Would y'all only intend that for recollection or impeachment?
Right, recollection or
Okay.
Okay, and then we also have a gang profile, which is filled out by someone. I don't know who wrote this. I don't think we know. We've been given a bunch of these. I don't know if we know who wrote any of them, but it wasn't Mr. Sledge.
Right.
So
We would not introduce the gang profile as an exhibit through Mr. Sledge. We may
Find out who
use
wrote
some
it.
part of it to refresh his recollection or something like that. It would be, because it would be a document that details certain incidents that involve Mr. Sledge. And it has photographs of him in it. We wouldn't be just whole hog introducing that.
All right, so this is not going to go before the jury.
Right.
Y'all may
We
potentially refresh his recollection.
It's just
over something like this. Okay. All right. Okay, that takes care of these Sledge exhibits, right?
I believe so, Your Honor.
Sorry about
Okay,
that.
so who do we move to next then?
And this is not stuff that they should have been doing, right? Because it just seems like a lot of busy work.
Sorry, I've got.
Maybe they needed the judge. Maybe they needed the judge. My bad.
Dropbox for some reason.
Yo, thank you everybody who's been supporting through Cash App as well as the Super Chats. Thank you very much. Support goes very far. Thank you so much.
Is there anything with, I know, looking at the witness list, we've talked about Burnett, Sledge, and Zachary now. Thorpe's going to be moved to a bit later. So Bean.
Not yet, Your Honor. There was one that we can talk about that I think merits conversation.
Okay.
So Mr. Kendrick pled guilty in 2015 when he was arrested with Martinez Arnold in October 2015, where they had the two guns, one of which was stolen. In the plea colloquy, the prosecutor, as a factual basis, asserted that YSL is a gang and that Mr. Kendrick is a member of YSL. And Mr. Kendrick acknowledged that and agreed to that. And so we intend to introduce evidence of that against Mr. Kendrick during the trial.
Okay.
We're absolutely going to object to the entry of not only that colloquy, but any plea that reflects a gang charge that Mr. Kendrick pled guilty to. Mr. Kendrick, to my understanding, I mean, that's a decision he's going to make, but I have no expectation that I'm going to have the opportunity to cross-examine him. It was a testimonial statement. He was in court speaking to law enforcement for the purposes of securing himself the best deal possible. And certainly his acknowledgement, admission, or his testimony, I would say, is what it is, out-of-court testimony, or out-of-court testimony as applies to this case, affects my client. A element of this whole case is whether YSL qualifies as a criminal street gang under the law. Mr. Kendrick provided testimony to that, that I will not be able to cross-examine. And so we are going to object to any entry of the plea to any gang count and any colloquy during the plea regarding the nature of YSL, according to Mr. Kendrick.
And Your Honor, the court can limit the jury to consider that against Mr. Kendrick only.
Go ahead.
That would be wholly insufficient to protect the rights of Mr. Stillwell and the others, quite frankly. curative instruction or a limiting instruction is not going to suffice. And the state can try to prove their case, but they cannot try to prove their case with Mr. Kendrick's statements during a plea.
Well, I'm not sure that's true. I mean, if it is admitted only against
forgot about that.
Mr. Kendrick, and I am Kendrick's, and I tell them that that's all it can be considered against, we'd have to craft the right instruction, but I mean, it's out there and it's evidence. And I mean, I agree it's testimonial, and so it shouldn't come in against anybody other than him. It can't come in against anybody other than him, but seems that it ought to be able to come in against him. Are you
Why
saying
though?
There's just no way to limit it?
Go ahead, Mr.
Yeah, and I agree with Mr. Shart. That is asking the jury to climb a steep hurdle. And that's why Bruton says that, yes, you can limit the statement. It used to be, as the court may remember, on a Bruton issue, if Mr. Kendrick made a statement, he made a statement in this case on October 6, 2015, and he implicated Mr. Stillwell, or he implicated Mr. Williams, etc. It used to be that there was an instruction given, going back to common law, that it can only be used against Mr. Kendrick. And the court said that's not good enough. In a joint trial, the jurors can't be expected to follow that instruction. It's you said it earlier too. Presumably the jurors follow the instruction all the time. That's what we presume. But in Bruton, that's why we excise or redact.
Right.
And here, it is an essential element of this conspiracy in count 1 and several of the gang counts that YSL is a criminal street gang. And now you have, and that's what I was saying before, and I'm looking for the cases.
Right.
But for Mr. Kendrick to get up and say, not get up, but for his plea colloquy to say, I am a member of YSL's criminal street gang, that instruction has to be airtight. Otherwise, he needs to be severed.
I mean, I agree that the instruction needs to be airtight.
Or he needs to be severed, or it's excluded. And I gave you a case when you first came on the bench here. I gave you, if you remember, if you don't, I could give another copy. United States versus Vendetti, V-A-N-D-E-T-T-I. I gave it to everybody, or at least the ensemble court in the state, and I think Mr. Weinstein. It's 623 F second 1144. It's the Sixth Circuit. It's 1980. It's good law. And I also cited State versus Jefferson, which is 302 Georgia, 435. That's 807 Southeast 2D, 387 2017. And they just and it's State versus Thomas, THOMAS, 364 Georgia, PO 148, Division 2, 874 Southeast 2D, 195, 2022. But the bottom line, Your Honor, is I would agree with the Honorable Maxwell Shart that a instruction for that type of, that is explosive evidence that goes directly to the essential elements. So I do not believe that instruction would cure any type of fair trial for the other people in this case.
Just briefly, Your Honor, we would object to any severance at this point in time in the case.
All right. I mean, I've read Vendetti, and I don't think that it actually stands for the proposition that you're arguing it for right now. I looked at the other two.
That's
as well.
interesting.
The guilty plea of any non-testifying co-defendant can't, it's not proof of guilt for any of the other co-defendants. I mean, I agree with that, but that's not what it would be offered for. Y'all, the state, need to come up with an instruction that you believe will insulate the admission of the plea
What?
colloquy, you know, the part that you intended, where if he says, yes, YSL is a gang and I'm a member of it, from any Bruton-ish type problems.
Bruton-ish.
Yes, Your Honor.
And we'd need to do it at, you know, before that's admitted, not just at the end of the trial. It needs to be provided to the jury at the time the evidence is admitted.
Understood.
But, I mean, I don't think that the law provides that it needs to be excluded, just that it needs to be appropriately limited.
Interesting. Okay.
And if you can find other law, please forward it.
Other law.
But I don't think those three do it. And let's see. So Thomas, give me those two sites again. Just let me make sure I wrote them down correctly. I think you said 302 Georgia 435.
Yes, that's State versus Jefferson,
Jefferson. Okay.
2017, and then State versus Thomas, 364 Georgia PO 148, Division 2.
Yeah, got it. Thank you. Yes.
May we offer as well Henderson, just for the court's consideration. Henderson v. State is a Georgia Supreme Court case decided August 21st, 2023, 317 Georgia 66 at 77.
Okay. Is that a new one or have y'all given me that before? Okay. All right, I'll take a look at it. Okay. So you think y'all may have? All right. For a different reason. Okay, well, I'll take a look at it for this reason. All right, so we're gonna need to do some work on that one, but those are, I think we understand the parameters. Okay, so I don't know what, I mean, thank you whomever raised that, but in terms of going through what other groupings of evidence we need to look at in this first 30 witnesses. The next witness that is on y'all's list in order, you know, generally in order is Mr. Bean. Is there anything from him that we need to look at? I think, yeah, no, okay. So no social media from him? I didn't even see him in this folder, but.
Mr. Bean,
No.
that's the guy that was getting high.
And then there's
Mr. Bean.
Kenya Morton, and there's maybe an interview from her. I don't know if you.
Her interview would not come in
Okay.
unless she's listed as the alibi witness for Mr. Kendrick.
Okay.
And we wouldn't be putting in her interview unless it was to impeach her.
Unless it's impeachment.
All right, so we don't need to look at any evidence that's going to be used with her, right? Okay. Then Sprinkle, is there anything we haven't already talked about for him that? So he's got a folder. If y'all want to open up his folder. And then within his folder are lots of folders. So hopefully the defense has, in the couple of weeks they've had the folders,
Why is it gonna be defense's fault?
months and months that I guess they've had the evidence, made a determination as to what, if anything, y'all would be objecting to in this grouping of evidence.
I do have objections, but there's a lot here, so I don't. We can discuss certain things, as Your Honor sees fit. I will say I do have objections in this folder, though.
Okay, well, now's the time to go through them while we have some days without our jury.
Yes, Your
So
Honor.
let's dive in.
Okay.
Where shall we start? We've got an Arnold file, two Arnold files, Garlington, Kendricks, other items, Stillwell, and then some.
Wow.
I don't
This is
know.
such,
Looks like pictures, maybe.
this is so painful.
Let me ask this. Is there something that y'all are more ready on, and then we could dive into this tomorrow? Would that help?
Wow. Talk about helping him with the homework. This is straight study hall.
Sure.
What's up, Trevor? How are you? Grace and peace.
Finish, we can make an announcement on the Marquavius Huey motion in limine, so get that off of our.
Okay. We'll wait till after they confer.
But they're going to say nothing about the moving the child forward. Okay.
Sure. Why don't we just take a quick recess? That way, if anybody needs to use the restroom, y'all can talk. And if anybody else needs to use the restroom, they can go use the restroom. Okay. And
Amazing. Amazing. Yo, when we call this Saturday school court, I mean, we mean that as the most pejorative that you can pejorative. This is craziness, man. Come on. Wow. Where are y'all at with this? How are y'all feeling about this right now? It seems like let's do that. Let's drop in the chat. Go ahead and give me an emoji that kind of depicts how you're feeling right now about this, because this is just insane. I'm sorry, Judge Whitaker is doing too much to help this doggone defense. I'm sorry, state prosecution. This is just craziness now. I see somebody talking about Weinstein. Yeah, like Weinstein asked for that primarily because of what we're seeing, in my opinion. Let's see what we got. We got the embarrassment. Oh, don't be putting green things in there. Remember that's Rico right there. Allie, come on. I'm with you. I'm with you. Very confused. Yeah, Trevor, this has been a trash fire since day one. And it just doesn't look much better. Atlanta, we got to do better, Jim. Very confusing. Very confused. I agree with you 100%. Yeah, I mean, totally. Hey, thank you, Red Jacks, for the super sticker. Thank you so much for the support. Grace and peace. Thank you, friend. Yo, I don't get it personally. I do not understand. I still would love to know, did the prosecution get any kind of reprimand for coming in late this morning? Did they get any kind of And it seems like they didn't. I not to be funny about it, but I seem pretty comfortable that they did not get any kind of sanction. Yeah, I'm right there with you, Bridget. Lots of, yeah, she just quit. She just gave up. Like, look, I'm just biased. I'm biased. No. What's that? You're not ready? It's the defense's fault. Like, that's what I'm feeling like now. Like, yo, you're not ready. It's got to be something that the defense has done wrong, because you would be ready. Here. All right, I'm working on a project here. I think you all will like it. All right, got a couple of projects that I'm about to drop in the chat in a moment. You know, I've been working on these, so real quick. So they're not the best. I think they're pretty good, though. I think they're pretty good. I think you'll get at least get a chuckle out of it, if nothing else. At least get a little smile in your day. Oh man. All right. And this is how I'm feeling for sure. I mean, when they said pastries, like literally they had pastries in the picture as if that's like a evidence that somebody's in a gang. At this point in the game, I'm like, what isn't a gang? I think it's probably a much more reasonable question. What is not a gang? Because at this point, I have no idea. Like, what doesn't constitute a gang? Okay, let me just close out a couple of these things so I can share them with y'all. All right. This is craziness. I suspect today's behavior will go to the bar. I don't hold up any, unless by bar you mean the bar. I'm sorry, man. I just can't. After what I've seen so far today, man, and what we've been seeing most of the day, I have no hope that anything is going to come out of this, and that they're not going to be held accountable. They're not going to be made to at least acknowledge where they're wrong. I don't think that's going to even happen, man. Any other time I would have believed it, but now I'm just like, I don't even think Judge Whitaker even cares. Just Whitaker's just doing whatever. Just flying by the seat of her pants. Okay. I think I got all the colors now. I might be wrong. Darn it. Yeah, this is definitely, wow, 40 likes short of 1,000. That's what's up. Thank y'all so much for everybody that's hung out with us. I mean, we started out pretty early, and if you weren't following along, court started late today, and it will start late tomorrow as well. So I'll probably go live, and maybe, hopefully there'll be some new motions. We'll read some new motions tomorrow. But what we did, we started out with Doug Weinstein's motion for a speedy trial. We started with that, and then court started, so we jumped right in and got cranking. So we've been going since then. I hope that tomorrow will be equally as entertaining as today, because man, this is just wild at this point. But yeah, I definitely, man, 40 short. Thank y'all so much. Everybody that's liked the video and come through and checked us out. What does Christy say? Christy's like not feeling this at all. I see you over there. We watch YouTube. We see you. At the current moment, my Rule 22 has not come through. I am looking again on my email. I was not paying attention to it, but let's just look. Maybe the Lord is moving. No, my daughter's language teacher sent me an email that she has a language competition. Okay, there we go. Let me look at my spam folder real quick as well. The response, the initial response came quick. I wonder why it's taking so long though. Hopefully they're not over here in this live chat. Like, look at this guy. He's over here causing all this trouble. Yeah, like how you gonna have sprinkles on the pastry, man? What's up with that? Yeah, man, they wild, man. Nah, I have nothing, man. So to answer your question, I have not gotten my Rule 22 yet, but I'm just going tomorrow. Thank you for allowing us to watch the trial with other viewers without major shout outs and interruptions. Okay, no problem. Thank you so much for hanging out with me. Okay, if you can't hear the judge, it's because they're not using their microphones correctly. It's definitely loud on this outlet that I'm using. So it's not us, it's them. It's not you, it's them. No, it hasn't spoke on it at all, actually, as far as we know, at least. The rumor has it that she's going to deal with it a little later, but she hasn't outright said it. So we're just kind of like playing around. Thank you so much, Real Thoughts. Thank you. Yeah, at this point, water is RICO. Like if you're getting water, they're literally sharing pictures saying, oh, this is RICO. Like, y'all are wild, man. All right, let me see if I got this right. Okay, I called myself designing t-shirts while we were doing this. So let me see if I got it right. Let's see. Okay. All right, if you're interested, the DWC Gang Gang t-shirt is now in the store. I just dropped, I was calling myself making it. Check it out first. Let me know what y'all think about it. Who can place a bar complaint? Okay, if I'm understanding this correctly, that's a great question. All right. It has to be somebody that's associated with the case, if I'm understanding correctly. So for example, this is the YSL trial. So it had to be somebody from the defense, from the prosecution, I think a resident of Fulton County. Okay, so therefore, I think anybody in Fulton County that's watching this is like, this is an absolute dumpster fire. Then they should be able to file a bar complaint, I think. But I am not a professional. I am not anything. I'm just how I understand it. But even in that, now this I do know, even in bar complaints, they don't get as much, they don't, oh yeah, I need to let you get in that store. I'm sorry, Missy. Even with bar complaints, they don't, for example, if I filed a bar complaint against Adrian Love, and let's just say it was valid and the bar literally said Jason is correct, you as the general public might not know that the bar has said that Adrian Love, you're going to be suspended for a week, or Adrian Love, you might get a fine. You don't have to know. They might not let you know that. It's only when it gets to a certain level, AKA what happened with Melnick being suspended for 6 months. That's it, if I'm understanding correctly. But I will definitely make sure to ask like Phil Holloway or other real lawyers that kind of get into this, AV and the lead attorney. They've talked about this because they've been a part of it. So I'm just really, I'm just learning. Okay. Trevor, that hurt, bro. That hurt like in a special way, bro. That was really messed up, man. Okay. They allege that this case is going to be over by February. Is it February? Yeah, February. I'm not gonna. I do think that it probably could be over in 2025. I just think February is super aggressive because you got Thanksgiving, Christmas, New Year's, all that coming back to back to back to back. So there's going to be lots of breaks in between there. So I'm not holding my hope on that. I mean, it's going to end in 2025. I will say that. I do think no matter what, even with Judge Whitaker doing what she's doing, it'll probably end in 2025. I just can't see what they're talking about February. I'm like, good luck with that, my guys. So I think some people are saying May. I can dig. May makes sense. February did not make sense. Not with, again, coming off the Thanksgiving, Christmas, New Year's, all those holidays right after one another. Yeah, I'm not holding out any hope. And I guarantee you, there's going to be more shenanigans that are going to come up, all that kind of stuff like that. Yeah, I can't. I'm not going to lie and pretend like, oh, yeah, that makes sense. Because I don't believe it will. I don't believe it's going to happen like that. All right, let's see. Now, this is a good question. Y'all are coming in with these good questions, Real Thought. Will anything from this trial bring case law in the future? I think there's going to be a lot of things. I don't know if is that case law? If states are no longer able to just determine that something is RICO, I think that's going to come up. Wait. Oh, I'm sorry. I thought somebody was giving me some insight about bar complaints. I do believe that there's going to be things that come out of it. Like example, a city or county cannot just determine that something is RICO on their own strength. I do think that's going to come out of this. I do think that there's going to be a lot more discussion about using rap lyrics, good or bad. I think there's going to be a lot more discussion about that. So there'll be some case law that comes out of it like that. I think also speedy trials is going to become, they'll look at this and be like, remember the Georgia RICO case, the YSL trial, blah, 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 took 2 years, blah, blah. I think that's going to come out of that. That's my little 2 cents. What did I see here? Oh, I like that. RICO's the new 3 strikes law is being overused and prosecutors are pushing it far past what it was intended for. There we go. It's like NASA saying astronauts can come home in February. That was a long 8-day trip from Boeing. I agree. Oh, okay. See, this is something I didn't know. And what does Bitter Lily say? Adrian Love has previous cases of Brady that the bar needs to take note of. And there we go. Well, let's just here, full disclosure. What happened to Jonathan Melnick was a couple of years ago. That whole situation, it's been held up in whatever their little process is, and it just came down allegedly just last week. But it was some time ago. It wasn't last Tuesday. So if that be the case, then what hope do we have at Adrian Love? It has to be through the Supreme Court. I don't know what that is. What was the discussion? Yeah, they're bringing, I hope the goodness we just misunderstood. I hope we really misunderstood. And they're not trying to bring a hospice patient to talk about cell phone data or cars or whatever. That's just wrong. I'm sorry. And oh my gosh, that's just wrong. There's so much that could go wrong with that. I can't even wrap my mind around. I hope that wasn't it. I really hope that's not what they were trying to do. So these states have enacted RICO statutes, but does it rein it in or does it allow them to keep using it like we're using it, is my question. Res1 asks, do y'all think this thug cat should be on the same level as Capone in a RICO case? What a waste of taxpayers' money. Please remember, Al Capone, after all the evil, all the wrong that Al Capone was accused of, he was only arrested and thrown in prison for tax evasion. So they didn't use RICO, I don't think we had RICO at that point. Well, maybe they did, but all those charges, all the things that Al Capone is known for, all those things that Al Capone has been accused of, all they got him on was tax evasion when the smoke cleared. To me, I think they should just go in and cut their losses and see if they can get Young Thug on something like that. If that's what it ultimately should be. I just think that the RICO is just too much. And we see it. We're looking at it in 4K. This is too much. Love learned Brady from Harris. That is hilarious. I honestly think a RICO should not ever be charged by a state prosecutor. Like the state attorney general, if they found something to be RICO, that would be different than a county. But I think it's too much power for sure. It's too much power. Yeah, this is another great point, Cuzzo 24/7. It does seem like Georgia's RICO overwhelms federal RICO charges. Allegedly. I like how you did that. To catch love. Well, remember, it's Hilton. Hilton is the one that's allegedly a professor at Emory University. DWC. But yes, I got your point. Yeah, that withholding evidence thing was wild about Harris. That was crazy. All right, let's see. They're jumping back in here. Let's see what they got. Anything good. Let's go. Totally. You're right on the money. Right on the money.
Okay, before we move on to whatever we're going to move on to next, somebody kindly sent me the state 60 WA, I guess, that's already in. And I've only gotten through about half of it, but so far I don't see how the item number 14 from Zachary's folder is cumulative of what is shown in that video, and it may be in the part of the video that I haven't seen yet, but can somebody pinpoint for me? Can we pull it up and maybe y'all can tell me what part of that makes this other potential exhibit cumulative?
Yes, Teresa Stanley, I have a video on that. Actually, 2 videos this weekend on that.
Hey, baby. And I do not want to watch the whole video. I mean,
She said, I don't want to watch this foolishness.
The defense is contending makes Zachary's exhibit, I don't know what the exhibit number is, but the item number 14 cumulative. Yeah.
you asked if there was another video that showed the display of handguns and quote unquote gang associated
Right.
verbiage
Right.
and things of that nature that tended to show associations with whatever we want to call YSL,
Right.
using the word slap and slime and things of that nature and displaying of handguns. And that our point was that the state has admitted, I believe this says 5 minutes long. I remembered it being longer than that, but
Oh, it's longer than that.
Oh.
'Cause I watched it for 5
okay,
minutes.
yeah.
Version, so the what was admitted was shorter than the original
Okay.
version.
Well, that's merciful for the jury.
Right. So, I mean, my point was we've had these types of videos introduced before. My intention was not to suggest that it was identical
No,
or
no, and I know
exactly
that. But I
the
mean,
same.
I wasn't seeing a whole lot of like guns in the front of the camera kind of thing. And they're just standing around in a parking lot saying things and what have you, but
And the only portion that I believe has a gun, one of the co-conspirators, Walter Murphy, I think the line is he just got out last night and he keep the strap on him and he lifted up his shirt, but he didn't point it at the camera. He just lifted up his
well,
shirt.
and maybe I didn't get to that part of it yet, but let me go back and look at the item we're talking about again, but it seemed much more kind of the whole point of
This is
the
embarrassing.
video. So, sure, yeah. I mean,
My whole crew got blunt.
What are y'all doing?
That's why I said little D, bitch. Slide shit. Yeah, ho. Right, motherfucking playing, ho. You don't have a real big bullets, bitch. I don't even play with her. Yeah, ho. That's like the boy.
Okay. Well, I mean,
allow that in.
Yona, did you receive 2 videos or just one?
Just now of the 60 whatever.
Yeah, 60 WA, I think it was,
I
but
think
there was a second one that was sent as well that actually had.
Okay, now I've only looked at one of them.
Yeah,
How about we look at the one that was one of them redacted and one unredacted, or are there 2 different?
No, there are 2 different videos.
So one with 60 WA.
Yes.
What's the other one? Whiskey Alpha. I need to get used to that.
It was a state's exhibit. I don't know offhand
All right, hang on.
the exhibit number.
so apparently they're trying to go through these exhibits. This is so frustrating.
It's on a Google Drive.
I would think they
Oh yeah, no, I'm just now getting that. So if that went to, I mean, I guess I can pull it up, but I don't seem to be able to play the sound. So do y'all want to pull those 2 up? Because I guess they're now contending that.
Yeah, and just to kind of lay the groundwork a little bit,
Sure.
Judge, the second of the 2 videos that was sent show it has Mr. Williams with a handgun. It has someone named Mondo. It has Buck, the person who was referenced previously, who has a handgun displayed in the video, and it also has another person you've heard the name Fatty outside of a house. It's a shorter video, but it has the images that the court.
All right, well, let me take a look at it.
Yes.
Just lifestyle. Oh yeah. Real bleed, aka bleed, nigga. Yeah. Man, what mud? Do this every day. Miss like kitchen. No, that kitchen, man. Yeah. I told him to put on the camera. Go on the test, man. Yeah. You keep it still over, nigga. Please, you fucking good. Oh, you not playing. Step up, you know what I mean? Nigga, real. And we keep fucking there. Not real slack. Keep fucking there.
All right. Okay. All right.
All right. I don't find them to be cumulative, that there's one small part of that where some woman holds a gun. I don't think that that's really the same as what's shown in the item number 14. So I'm gonna stand, my ruling stands on that. I appreciate y'all sending those over there for me to consider. Okay, so are y'all ready to dive into the items that would come in with Mr. Sprinkle?
I don't want to dive into nothing.
Or do you want to move to something else and come back to that? That's
what
y'all were
hubbling
hubbling about, I think.
Speaking for the group, I believe the preference would be to discuss the state has noticed a number of intrinsic acts.
Okay,
I think the group would like to discuss that.
that's
It's all the
fine.
same
I mean,
everywhere
we got to
else.
get through all of it, so I don't really mind if we do it in a different order. Okay, let's do that. Oh, and actually, Miss Hilton, you had said you wanted to put something on the record about, I think, Mr. Huey's motion limine about I assume it was the one about the photo ID from the deceased witness. Okay.
Oh my God.
What's your announcement?
Your Honor, the state does not intend to introduce that photographic lineup
Okay.
or the interview itself. The state would ask if a photographic lineup occurred and would ask if Mr. Howland was interviewed, but not the substance of what happened with either of those items.
Okay. Does that cover it?
So, Judge, good afternoon. It does cover it, Your Honor. I am concerned on asking the question of whether or not one was occurred would make, I don't know that that would be necessarily relevant, or kind of implies that perhaps there was one, but we're not getting into it, so I'm not sure the relevance of asking that question. Maybe the state can shed light on that.
Sure, Your Honor. I believe that we still have to show the credibility of our police officer conducting an investigation. And so I think that it'll be relevant that he conducted an investigation. That was a part of the investigation.
All right. Yeah, there's often an argument that the police didn't do a thorough investigation. They already had people targeted, and that's all this is. So to the extent that it might go to combat that, then I will admit that over the relevance objection. That I will permit that question. And the rest of it, they're conceded.
Call me
should stay.
surprised. Call me surprised.
So they're not going to ask, they'll ask that question, but they're not going to ask about whether or not there was an interview of Mr. Holloman.
Well, I think what she said she intended to ask was, did you interview him?
Yes. Did you interview him?
Interview and whether or not there was a photographic lineup.
Are you going to ask that? I would
say-
think that that's not, we should probably stay away from that.
I didn't hear it because of the mic.
Are you going to ask whether there was a photographic lineup with him, with that witness?
Initially I was, but based on what the court just said, no. Then I'll just ask, was there an interview? And then we.
Okay.
Mm.
That would be the far safer route. Okay. Okay, so y'all want to move on to
Man,
intrinsic.
thank you.
Okay. Which ones? Because there was a set that y'all said there just hadn't been a 403 analysis on yet. And then there was, I guess there were a few that at least somebody, Mr. Ryan was maintaining, were not really intrinsic.
Yes,
Okay.
Your Honor. That's accurate. Back in 2022, the state filed a general notice that they
Who
were
was
going to
that?
produce intrinsic evidence.
I don't know who she is.
We then got a witness list on July 31st, which I think was supposed to be one of the final, we can rely upon this witness list. And within that, there were 4 incidents which happened in 2023. So they
She
wanted to
talking a lot
post-date
today,
that
too.
Notice too, they post-date the indictment. So we've never received any sort of notice from the state saying we are seeking to admit this as intrinsic. However, that is what it is labeled as
Okay.
on the witness.
Little
list. So
sister's
that
back there.
Those
All
4
right.
are what we take issue with.
Okay, got it.
Who's missing today? Who's over there
And
that's
these are
missing?
the incidents. that
Harvey's
occurred in the
missing.
jail, Generally.
One in the jail, 3 in the courtroom.
Okay, thanks.
I'm not sure if Ms. Abbasi realizes that we did notice 2 of the ones that occurred in the earlier part of 2023. The stabbing of the person in the jail by Mr. Ryan, Mr. Blaylock, and others, as well as the violation of the Georgia Controlled Substances Act by Mr. Williams and Mr. Adams. But and those 2 occurred on January 31st, 2023 and January 18th, 2023, respectively. The filing that we noticed the defendants of those on was November 6th, 2023. There were 2 additional acts that occurred in 2023 during the time that this case has been ongoing. And one was the drugs that were found in Mr. Stillwell's cell. And we've noticed some of the pictures of the drugs and the other contraband, and the marijuana that was found in Mr. Ryan's pants when he was searched in the courtroom.
But what's got to do with the RICO from 2015?
So the stabbing, that occurred in the jail, right? Okay, and then the VGCSA violation was in court?
It was.
What's it got to do with?
Obviously, drugs in Mr. Stillwell's cell was in jail, right?
Right.
And then the marijuana in Ryan's pants was in court. Is there another incident that occurred in court?
Not that's on here.
Okay. Ms. Abbasi, you had said 1 in jail, 3 in court.
I'm sorry, Judge, that
2 in jail, 2 in court. Okay. Okay. And the argument as to each is that this is not really intrinsic?
yes, Judge.
Okay.
It doesn't fall into any of the 3 categories which would classify it or qualify it as intrinsic.
Okay.
Okay. Shout out to her.
Pull out my case law on that. Which What's the state's position on why and how that is intrinsic?
The Bussy stabbing, which is going, I'll start with, Your Honor, involved YSL.
I'm sorry, what'd you say? The what?
Oh, I'm so sorry.
I just didn't understand what you said.
Understood. The victim in the January 31st stabbing, his name was
Okay.
Harold
All right.
Bussy. And that's what I
Bussy,
refer to
okay.
it as. So that stabbing involved several YSL gang members stabbing an inmate
Wow.
at Fulton County Jail who was
Mhm.
alleged to have messed with Rodelius Ryan's commissary. It involved, among others, Demise McMullen, Javon Fleetwood, Christian Eppinger, Damone Blaylock, and Rodelius Ryan. They all, in concert, held down this person and stabbed him repeatedly.
But-
all to protect and to vindicate something he had done to one of their fellow YSL gang members. It's the way that I
Okay.
see it. So that it seems just, it's what we've alleged in the indictment that YSL members do. They work to maintain individuals ready and willing to preserve and protect the reputation, power, and even the territory of the enterprise through the use of violence.
Okay.
I think she's reaching.
I
I think
understand.
she's reaching.
With respect to the law, we would cite Johnson versus the state, a Georgia Supreme Court case decided September 21st, 2021, cite 312 Georgia 481. And we cited this last week. The Penn site is 491 to 492. In support of it. Okay. With respect to the January 18th violation of the Georgia Controlled Substances Act, this is 2 YSL members on trial for conspiracy to violate the RICO Act through drug distribution, drug use, drug possessions. And while in court on trial, they are passing Percocets, one to another. And we argue one to the alleged leader of YSL while in open court. One of the assertions that we make regarding the conspiracy. We have contraband in the jail. We have stabbing in the jail of YFN Lucci. We have communications in the jail. These types of actions on the part of the defendants are the type of actions that we have alleged in the indictment, and it shows that the enterprise flows from the streets to the jail to the courtroom, and that the conspiracy is ongoing.
And what exactly is the evidence you would be introducing on this VGCSA?
The video of it.
And what all does, I mean, maybe I need
The
to,
video
what does it show?
shows Mr. Adams going up to Mr. Williams while on a break. He's appearing to dap him up, if you will. Mr. Williams puts his hand up under the table. One of our lieutenants goes over to Mr. Williams and sort of says, give it here. Mr. Williams brings his hand out from under the table, relinquishes the Percocet to him. And later Mr. Adams is searched. And I think more Percocet pills, more drugs are found on Mr. Adams. And the drugs, the photos and
Okay,
tests of those drugs.
all right. And what's next?
The marijuana was also, so in Mr. Stillwell's cell, there was, on March the 29th of 2023, there were drugs found in Mr. Stillwell's cell that consisted of ecstasy, pills, I think contraband, was it cell phone? A contraband cell phone, for him to have gotten those drugs into the jail while he's on trial for.
She does not sound confident. What are you talking about?
Involving narcotics and the enterprise and the sale and distribution of drugs through that enterprise, we believe is evidence of the ongoing conspiracy.
Okay.
Another.
And then the last one, I guess, was the marijuana found on Mr. Ryan. Give me a little bit more background about what your evidence is going to show on that one.
That Mr. Ryan, while sitting in court, I believe deputies may have smelled the marijuana
Okay.
on
What?
Mr.
Smelled
Ryan.
the marijuana?
And when they went back to try and search or to figure out where the smell was coming from, a large commotion was made. And the deputy,
A large commotion by,
Mr. Ryan, and the deputies found the marijuana attached to, I think, his inner garments.
okay.
We have the video.
Okay,
Okay.
we don't know how it got there. I mean, on the Percocet, you got an alleged gang member providing it, right?
Yes.
So how about, we don't have anything like that with regard to the marijuana?
We don't have,
Marijuana.
we provided him with the marijuana, no.
Okay. All right.
This is crazy.
I don't know how pertinent it is that we have one that's not on here that is also involving drugs that are brought into the courtroom and provided to another YSL member, but that particular one has been severed, so we don't have that one
Right.
on here.
Okay.
Right.
I think that the first three that we talked about are, I can see how those would be intrinsic to showing the allegations that, this is a continuing, ongoing RICO enterprise. Mr. Ryan being in possession of marijuana when we don't know where it came from.
Good catch. Thank you, Judge
That
Whitaker.
one, I just don't see that falling within. I mean, it shows, what it shows, that he's in possession of an illegal substance, but it doesn't, I don't think it's intrinsic. So I'm going to rule that one out.
Yes, Your Honor.
The other three,
Your Honor,
yes. Go ahead.
I appreciate the directed verdict that you just gave for one of Mr. Ryan's.
Oh, is that
intrinsics.
one of his, that's not something.
No,
that-
no.
Yeah.
I'm saying you're
That's
keeping
not
it out
anything
without
from-
hearing, but from us. But regarding Mr. Stillwell's,
Mhm.
okay, we have an indictment with 100. I believe it's 191. Could be off 191 over X.
Yep.
Okay, we also now
Here it
have a
comes.
list.
Here it comes.
At first, we thought maybe they had abandoned these 53 and they were narrowing it down to 4, but no. It's 53 plus 4,
Yeah.
57 plus 191. That's 248, I believe. 248 uncharged events or not substantively charged
Right.
offense in that are coming into this trial. Regarding, the state keeps saying, and this shows the enterprise. Okay, there were apparently, I've seen photos, I wasn't there. There were pills that were recovered from Mr. Stillwell's cell, where he has a cellmate.
Okay.
Okay. There is absolutely nothing about those pills that suggest they were provided by anyone associated with YSL. There's absolutely nothing that suggests that those pills were going to anyone associated with YSL. There's absolutely nothing to suggest that any proceeds from those pills were being provided to anyone in YSL. There was a phone. I have not received any information from that phone that suggests any link at all to YSL. I am not saying my client's a drug dealer, but what I am saying is people that are in possession of drugs, whether it be my client or his cellmate or someone else, are able to sell drugs without being part of a huge enterprise and without any evidence that somehow this is linked to YSL. This isn't intrinsic. The test for intrinsic is an uncharged offense arising out of the same transaction as the charged offenses. I don't believe that's the case. Evidence necessary to complete a story of the crime. That is definitely not the case in this scenario, and it's inextricably intertwined with the evidence for the charged offense. I don't believe that's the case either. So I don't know why this is.
I understand. Thank you.
And just so you know, Your Honor, he is charged on a separate indictment. I believe it's indicted. If not, it's in a CP case still, but he is charged separately, and that case is pending in Fulton County Superior Court.
Okay, appreciate it. Thank you for bringing my attention to that.
Your Honor?
Yeah.
If I may, a bit.
Who is
further.
this?
The one case.
On which?
Really regarding all three of them. I'll
Okay.
start specifically with the stabbing as the state did.
Can I rule on this other one first? Give me just a second.
Which other one?
The one that Mr. Sharp
Oh,
was
yes,
just
yes,
talking
Your Honor.
about. Okay. So the Stillwell had a cellmate. Is there any evidence as to where the drugs
guess-
came from, or that it was his, or that the cell phone was his, or connected in any way to YSL?
Well, two things. So yes, we believe that. I think we have do body cam research.
I don't know.
We believe that the testimony from the deputies within the jail would establish his ownership of it. But more importantly, what we have, I briefly touched on it, was the other YSL member whose intrinsic act that we've not put in here. The pills, if we call them purple hearts, blue stars, and yellow diamonds, they were trafficking amounts in Mr. Stillwell's possession, and they were trafficking amounts in the other YSL members' possession.
Aren't those
That
Lucky
is not
Charms?
on here, and that has been severed. They are the same type of pills, and they are a large trafficking amount.
Okay. But
Wait, didn't she just wait? Are those Lucky Charms?
And we know that at least that other one, that other YSL member, smuggled the drugs into the jail, or at least into that area, through the courtroom.
Y'all, this is crazy. Serial is now RICO.
As it was
Ladies and
described,
gentlemen.
it was enough in one, it was a pharmaceutical.
okay, so
Little Johnny, little Sally in
the
trouble,
evidence
y'all.
that what was in Mr. Stillwell's cell came from that?
Other than it was that they were just alike. If you looked at photographs of it's not like you had all white pills. Like you had the same array,
Blue,
variety,
purple, and
to use just some colors. Like there were literally at least three different colors and three different shapes of pills. And they were the same, three different colors and three different shapes.
and you can establish that those were YSL related?
Yes, because, yes,
How?
when you say those, you're talking about the ones
So
that
if
originally came in?
I'm to accept that y'all have enough that you can make the assertion that the pills that came through some court proceeding to this other person who's not a part of this trial,
Right.
are the same that are in Mr. Stillwell's cell, then what's the YSL connection?
Not the
there?
same pills, the same,
Type, the
Yes.
same, shipment or whatever, the same.
that person.
Let her
that
explain.
person was in this trial. That person was in this trial during that time.
Okay, but them being in the trial and co-defendants doesn't establish what the assertions are.
No, it's the not similarities, the exactness of the, like,
No, I'm not asking at this point, like,
This is embarrassing.
assuming for the sake of argument that, yeah, these pills all came from the same place. And he, in fact, then what's the YSL tie-in?
maybe approach with a member of the.
No.
Sure.
What do you need an approach for? I'm sorry. This is embarrassing. This sounds a lot like the argument that they used in the Alec Baldwin case.
I didn't know y'all didn't have them. They're not up here.
What, y'all passing out pills now? What? Lucky Charms?
Yes, you may.
I guess they're
So
unlucky
y'all
charms, like you
satisfied
said.
About, our other bench conference was about the location of that other person. Everybody, I just assumed that y'all.
Who is this young lady, though? I don't know who the other young lady is. She seems pretty smart, too. She's like, she knows what's going on. I love it. Yo, did you say serial killers? Why are you people like this? Those marshmallows, though. They had the marshmallows in them, though. YSL pills. So now they got like a whole distribution. They're like Bayer and Excedrin and stuff. I mean, really, like YSL used pencils at one point. So now all those yellow number 2 pencils that you got your kid for school, all of those are going to be brought up on RICO at this point. Magically delicious RICO. Man, thank you so much. Hey, it's funny. I just dropped the link here. I dropped the link. I did a meme and I put it on Twitter and I shouted out, I tagged Doug to it, and Doug has already liked the video, liked the meme. So we know what Doug is doing over on that phone now. I mean, they might really be real drugs, but I think they're making a great point. Like, how are you blaming YSL for those? All right, so the dangerous crew has now made it home. I hear the garage door opening. I mean, they're blaming them for everything. Right. Did they test them? Like, how do you know they're all the same? How do you know one is not just like an M&M with the M rubbed off? Not trying to be funny, just being real. Wait, that sounds like my wife. Hold on. That might be Lady Dearwood Christian. I might be in trouble because I think I parked in her parking spot. I did, and she's here. Oh man, I'm about to get karate chopped, y'all. I'll be right back.
All right, I am, with regard to the contraband in Mr. Stillwell's cell, I'm going to rule that out as well. And I mean, you may have another indictment against him at some point in time, and it would all be appropriate to come in there, but not for this case. So that, now, Ms. Abbasi, what do you want to say with regard to the other two?
Yes, Your Honor. Your Honor, actually, the state cited when they discussed the stabbing, the same case I cited, Brown, which had, as Mr. Shard said, those three circumstances. Uncharged offense, which arose from the same transaction or series of transactions as the charged offense. That's actually the topic of discussion in Brown. And in Brown, it was a robbery which happened 1 hour before the charged crime. If the state is going with it's part of the same transaction or series of transactions, then we have a very serious problem with proximity, because the case law is not anything a conspiracy does that happens over the lifetime of the conspiracy qualifies as intrinsic. It has to be closely linked with the others, closely linked with the other charged offenses within the indictment. Your Honor can look at Sanchez Villa versus State, just 341 Georgia App 264 from 2017. Within that case, the evidence the state was trying to present, the court found all of the cases the state submitted distinguishable. And the same is true here when Your Honor goes through the cases as far as being part of the same transaction or series of transaction as the charged offenses. This, like those cases, is attenuated in time. For ones which do have more time in between, they discuss how in those cases, the defendants in their other uncharged acts were in the exact same role. So in one, it was trafficking cocaine as the lookout. In the uncharged, trafficking cocaine as the lookout. There were very specifics linking them.
Were any of these in the Sanchez Villa, either those facts or the cases that are distinguished, either a RICO charge that was involved or a gang enterprise?
I will double check because they go through quite a few cases. I'm going to have to look back through all of them. I think the hallmark of it that we get within Sanchez after they discuss all these cases, the evidence in this case, the Sanchez case, is considerably more attenuated in time and space from the events leading up to the charge offense. So it offers little to help the state. They continue on and say that, well, as far as this goes, we're not in a circumstance of completing the story of the crime. This is just expanding it.
Yeah, I mean, right, it's a different crime, but it might have been a different thing if they were charged with a RICO count in Sanchez. So that to me is what, if these were just whatever the other charges in the indictment are, then I would say, no, but it's the kind of enterprise nature and the ongoing nature that.
And I certainly understand that, Your Honor. I think, however, to say, well, it's part of the conspiracy basically opens the door to anything any defendant allegedly who is a member of YSL does, then automatically becomes part of the conspiracy and automatically comes in simply because it is intrinsic. I think with a lot of this, Your Honor, we're getting close to some due process concerns here. The defendants are on trial for the offenses they were indicted on. That's what they're on trial for. They're not in trial for the enterprise continuing in 2023, that it was still ongoing. That's just not relevant. If the day after indictment, every one of the defendants got together and said, whatever our group is over, and it was completely disbanded and no longer continued to exist, that wouldn't be relevant either. What they're indicted for is what they're on trial for. So here we're expanding. That's, I think, a lot of what's happening with our social media and other things that I guess the state has found afterwards. They're now being tried for things the grand jury never heard about. And that specifically is a violation of due process. I can supply to Your Honor the U.S. Supreme Court case law.
No, I'm with you on that one. And I am very skeptical of the state's argument that any uncharged not showing up in the indictment overt act that they offer could in any way support, if found, a RICO count being established. So unless I hear otherwise, which I don't want to hear otherwise right now, we'll take that up another day, but that's not our issue right now. But yeah, I think the state's got some convincing on that count. But with regard to whether, it's intrinsic, I want to get it right. I want to follow what the law says about it. So I think that the key issue here is if we're talking about RICO or we're talking about, a gang enterprise kind of thing. So maybe we could all do a little bit more research on that.
I did look at, in the state's original notice, they cited a proposition, I believe that was cases have been in gang and conspiracy prosecutions, gang and conspiratorial activities have been classified as intrinsic evidence. They then cited a number of other cases. There is not one single case I can find in any case at all where the intrinsic actions come after the indictment, because that's the touchstone of it being intrinsic, that it really is all one thing, that the story doesn't make sense without all of these pieces. And these things hadn't even happened yet. So it's not possible that they could be essential.
Let me ask you this.
Wow,
If,
come on.
for instance, and this is entirely a hypothetical,
Yes.
but if this group got together and stabbed this, whatever his name is, Bussy, not because he messed with Mr. Ryan's commissary account, but because he was going to be a key witness in this case. And I'm sure the state, if in this hypothetical, would argue we're trying to send a message that he better not be a key witness in this case. Would the argument be different then?
Well, yes, it wouldn't be, they wouldn't be trying to admit it as an intrinsic act. It could be
Right.
a crime in and of itself
No,
separately.
no, we're not talking about then they get separately indicted. We're talking
Right.
about they're in the middle of this trial. This happens. It's not obviously set forth in the indictment because
Right.
it just happened.
It would be 404B and probably fall into a category there, which would make it admissible for a basis which was not character. It just wouldn't come in as under intrinsic.
Okay, so you would still make the same argument that it was not, that it couldn't be intrinsic evidence, even for that, because it occurred afterwards.
Based on the definition I've seen of intrinsic, I don't think it's possible for something which comes after to be
Okay.
necessary to complete the story, unless the story wasn't complete at the time of indictment. But that's fundamentally unfair to try them for something which
Wow.
hasn't happened.
Okay, they're not being tried for it. It's,
Correct.
but okay.
Based on your
All right, well, y'all try to find me some more on point law.
Wait,
on
did she
both
not
sides,
find enough?
please, if you could. So maybe that'll be my preliminary ruling, subject to revisiting, okay?
And Judge, there was one other thing. I don't know that it'll have any bearing on the court's ruling, but in that instance where Mr. Stillwell, where the drugs were found in Mr. Stillwell's cell, there were, Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Is the shank inscribed YSL? Then
No,
it doesn't,
no.
I mean, it makes Mr. Stillwell look bad, but it's not intrinsic.
Yes,
Okay.
Your Honor,
Yes.
if I may,
Yes.
before you make a decision on the one alleged intrinsic act that was referenced by the state involving the supposed passing of a Percocet pill from Mr. Khalif Adams to Mr. Williams, I would ask that the court at least go and take a look at the video that was referenced by the state. I think it's instructive. I also think that well, fortunately for us, paints a different picture than was recited by Madam Prosecutor. I think the events did not occur in the manner that she referenced. I was present. I was sitting right next to Mr. Williams. I think the video will show something being passed to Mr. Williams, not him hiding his hand underneath the table or bringing it out and then giving it to the deputy, or the deputy saying, give it here. It didn't happen that way. And I think that goes into the analysis of exactly what happened.
All right, why don't you just tell me what you recall or what you think the video shows?
Sure. What I recall and what
Run the
I
video.
know happened, because I was
Okay.
sitting right next to Mr. Williams in the front of the courtroom, is that there was a break. Mr. Adams, who was sitting in the rear part of the courtroom, came up, and as he was going towards that door, goes as though he's going to give Mr. Williams a high five or a dap or something like that, and put something in his hand. There's a deputy who's standing about 2 feet in front of Mr. Williams. Mr. Williams looks surprised. Mr. Williams has it in his hand and puts it down on the table immediately. There is no putting hand under the table to try and conceal it. The deputy, who I was within earshot of, did not say, give it here. Mr. Williams looks at it and puts it down on the table, and that's it. Okay. And at which point another deputy sees Mr. Adams and either takes him, I don't remember if they took him in the back or brought him back here. Okay. He was searched in the back, as I understand it. I think court recessed after that because of those occurrences, but that's how the incident actually occurred.
Okay. Can y'all send me that video?
Yes, and
Okay.
and the deputy, the lieutenant, would also be a witness.
I just dropped it in the chat. Here it is right here,
Well,
y'all.
I mean,
The version
I would
I'm
imagine the video shows what happened. So.
It does.
It does indeed speak for
All right.
itself.
Well, we'll come back to those two. All right, so that takes care of the allegedly intrinsic, but according to the defense, can't be intrinsic because they happen later in time than the indictment acts. What about the other intrinsic or allegedly intrinsic acts that there has not been a 403 analysis on yet?
Can I just add something to the last? Your Honor, can you ask what the prosecutorial need for this is?
I can, but with
Here it
intrinsic acts,
Here
that's
it
not
comes.
part of the analysis.
Yes, 403 is the
Well,
analysis.
403.
Which
So-
includes the prosecutorial need, waste of time,
Come on.
prejudice, substantial prejudice outweighs any probative value. But to me, this is a big case. It's
It
been going on
is.
a long time, and now intrinsic acts. So yes,
Okay.
I don't know how much the state needs to prove that Mr. Williams was knowingly or unknowingly given an alleged item. I'm not so sure the crime lab came back, but I can't answer for that.
Has the crime lab come back?
That may be true. I don't know. I don't remember.
Okay. All right. So we now have a 403 argument or objection.
So, Your Honor, I think that the court had it right regarding the need to analyze, looking at the prosecutorial need. If it's a 404B act, then that would be a situation where we would be looking at the prosecutorial need, but it's not. We're alleging that it's an intrinsic act. And looking at 403, Your Honor, the analysis is it substantially more prejudicial than probative? And it's simply not, is our position. He's alleged to have, Mr. Williams and the other indictees here are alleged to have conducted drug transactions. One of the acts on the indictment involves
Them having a trafficking amount of drugs, right?
at least one. So we would argue that it in no way can be viewed as substantially more prejudicial than probative, and it's intrinsic. But we're pulling up the video too.
Well, I mean, I guess is it intrinsic is yet to be determined based on the time period, but.
Your Honor, this is
Yes.
not really my argument, but I have got to weigh in here
Oh,
on
please
this
do.
issue. Yeah, thank you. I'll get my 5 minutes in. The 403 analysis is not limited, as you know, to is it more prejudicial than probative. As Mr. Steele said, you also have undue delay and waste of time, and those are factors as well that I'm not surprised that the state ignores, because they seem to have no concern for delay or waste of time. So those are factors that the court should consider as well, Your Honor.
All right. Thank you. Okay, well, I will give y'all a couple of days to, if you can find more on point,
I knew it was
Law.
gonna come. I knew it.
provide that. And if not, I'll just have to go on what we've got and make a decision. I'll take a look at the case that got cited and the cases within that. And then if need be, do the 403 analysis. I may not get to that, but okay. So
She's
that's
wild, man.
those.
She's wild.
What about the other intrinsic acts that 403 hasn't been done on yet? Do y'all just, is there a list? And is it? And I can't, let me see who, I'm not sure quite who filed that one. Or maybe Mr. Sharp just told me there are some that the 403 hasn't been done on yet. From the November 6, 2023 filing, but I don't know which of those.
And some of them have already been, so Judge Granville made an initial ruling
Right.
on one day on 1 through 3. And then throughout the trial, we dealt with and admitted evidence on number 4. Does the court have
Not
the
right in
list?
front of me.
What list you're referring to?
The filing on November the 6th, 2023.
Yeah, I
Of
think
the-
I got that. Give me a second to locate it.
I didn't know what that is, and she just like turns the paper like that. That's a wild. This is a mess.
Okay, yep, I got it.
So, Your Honor, my recollection is that we began discussions on this one day a long time ago.
Okay.
And I agree with the state that they have presented evidence on some of these incidents, some of these acts. Your Honor is saying that we haven't done a 403 analysis. I don't believe
Only
we've done.
because y'all, that's what I thought you had said to me.
Okay, if I said that, I believe I misspoke. I don't believe
Okay.
we've done really any analysis on this list. Meaning,
Okay.
I don't believe, speaking for the people on this side of the room, I don't believe that we are conceding that they're intrinsic.
All
in
right, so
getting
we
into
may
the
need
403.
to, starting with number 5, look at all of them.
Well, Your Honor, I thought we were going by the state's July 31st witness list. So that would not encompass all of these things on here. That witness list went through by what offenses it was set to
Oh,
prove or
this
acts.
one?
Yes. So I was relying on the witness list when filing motions in limine of what they actually intend to prove. I thought that was the whole purpose of.
Well,
Judge, I'm not sure if Ms. Abbas, we filed this November
Yeah.
the 6th of 2023, and I know she wasn't here at that time, but we,
Where'd she come
this
from?
is the argument I think that Mr. Sharp made. This is the one that he sent out with his objections. This is the filing. So this is the one that we're addressing.
okay. Well, I mean, if for instance, you're not gonna, you don't intend to use, 20 through 30 anymore, tell us that. If you still think you intend to use every one of them, tell us that.
A lot of them have already been completed, and there have
Okay.
been testimony, there's already been
All right.
testimony on a lot of them.
Okay, so can you tell me right now?
Yes.
Which that's true for?
Number 4, the 5/12/2013 aggravated assault and home.
Yeah, I mean, I've got it right in front of me, so if you just want to say number 4, that's fine.
Number 4, number 5.
And you said a ruling had already been made on 1, 2, and 3?
Yes,
Okay.
we didn't admit them, but they were. Okay, so we did not admit evidence of 1, 2, and 3. All that we did was address them initially. We didn't admit evidence, and we don't intend to, but those are the only 3 that were addressed initially.
And you don't intend to, so you're not intending to introduce those 3?
Right.
Okay, well then we'll cross 1 through 3 off the list. Okay, 4 has already been admitted, 5 you said has already been admitted.
Right.
Now what?
Also, as it relates to 7 is one of the overt acts listed. The reason that we included it here is that Shannon Stillwell's name was not in the indictment itself
Okay.
on that overt act. The same as to number 8. What? I said the same as to number 8.
Okay, so those are listed, those acts are listed
They're
as
funny.
overt acts, but Mr. Stillwell is not listed in the indictment when
Right.
you're talking about the overt acts. Okay,
Correct.
all right. What about 6?
6, actually, we so 6 is gonna be talked about. It has already been talked about some, and it'll be talked about some more.
Yeah, I thought it had already been talked about some. So I mean, that's in the past, basically. 7 and 8, given that they're overt acts, adding Mr. Stillwell to them, that can still come in as intrinsic. What else?
10 has already
How about
been.
9?
9 has not been talked about.
And do you intend to still present evidence of that? I mean, you do at some point need to streamline your case.
So we can strike off number 9.
All right.
I believe. Ten and 11 have already been alluded to, and in fact, 11 has been discussed by the witness who's currently on
Okay,
the
so
stand.
those are already in.
Yes, and I think that the court at first asked me to tell the court which ones that we had
Well,
already.
you know what? Why don't we just walk through them the way we're doing now? Because you might decide on some other ones that you don't
Oh
need
my
those.
gosh.
All right. So Hill Street there will be testimony given on that through Detective Dennis.
Okay. And his.
Oh, he already
involved in
talked about
that.
it. Ms. Hilton has
Okay.
removed.
Isn't this what they're supposed to have
already
done,
in,
though?
so, Okay.
Number 13, a witness has already talked about.
Okay.
Mr. Copeland on the stand. Number 14 has already been testified about.
Okay.
We've taken off number 15.
Okay.
Number 16 has already been testified about. Number 17 has, we've already presented evidence on.
Okay.
Number 18, we've already presented evidence on. Number 19, we intend to present evidence on.
All right. And tell me, is that like part of the gang rivalry leading up to Mr. Thomas's? I mean, I'm just looking at the date for that, or why is that intrinsic? Why is that a part of the whole story?
Already.
We've talked about it, or y'all have talked about it.
She's right. We did.
I'm not aware. In
The aggravated assault at Trestle Tree on the 8th.
what case is that?
The aggravated assault at Confederate Court,
I'm aware of that, but
through Detective Dennis. I believe that when he gave, I'll have to go back and make sure, looking at our,
In 4K.
at the flip chart that we made while he was on the stand.
Okay. But would this be part of the back and forth that y'all assert led up to?
Y'all.
It was part of the shootings that they went back after the murder of Donovan Thomas and found out about. So that when we say back and forth that led up to it, they
Uh-huh.
started investigating those shootings after the murder of Donovan Thomas.
Okay.
And this was one of the ones that
And this is a shooting of whom by whom?
at Trestle Tree, which would have been if gang territory, we alleged by YSL members. but
Okay,
her-
and what evidence do you have of that?
We did. Okay. So, and just so that Mr. Sharp has that, it's for 150080094. We've already put the CAD report and the 911 call in.
Okay.
Okay, well, that pretty much
Well-
sounds like that's in then.
Well, I don't agree. I mean, what's I think obvious right now is I've been very involved in this case.
Mhm.
I don't know what this January 8th shooting is. I'm asking Miss Love. She doesn't know. So I'm trying to figure out how anyone could argue, if no one even knows what it is, how it's so intrinsic to this case.
Yeah, I don't know if she doesn't know what it is.
Well, I mean,
period,
I keep
or if
asking,
she
I'm
just
giving
doesn't
a-
know right now what it was. So who is alleged to have done this?
So,
Or is this just a general, we, the gang experts, found out about this and we think this was a part of it? It's so, okay. Is there gonna be more besides what's already been
no.
testified to?
No.
Okay, so it's already in. Okay.
Okay.
What number?
20.
20. We have already heard testimony on this one.
And that's all we're gonna hear as to
Yes.
that? Okay.
Yes. And we've already heard testimony on 21
All right.
and 22.
Mhm.
We're not introducing 23.
Okay.
24, we've already heard testimony about, and we will hear more. This is actually where we got that video from that we mentioned. Mr. Sledge, that's in the folder for Mr. Sledge.
Mhm.
Number,
So, hang on. What else is gonna come? I mean, great if the video happened to be from there, but what else is gonna come in about this ag assault criminal damage?
well, Antrevia Smith is one of the witnesses that we've listed,
Mhm.
and her testimony.
That's a victim?
Yes, that's whose
Okay.
house it was.
All right. Okay. Go ahead then. 25.
This is January the 28th.
They just make it up as they go.
I thought we'd already introduced that. Kendrick's position of firearm on January 28th. $15.02.
I don't know. I have no idea at this point. It really looks like they're trying to make this up as they go. So 24 of the 191 indictments involve drugs. I wonder how many involve guns. Interesting. Okay.
Back to 25, 20.
Okay. That's fine.
26, we're not going to introduce evidence of. 27, we've already introduced evidence of. 28, we've already introduced evidence of. With the exception.
Yeah, this would be hard to watch in real time. I'm kind of glad the jury is not here. It'd be painful at this point.
That with the exception of Shannon Stillwell's involvement in the Little Wayne bus shooting, it has come in, but it was added here because Shannon Stillwell's name was not on the overt.
All right, that's fine.
29 is coming up. The shooting at Club Crucial preceded the shooting at Adele Drive and
Club Crucial. Oh my.
So, I'm sorry, 30 through 33. Oh, okay. So they're just listed on here twice, basically. Okay. So I can just cross off 30 through 33, right? Because we've already covered them. Okay.
They got to be on sticky pad. Lord have mercy. Please. Please just quit.
Okay.
36, we don't, well, actually.
Can somebody confirm, is this what they were supposed to have done over the weekend? Am I just assuming that?
I asked the court to allow us to come back to 36. I believe that there are rulings that have been made on that.
Okay.
At first,
Right.
I want to check. 37's already been testified about. 38's already been testified about. 39, we don't intend to introduce evidence of.
Okay.
40, we do intend to introduce evidence of.
Okay. That seems pretty intrinsic.
Just as a word, and then like, it's like an Easter play.
Judge, I
Yeah.
apologize. As far as 39 comes in, I was thinking of another incident. 39 is coming in. That is what led to the arrest by Mr. Kendrick and Mr. Arnold with the firearms that Mr. Kendrick entered a guilty plea to that involved his plea colloquy that we spoke about earlier. But the fact that Mr. Arnold didn't want to identify Mr. Curtis or testify against him at trial is not, we're not putting that part in.
Okay, but that Arnold was assaulted by
Mark.
that you want to have come in. Is that what you're saying?
Yes. That is what led up to the arrest of Mr. Kendrick and Mr. Arnold. They went to retaliate.
That's interesting.
So my apologies. That's 39 and 40 coming in.
Another mistake.
41 being taken out. 42, we don't intend to introduce evidence of 42.
Okay.
43, we do intend. 43 is coming in. Well, we intend to introduce evidence of 43. That's tied to the armed robbery that he's alleged in the indictment to have committed.
Okay.
On October the 11th. 44 comes in because that, we believe, is the motive for the murder. That is the last murder on our indictment.
Mm-hmm.
45 similarly is tied to the Shamel Drinks murder. So we would argue and would ask that that be allowed to come in. 46 as well is tied
painful.
to the murder of Shamel Drinks. As a matter of fact,
47 and 48 and 49 are all tied to that murder. So the ones that we've listed as intrinsic that the court has heard us talk about, for the most part, 90% of them, I think, are part and parcel of acts that have been alleged in the indictment that just didn't include certain aspects
Wow.
that are
Okay,
now
thank you,
listed on
Monica.
the supplement.
All right. Yeah, I mean, there's not a whole lot. Well, what about 50 and 51? Those are the ones that we just talked about. Okay. All right. So other than those two, I mean, honestly, most of it already has come in, or is like, I don't think even arguably not intrinsic to the rest of the crimes and overt acts. So I think the rest of these, not 50 and 51, but the rest of them, unless y'all got some kind of a 403 argument to make, those seem appropriately in. Okay, so sounds like that settles that, other than those two subsequent acts.
What are we doing? What is going on?
All right, with regard to the, I think I already asked y'all to do this, but the Bruton portions of Mr. Kendrick's statement, y'all are gonna try to get together on that, or have y'all already done that?
I thought it was agreed that because I listed out what I believe are redacted portions, and I gave the timestamp on the actual interrogation, then the state can say we disagree or we agree, we could get together.
Okay, but that hadn't been done yet. Y'all still need to do that?
Right.
Okay, well, that's something I think we might get to tomorrow.
As well as we were just served by Mr. Williams a bucket of exhibits. I think he wants to introduce with somebody at some time
Okay.
through a Dropbox link. So we could probably discuss those this week as well.
Okay.
You can, but it'll take about 8 seconds. There's not much to discuss. I added a video, and I specifically wrote what it is, and then I added it to the Dropbox so everybody has the world that Mr. Williams may introduce at trial.
Okay.
Exhibits. So it's just one video.
All right. So do you believe
Thank you, Mo.
the state will be able to examine whatever portions of Mr. Kendrick's statements they think might need to be redacted and let us know?
Yes, I looked at
Okay.
some of the, I don't agree with them, but I can look at them and have some agreements if they're arguing by tomorrow.
Okay, sounds good. So tomorrow we'll still need to do that. We'll need to do the PowerPoint.
We served that one.
Right. So I'd like to maybe take that up tomorrow or sometime this week. I want us to be ready on as much as possible though, so that if we finish one topic, we can move on to the next one. And then we've still got I guess after those two, we just keep moving through the evidence that are in the first 60 witnesses and, figure out any kind of
Let's figure out
rulings that can
things.
be made ahead of time as to those. And that would include Mr. Sprinkles. Okay. And have y'all done the next 30 yet?
They have everything until 60, and we'll work on the 61
Through 90?
through 90.
Okay.
Your Honor, just
Mhm.
calling this to your attention. Ms. Hilton
Nope.
is correct. She identified specific co-conspirator statements or things that they allege are co-conspirator
Right.
statements. In reality, we have a lot of different voices here.
Mhm.
I have reviewed all of the wiretap calls
Yep.
that are relevant, at least.
Okay.
But in my opinion, there's going to be no way to litigate those matters other than just going through them. I hate to say that, but we're not going to agree that any of them are in furtherance of a conspiracy, and we're not going to agree that a number of them, we don't even know who Mr. Garlington is talking to.
Okay.
So that is something that I would humbly suggest should be on the agenda, because we're going to have to work through that.
Okay. I mean, yeah, I agree. This is the wiretap. We got to get through all of it. So what witness is that going to come in through?
Your Honor, that's going to come a little later in the trial, but through Investigator Viverito. So this will be probably towards the end when we're talking about the Chamel Drinks murder.
Viverito?
Yes, Your Honor.
Okay, well, if we get through, I mean, it's a big chunk of stuff we have to do outside of the presence of the jury. So it may not be what is first on tap, but we're going to try to utilize our time. So that's something we need to turn to as well.
And to give just a court of reference, it would be after witness 91. And this is when Investigator Viverito comes up, probably her third or fourth time. So
Have y'all given thought to streamlining your witness list and your evidence?
So Judge, just so that the court is aware, early on, I don't know how familiar the court is with the number of witnesses that we initially started out with, but we started out with over 700.
That's too many to start with, though.
Before, I believe Mr. Weinstein filed his first motion to limit the state's case with the former trial judge, the state announced to defense that not only would we actually be asking for an earlier start time and a later finish time, but we actually told them that we had reduced our list from the over 700 to just over 200. And we've reduced it further. And then after that was when I believe Mr. Kendrick filed a motion to force the state to reduce its list, but we had already said and done that. So now we've reduced it even further. And I believe that we are at that point where we've reduced it.
Insert a
The
shot clock.
delay that Mr. Kendrick referenced in his motion has not been attributable to the state. We have had a number of administrative days. We have had a number of
That's a lie.
delays that were caused for other reasons that had nothing to do with anything that the state's case entailed. So our case and the length of our witnesses is not prolonging this trial at all. And our position is that we have streamlined it considerably. We continue to streamline it even after our first streamlining that we apprised them of.
All right. Well, all I'm saying is, please try to do what you just said you are doing, which is continue to streamline, and I don't have the entirety of who's saying what to what, but you do have the thing that says what counts each witness is going to go to. Just make sure that you're not being cumulative and that the witnesses you're calling are basically worth calling, that they're going to add something material to the jury's ability to decide this case.
And Your Honor, we have in We have
quiet.
indeed been doing that. I think
You've
that the
not.
main cumulative objection has come from, as I remember, they've argued, well, they've called a gang expert, 3 gang experts, and that's cumulative. But each gang expert has talked about a different set of information that they have knowledge of. And they also had factual information that they were both fact witnesses and expert
Okay,
witnesses.
but
So-
you're expecting 2 more gang experts?
You don't need any more, is what she's
in
saying.
terms of new ones, yeah, there were 2 left on the list that we haven't yet gotten to.
Right, so you'd
one
need-
of them we may not call.
Okay, well, you would need to be able to express what it is that that expert or those 2 experts is going to offer that hasn't already been covered by the 3 that have already testified.
We would.
Okay.
And Your Honor, I would like the opportunity at some point this week, I expect the state to answer, to respond to the motion that we filed, but I would like the opportunity to actually argue that in front of you.
Well, I mean, I don't know that I need a response from the state. I also don't need argument from you. I mean, I understand what you're asserting in your motion.
I mean, just today, Your Honor, they say that gang experts, for example, because that is one that we have gone to, that they have not been repetitive. But just today, and I wrote this down because it's just emblematic. Just today, Ms. Love said, quote, our gang experts have testified to B replacing C. So there's a situation there where their gang experts have testified to the same thing multiple times. There's B replacing C. It's constant, Your Honor. And there's absolutely no reason that they should get to run this courtroom. Now, I'm not asking to run it. I'm asking you to run it.
I'm running it.
Okay?
No, you're
And
not.
You have the ability to put a time clock on the state.
Come
We're
on.
way past the time. I'm just going to finish real quick. We're way past the amount of time that we have told the jurors that they will be here. And that is a factor that you can consider. We told the jurors, now I remember 6 months. Other people have said we told the jurors 6 to 9 months. We're going to far exceed that. There's any number of reasons, and they're outlined in the motion. If you don't want me to argue it, I won't argue it, that we can put a limit on the state, or you can put a limit on the state.
Okay, I understand what is set forth in your motion. I understand the law. I understand what my powers are as the judge presiding over this case. I understand that cumulative evidence is unnecessary and maybe undue delay and a waste of time. I also understand that the state has a right to present its case and that they don't have to be limited to just one witness per, count in the indictment. They have rights to. So I appreciate what you put forth there. I agree with it. I mean, it is granted. Okay. I will not permit there to be excessive, repetitive witness after witness saying the same thing, exhibit after exhibit showing the same thing.
Well, the relief I requested was to put a specific time, whether it be days or hours or however you want to do it. So if that's granted, I am thrilled.
Well, I'm not sure that I know at this stage, given that we have only not yet gotten through one
9
incredibly
months.
long and somewhat painful witness testimony, what that time limit might be. I don't anticipate most of the other witnesses to be as long on the stand as this particular witness has been. And maybe I can get, maybe let's just ask the state right now, like time-wise, do y'all expect any of your other witnesses to take as long as
That's a dumb
Mr.
question.
Copeland
That's a
has
stupid
thus
question.
far taken?
No, we didn't expect him to take them.
But Your Honor, this is not the only witness that is
I
taking this
cannot do
long.
anything about what happened before I was the judge.
I appreciate that.
I just can't.
And I'm not asking you to. All I'm saying is
Come on.
that the state's saying that they don't expect other witnesses to take this long. There have been repeated witnesses that have taken weeks.
Okay, well,
And I mean,
let me drill down a little bit more. Okay. So are there any other witnesses that are going to have video interviews that are anywhere as near as this witness?
No, and for any witnesses that have taken more than a few days, there have been breaks, there have been pauses that have caused us to have to take that witness over a period of time longer than we ever anticipated.
And I hope we don't continue to have sound issues, but nobody can do anything about that, although I'm trying to at least get us a reasonable backup, which should have already been in place anyway. But all right, so I'm going to need an answer as to why there needs to be any other gang expert at all in some
Yes, come
amount of
on.
detail.
Yes.
And y'all have the witness list, just like, you have the state's witness list. So if there's somebody else like the two extra gang experts that you all looking at the list and knowing the case backwards and forwards think, the person who's going to say this, somebody else already testified to all of these same things, then y'all bring it to my attention and we can go through and get answers as to whether those people or those witnesses or those exhibits are cumulative. But I can't know at this point in time. I haven't been in this case long enough yet to see what's reasonable for, a witness to take.
Okay. So I'll be back in a few weeks asking again, Your Honor.
Okay.
No, not a few weeks. He's throwing shade.
All right. So I think there aren't any other short things. I'm happy to stay here another hour if y'all'd like to. Nobody else wants to. This wasn't even a full day, y'all.
Can I inquire?
Thank you.
The item that's I think the computer with the headphones on it, is that going to be in front of the jury? So that
No, that's a ridiculous place for it to be right now. If we end up having to use it at all, and I appreciate the state, bringing it as a potential fail-safe. I don't know I think we're going to try while you're doing your oral argument tomorrow morning, somebody is going to come in here and see whether they can even have this be the backup. But it would, as I understand it, we wouldn't be using the video. We would just be using it for its audio output.
So it would
And it would be up against the
up
wall.
against the wall,
Yeah.
right? That's where we had it.
Like we don't
initially.
even need the video part, right?
Not necessarily, but it would be showing the Zoom. It would just all be the same
Right.
thing that's
But
on every
the
other
jury
screen.
doesn't need to watch that screen. They can watch the screen they already have available. So
Right.
we can slide that entirely up against this back wall
That is what we
where it's
had.
out of the way and not, blocking anybody's view.
That's
But-
exactly the way.
But we would potentially use it for sound if our sound system continues to go on the fritz. IT tells me they think they have come up with a solution. I don't know whether they have or not. I also don't know how long it's going to take them to implement said solution. So I have asked them to have something else ready. This may be part of it, but yeah, okay. I'm reading an email that just got sent to me by the head of IT about it. Anyway, we'll try to get all of that addressed. Okay, so we will convene Sergeant Ingram on the scheduling. I had said 12. Is that doable, or is 12:30 just a better? Okay. So let's all plan to convene at 12:30 tomorrow. So when y'all show up at 12:30, it'll actually be the right time. And we'll see you then. Be ready to work on and have objections and responses ready for what we've just talked about. Okay, that's all I wanted to know. All right, so we're adjourned for the day.
Okay, so though they didn't talk about it, I think she alluded. Is it over? It might really be over. It might really be over. Okay. She alluded that the state didn't know, they had the wrong time. That's what she kind of insinuated that. I'm not saying that that's right, but it seemed like everybody else knew it was 12, but the state thought it was 12:30. That's what it sounded like she was saying by saying that she wants to make sure they're the right time tomorrow. And is 12:30 more reasonable? That's what it sounded like. Again, I'm not giving justification for it, but my goodness, in the morning, if I was going to be fair, which, every now and then I try to be fair. Dear Woke Christian tries to be a fair guy. If I was going to be fair, that would probably make sense why all of them weren't there. Like nobody was there at all. That would make sense. However, it still doesn't make excuses. Like, y'all don't have this on your calendar? Like, for real? I guess. Anyway, everybody else knew the right time. All the defense had the right time, and all of y'all had the wrong time. Okay, I guess it just doesn't make sense. And it's if it wasn't like a pattern, if it wasn't an ongoing matter, I'll give my last example. Okay, they really did cut the feed off, so it's done. Last example, not out of here. As a classroom teacher, if you have a student that always does the wrong thing, you are less prone to give him or her grace when being accused of doing the wrong thing, but they're actually right. But if you have a student who's always doing the right thing, you're very gracious with the one when something happens and maybe they did actually sock little Tommy in the nose or run over little Sally on the playground. You're much more, because you're like, this is not what they do as a pattern. But when it is their pattern to misrepresent and misbehave and not follow your directions, you're a lot less prone to give them grace when something goes wrong. And that's what I'm saying here. But there needs to be some consequences, though. Also, if you're not giving any consequences, it's really your fault as a teacher that little Johnny and little Sally are completely running amok. Earlier, I said that the problem with education is the adults. And this time it would be me, the adult, not giving proper consequences for poor behavior in the classroom. And that's Judge Whitaker. Judge Whitaker is not policing this classroom. She's got little cats running all around the place and they're just doing whatever they want to do. And it's crazy, man. It's crazy. But my goodness, in the morning, man. So tomorrow we will start at 12:30. But if there's a motion that gets filed, which I'm saying there's going to probably be a motion or two filed, I will gladly jump in here and I'll jump on and we'll talk about it. So, bro, you're doing it right. You're doing right. They just sent her my text and they say something I won't take that heat. Okay. I feel like I might have jumped in on somebody's conversation. But yeah, man, this is wild. Hopefully, prayerfully, she will consider with a level. I mean, just one time, respect one of those motions. I think if she totally just disregards that motion, that has got to be the worst thing cooking. Because I mean, Judge Doug Weinstein is very clear there, and gives her the latitude though. Like you have the latitude to determine, like, no, y'all got to get this thing going. So hopefully it'll happen. We'll see what happens tomorrow. I thank y'all so much. Tonight is the first night of the DNC. Tomorrow we'll go on live a little early tomorrow and kind of like recap and talk about it. So I'd love to hear what you all think about the Democratic National Convention. I've been looking at Twitter. People have been texting me stuff. There's a lot of craziness going on outside the convention. So I can only imagine what's going to happen tonight. They've already had party crashers. They've got quasi riots and tons of protests. So it's going to be interesting, to say the least. So let's talk about it tomorrow, or, whatever. I got a movie premiere to go to tonight. So we'll see what happens. But everybody, I want to thank you so much for your support. Thank you everybody who was a blessing in the super chats, as well as everybody in the comment section. I really appreciate it. We got 1,000 likes in this video. I've never had that before. I haven't had it. Yeah, I don't think I've had it before, y'all. That was amazing. Thank you so much. And I appreciate every last one of y'all. Feel free. If you do watch the DNC, give me some notes. Send me some notes. What you noticed, or maybe some commentary, breakdowns of some of the speakers. That'd be something fun. I will jump in it if I can tonight, and I'll definitely be ready tomorrow to have a conversation. But I plan to see you all tomorrow, Lord willing, at 11. Since I didn't get my Rule 22, and somebody actually told me they actually would rather me, if I can't live stream and comment, They said they'd rather me stay at the house. So I think that's going to be it. I'll probably just stay here tomorrow and do it. But we will see nonetheless. So y'all, thank you again. I appreciate y'all. God bless you. And I will see you all tomorrow. Grace and peace. Take care.